welcome to another episode of Financial Earning. Today I want to talk to you a little bit about one of Mullen's 8Ks. They filed this one back on December 22nd. I'm bringing it up now because it has some relevance in terms of when this specific 8K would come into effect. So let's get right into it. First, I want to mention on December 18th, 2023, Mullen Automotive agreed to issue a non-convertible secured promissory note that does not include any stock warrants or other securities, and it does not include any conversion rights. Why is that important? That means that this specific promissory note is non-dilutive. It will not impact the market cap. There'll be no type of market cap erosion. There'll be no dilution in terms of increase of outstanding share count based off of this promissory note. So the note itself, it's providing additional capital for the company's manufacturing operations. So that is all we know about it. We don't know why it ends up being such a large amount of money. We just know that it's going to be used in some form or way in the company's manufacturing operations. So the total amount of this promissory note is $50 million, and the total purchase price is $32 million. That means that it's going to cost Mullen $50 million, and they are going to get in return $32 million. There is an original discount of $18 million. This debt agreement will occur on the latter of either January 1st or the first trading day on which the NASDAQ stock market is open for trading. So obviously January 1st we are not open due to the New Year's, but January 2nd would be the effective date, or as we'll find out later on. And also the note will bear an interest rate of 10% per annum, with interest rate increasing to 18% per annum immediately after the occurrence and continuance of an event of default. And it will have a maturity date set as the date that is 3 months from date of issuance. So if January 2nd ends up being the date of issuance, then the thing will be due in 3 months from that date. Also at the very bottom, you'll notice Exhibit 10.1. This is the actual securities purchase agreement, again, as dated on December 18th. So we're going to go ahead and jump right into that. All right, let's get into the actual contract. So I just broke out some of the information from this promissory note. This is the only page we're going to go over, so don't worry about all these red boxes. We'll get through it pretty quickly. So first thing I want to talk about is the name of purchaser, Asusa Holdings LLC. The name of the authorized signatory is Michael Wachs. Subscription amount, Mullen will be receiving $32 million. They will be paying back $50 million. And then the delivery section 2.2. Wanted to point out that on or prior to the closing date, the company shall deliver, and then look at section 4, the security agreement duly executed by the company. So this promissory note contract is stating that Mullen still has to actually agree and execute this. So we don't know if this has actually been, signed off, and if it's going to be effective yet. But we do know that we will find out on this closing date, which should be happening this coming trading week. All right, and then I want to jump over to section 4.4. The purchaser covets that neither it nor any affiliate acting on its behalf will execute any purchases or sales, including short sales, of any of the company's securities during the period commencing with the execution of this agreement. So in my opinion, this is good news for Mullen, which means that this specific company, Asusa, will not be able to perform any transactions that would affect Mullen's market cap at all. So yeah, I think that's really good news. Going to the section 4.5, a lot of people were a little bit concerned about this. The general release statement so says that in consideration for the payments and benefits under this agreement, each party hereby completely, forever, irrevocably, and unconditionally releases and discharges to the maximum extent permitted by law the other party's past, present, and future parent organization, subsidiaries, and so forth. So basically, it's kind of a general release where the companies are going to hold each other harmless for anything past, present, future. The next section talks a little bit about a waiver of jury trial. So this specific agreement, these two companies expressly are waiving forever trial by jury. So this would have to come to some form of arbitration or potentially settlement, but not through jury. And then the last section I did want to talk about a little bit And I think this is really important. A lot of people are concerned about this company's status when it comes to FINRA. It does say in here that if any provision of this note is invalid, illegal, or unenforceable, the balance of this note shall be remain in effect. So if one of Mullen's attorneys or anyone is reviewing this a little bit further and finds that there is some illegal verbiage or any kind of illegal activities, that that portion is going to be kind of taken out of this altogether. All right, and then this last slide, I thought it might pique your interest. It's some of the older agreements between Isusa and Mullen Automotive. First one I want to talk about is the one on the top left. You can see I have highlighted the 8K filing that this thing came out of. And it is originally an agreement between Drawbridge and Mullen, but Isusa Holdings ends up basically absorbing, taking on this older agreement or this older note that Mullen and Drawbridge had, and this note had a value of $23,831,535.98. And the loan had additional accruing but unpaid interest of $5,035,633.12. So looking at that all together, they basically took on this note for a little bit over $28 million, almost $29 million. And look at the interest rate, 28% interest for this agreement. Of course, the maturity date of this loan was a lot further out, but regardless, the interest rate is much higher than a 10% rate. The second one on the bottom right, you'll see another promissory note between Isusa and Mullen for $12,945,914. And again, you look at the bottom section 2, you can see again 28% interest rate. So although some people may say, man, 10% interest rate is pretty high, we're talking about borrowing a significant sum of money. We're talking in the millions here. 32 million to be exact is what Mullen's going to be getting for this. 10% interest rate, in my opinion, doesn't look too bad, but hey, I'm not a fan. I'm not a finance guy, as I've said before. And then some people have said, oh, well, I don't think Mullen could ever get any kind of really good interest rate or anything like that. I did find in their old 10K, and you can see the hyperlink for that 10K, some of their previous matured notes. So they did have a principal balance of over $3 million, and the interest rate was somewhere between 0 and 10%. Another one they had, which is a real estate note, 5.2 million, and it is anywhere from 5 to 8.99%. So Mullen is very capable of getting some of these lower interest rate notes or loans. So I believe that now that they are in the operational phase where they're getting out deliveries of these trucks and vans, as well as, and they're starting to generate revenue. So as a lender, having a company now that has revenue on the books, it should look a lot more advantageous. Only speculation I did want to talk about, and let me disclaim it as speculation, would be in the event that Mullen needed some form of a bridge loan or something of that nature, where they had a very large purchase in mind, or potentially they wanted to set up a contract and they required a specific amount of cash on hand. That could be some of the reasons why they would be taking on a loan of this size with this type of discount. So I guess we'll have to find out. If you guys like this video, if you guys want to see more content like this, please like, subscribe to this channel. Drop some information in the comments on what you did like, what you'd like to see more of moving forward. And with that said, I hope you guys have a great rest of the year. All right, good evening, everybody. Thanks for coming out. I really appreciate Mark taking the time. I know he said, he told me he has about 30 minutes. He's going to be able to kind of come up here, introduce himself, go through some of the previous court cases, some of the more recent court cases, give a little debrief of what he can share of his involvement with Mullen at the time. and then go through some of the comments if there's some time at the end for a little bit of Q&A. Mark, how are you doing tonight? Let me go ahead and make you co-host.
Yeah, can you guys hear me?
Yep, hear you, Mark.
Okay, great. Great to be with you, Ernest.
Thanks for coming out. Really appreciate it. I know a lot of investors are pretty excited. The news dropped, was it now 2 days ago, about you joining the Mullen team and helping represent us in certain endeavors. And then I don't know how excited you are about today's news. If you've heard, I'm sure you have. There's a little extra information, a little news dropped in an 8K filing today with Mullen as well. But I don't want to sidetrack from that. I'd love for you to maybe introduce yourself to any new investors that maybe haven't really done a deep dive into what yourself and your firm do. And then if you can go into any form of detail of your representation with Mullen. I know that it needs to be publicly disclosed information, so I'm totally okay with that. And then, if you want to go over some of those court cases, some things that you think would be applicable to our situation, and then just anything else in general.
Okay, thanks. So I'm a former law professor at a law school in New York. I've been fighting dilution funding for about 14 years. What I do is not as glamorous as, as what Wes and Alan do, and certainly not as high profile what Wes and Alan do, but we kind of do, we kind of have the same kind of mission creep. What my firm does is we do three things, but they all revolve around dilution funding. And if all of you don't know, any company you're invested in who's taken dilution funding, you're actually paying back that funding. The company's not. And dilution funding, from the metrics that we've had and all the cases that we've had, and looking at the markets in general, looking at Wes's cases, going back a couple of decades, I can safely say that dilution funding causes about 80% of all legal and naked shorting. Because the way it works is, and you have a lot of sophisticated retail investors in the Mullen community. And just for those who don't know, when you take dilution funding, the company is committing to issuing shares in exchange for funding. And the way those shares are issued is either through what's called a convertible note, which is a security, a convertible preferred stock purchase that converts into common shares at some sort of discount to market. That's called a security. And usually with one or two or independently associated warrants, which are also securities. And the reason why I want you to understand that a promissory note, which is convertible into stock, is a security, is going to matter as we further go into what dilution funding is and how dilution funding kind of works. So my firm does three things, right? So the first thing we do is when a dilution funder sues one of our clients, we determine which state law applies. And a lot of states have what's called a usury statute. Now, that sounds kind of archaic, and it is, because that comes from the 1700s, from the King's Court of Appeals from London, where the first codified usury laws actually existed. And that basically says, when you have a threshold of a certain percentage that you're allowed to charge on the loan of money. So if you understand a convertible note is also a loan of money besides a security, when that transaction's features violate the usury percentage limit thresholds of certain states like New York, Florida, California, Texas, Massachusetts, and a whole bunch of others, Illinois. In those states, a violation of the criminal usury laws voids the transaction. Now, just to give you some context, and I try to be as transparent with everybody as possible. So, we've represented many OTC companies against these small toxic dilution funders that are out of New York. And anytime they sued our clients in federal court, we would raise the defense of criminal usury. And we've had 11 decisions go against us at the trial court level. So I really got my head bashed in by a couple of these trial courts. And I knew they were wrong. I knew that, these guys really want to, explore immigration laws and sue Trump and whatever. They're not really so sophisticated on finance. So I appealed one of the cases to the Second Circuit Court of Appeals. And the Second Circuit said, hey, wait a second, Mr. Basile, you may be right, but we're not telling our 11 lower court judges they're wrong. We're going to punt this over to New York State's highest court, called the New York State Court of Appeals, and we're going to let them decide what the legislature meant behind codifying the usury laws. So a year of litigation goes on there, and at the end of the day, we win all issues. That decision is handed back down to the Second Circuit, and the Second Circuit started vacating judgments awarded to dilution funders to get stock, to get cash, whatever. Ever since that decision in October of 2021, we have basically put out of business the toxic convertible note lending market in New York, at least on the OTC markets, because they don't want to test whether or not their portfolio of loans are all illegal and void, which means you don't have to pay back the principal. All right. Now, some of you, may be hearing, oh, that's not fair. They took the money. It doesn't matter. They took the money, the issuers. The lenders violated the law, not the issuers. So it doesn't sound like it's equitable, but that's how the law is written, and that's the statute. So that really deals with the situation where these toxic dilution funders sue the issuers. But what about the toxic dilution funders that have already extracted millions and millions of dollars from the issuer based upon a $100,000 note? So the way these notes work is, $50,000 or $100,000 are loaned to the company, and then the lender converts stock at a 30 to 40 to 50% discount to market, and it does it in tranches. Like, so a $50,000 note will get converted $10,000 at a time each week. But as it drives the price of the stock down, the percentage discount still applies to the new lower stock price. So they're just getting more and more and more stock for the same amount of money that they're converting. And that's where dilution funding cripples public companies, not just the OTC companies. So we came up with a way to use the usury laws offensively through the federal RICO statute, the civil RICO statute. The civil RICO statute says, if you engage in the collection of an unlawful debt defined as violates a state's usury laws, then not only do you have to give back the difference between what you lent them and what you collected, but you have to give back 3 times that amount. Oh, and by the way, you have to pay their legal fees as well. So we've commenced several RICO actions under that statute. And every time we beat a dilution funder on a motion to dismiss, they run to the table, they want to settle. Because if we prove that that transaction violates state law, then every transaction that they've ever done violates state law, then the state attorney generals go after them. So that's the second thing we do. The third thing we do is, believe it or not, exactly what the SEC has been doing to a lot of these dilution funders. There's a statute under the Securities Act called 15A. 15A says, if you are engaged in buying and selling securities as a business for your own account through a broker or otherwise, you have to be registered as a dealer. And Section 15CC of the Securities Act says, any violation of this act voids the transaction. So that's kind of been interpreted a couple of ways. First, it's been interpreted, first of all, it's a hard and fast rule. If you buy and sell convertible notes, so if you buy a convertible note, convert it to stock, and then sell the stock in the public market, and you're doing it as a business, which means more than a few times a year, you have to register. If not, that transaction's void, but you have to go to a court and have it declared void. The difference is that in a case where it's a new transaction in the last 3 months and they haven't converted or exercised warrants, the idea is we cancel that transaction. You just have to pay them back what they funded the company. But think about all the potential dilution that has just saved the entire retail shareholder base, right? That's critical. Now, in situations where the funder has extracted, so say it's a $10 million funding, and the funder extracted $100 million from an issuer. If you win that dealer registration argument, they owe the company $90 million and our legal fees. So the way that I usually work with companies, I'm not going to speak about any specific company on this part, but I usually make a handshake deal with the CEO that if you get back money from these unlawful fundings, you need to at least express to me that you are going to provide a dividend to your retail shareholder base, a cash dividend based upon whatever you collect. Because it's only right to return to the people who paid for it, which is the retail base. So anyone who has bought into a stock for a short play has to kind of love what we do, because we're going to knock out that overhang. We're going to knock out that future dilution. That future dilution will never hit the market. And chances are the market's already been plagued by short selling and naked short selling. You know, they're rubbing their hands thinking, okay, you know, a shit ton of stock is going to hit the market in a couple of weeks or a couple of months. Let's start shorting it down now. And now we know there's going to be a lot of stock hitting the market that we can cover our positions on. And that's why I believe about 80% of all legal short selling and naked short selling is all born out of dilution funding. So if you look at an issuer, say, take a look at GNS, which may not be the best example now, but GNS, used Wesson Allen and filed a lawsuit. And actually the lawsuit, was kind of recognizable to us because they kind of used some of our prior lawsuits as a guide for them, right? And they were entering into a big battle with a couple of these big dilution funders, right? And Roger Hamilton called me up and said, look, this is your expertise. We need to bring you in on the team. We need you to kind of look at this, and we want you to help us file an amended complaint and go after them. I said, great. I can't wait. This is, I live for this kind of shit. So he puts out a press release. The stock goes up 25% that day, and every one of those dilution funders ran to the table and settled with him before I even had a chance to start. I'm not saying that that's going to happen in all cases, but the dilution funders know the statutes that we use against dilution funders are the same exact statutes that the SEC is bringing civil enforcement actions against these clowns for unregistered dealer activity. And guess what? In every single civil case against a dilution funder that the SEC has brought under 15A and 15CC, they have won summary judgment. They've also won final judgments, disgorging all profits for any funding that they've ever done, millions of dollars of fines, sanctions, penny stock bars, you name it. So the only difference on a dealer registration issue between what the SEC and what we do is the damages. They get disgorgement, right? They get fines, they get penalties. We get what's called rescissionary damages. So between us and that dilution funder, you get all the money back under rescissionary damages, less what they originally funded the company for. And that takes an analysis, and you have to work the numbers and stuff. So if you take a 20,000 foot view and you look at what West Christian does, and is fairly successful at what he does. He sues the brokers, right, for manipulation under 10b-5, consisting of stock spoofing and naked short selling. Okay. He starts his, if he wins a motion to dismiss, he starts his discovery and starts drilling down into the brokers to see if there's any other accomplices or any other brokers working in concert with them or whatever. I sue the funder. And when I sue the funder, all my discovery is with their broker and where did the stock go, what other brokerage firms and other brokerage accounts. And we get all the trading records, we get everything that they've made on the transaction, because that goes to our damages. And somewhere in between that discovery, Wes and I will meet, because we will start crossing over when we get to that point in our litigations on discovery. Now, what he has when he gets out of discovery really can't help what we do. But what we get out of discovery certainly can help what he does. So that's the 20,000-foot view. And we've already had successful civil cases. We're the only firm in the country that has successfully prosecuted 15A defenses and 15A claims. And one of our clients, I see Raul here, he's a big shareholder in one of our clients called Dark Pulse. We just got 2 state court judgments against the dilution funder that not only canceled all the transactions, but awarded our client monetary damages and all their legal fees. And this is a pattern that's now developing because the issuers are waking up. Some of the issuers are waking up and saying, we didn't know these things were illegal. So I don't see how they did anything wrong. Maybe retail communities don't like the idea of dilution funding, but unless Goldman Sachs is coming with a 10% discount, we're just going to buy straight common stock and we're going to be a long-time holder for 3 to 5 years. What are your options as a startup company, especially such a cash-intensive company for capital like Mullen and like a lot of other companies? So what we do, if anybody's in it for a short squeeze, they should love us, because the whole idea is we're going to take that stock away. That we're going to take that ability to get that stock through a warrant, through a conversion, and we're going to try to cancel it out and void it out. And then the company really, under the Securities Act, will only have to pay back what it was funded, right? That's how the law is. That's what the law states. I'm not making up something. And the hedge fund guys and some shills will show up in spaces and say, oh, poor funders, why, they made a deal and they, your client took the money. You can't see this. I'm Italian. I'm putting my hand under my chin and I'm pushing it forward. That's what I think of these people, because they have no problem diluting the crap out of these companies on your backs, on your investments, on your public market investments. They have no problem doing it, driving the freaking price of the stock down, where you guys are, you're struggling to build the wall and struggling to keep it from falling even further. They played you, not the company. The dilution funders played you. So, I kind of take this a little personally for communities I get invested in. And that's what my law firm does. We're basically the only firm that's doing this. So
now, Mark, let me ask a quick question. These lenders that become beneficial owners of a portion of the company and have these excessive amounts of warrants, is it legal for them to place puts on the company or place a short position on the company knowingly that they're going to exercise the warrants and drive down the stock price?
Well, I don't want to comment anything on any specific company, but you can't short on a warrant. It has to be an actual stock that you own, not a contract to acquire stock. You can't do it. There's a federal court case in Georgia. I think it's called, I want to say Mr. Krabs, but I'm thinking of stupid thing. I think it's Krabs something. I'll send it to you, Ernest, and you can post it. Federal court said you can't legally short against warrants. But I think that's what, either they're shorting against the warrants or they're shorting with the expectation that the warrant's going to be exercised and a shit ton of stock's going to hit the market and allow them to cover. So I don't know if it's the funders that are shorting although Savvy Management was just pinched by the SEC in a civil action for naked short selling. How about that? Didn't the SEC and FINRA said there's no such thing as naked short selling? And didn't Forbes and a whole bunch of other magazines and Bloomberg say there's no such thing as naked short selling? And why did the SEC commence an action against Savvy Management for naked short selling? So these are all things that the better educated you are on the law and the mechanics on how the market works, you guys are going to make way better investment decisions going forward. So,
Mark, one more follow-up question, then we can maybe move on to some of the other topics. So recently, Rule 13F2 was adopted by the SEC, and it's a form, I'm sure you know about it, for institutions. Institutional managers have to now report their short sale information to the SEC. Do you see that benefiting some of the smaller cap companies and some of the OTC companies?
if they comply with it, a little,
Yeah.
a little bit if they comply with it. You know, the problem is we don't have market transparency. Whether it's an issuer you can't get any answers from, whether it's FINRA because they're tight, whether it's the SEC, whether it's the brokers. You know, there are a couple of recidivists online that talk about the back end, talk about how they short and why they short and point to charts. You know, shorting to me is a very important issue. But remember, Ernest, what I do is cut off the shorting, but I really don't engage into prove shorting or naked shorting. I leave that to Wes and Al. You know, that's what they've been doing for decades, and they're pretty good at putting those pieces together. But yes, you know, I believe anything that provides more market transparency for the retail investor, not to protect the institutional investors, I think is a great thing. I think they should publish it every day before the open of market, you know, from the day before. I think you should know who took what short positions in your stock that you're trading in, because that will definitely have an impact on your trading decisions. Absolutely.
Okay. And another thing, just to kind of clarify another definition, if an investor is reading a filing and they see that their company is getting a contract with a lender for an equity line of credit, is that another form or another definition for dilutive funding or dilution funding?
All right. So you know what I think of equity line of credit? Bullshit. It's just another way of dilution funding. It's just the mechanics are a little different. The lender or the funder is still getting stock directly from the company and then selling it in the open market. That's the definition of a dealer. And that's just another bullshit dilution funding tool. So.
And Mark, a lot of times when companies, I'm trying to keep this very general, a lot of times when companies sign up for some of that dilutive funding, they also have to have anti-dilution clauses in place. That way the lenders are protected from any type of negative price action on those warrants that they're being granted to exercise at a later date. So when you're going after these companies and you're able to prove that there's illegal activities going on, if the company that is being held or at the mercy of these lenders, if they've had to exercise additional supplemental prospectus filings with additional warrants just to try to make up some of that anti-dilution clause or that verbiage in terms of I guess keeping that same equitable pricing for that initial contract, all of that is also all that would play into factoring exactly what the final settlement amount would be. Is that accurate, or am I off topic here?
Well, I mean, look, anti-dilution clauses really mean dilution on top of dilution.
Right.
So let's not beat around the bush. These anti-dilution provisions are solely to protect the funder. Why? Because the funder wants a risk-free funding. He wants a risk-free funding. The funder takes no risk. If you look at the SEC decisions and the SEC enforcement cases on dealers in Fife and Almagarby and Keener and Octus and LG and Crownbridge and Fiero and Irongate, whether it's an administrative enforcement proceeding or a federal judicial federal lawsuit enforcement proceeding, It's the same thing. There's no risk to them, right? Because all they keep doing is getting more and more stock to cover.
Right.
Then they have these penalty provisions, which in my cases, we've already determined that those penalty provisions are void as a matter of state law. They want these make whole provisions, which is just another way of saying we're gonna dilute on top of dilute and then dilute you some more. So these documents are constructed solely for their benefit to reduce almost to zero their risk on investing in these companies. That's why when they invest in these companies, you think they're doing massive due diligence? Look, a real investment from a legitimate brokerage firm, legitimate registered brokerage firm, takes months to put together because of the due diligence. You know how fast these transactions are? 2 weeks, 3 weeks. They want to look at your trading volume. They want to know if they can sneak in there when it comes time to convert or dilute, if they can kind of bury themselves in the volume and not be seen. That's exactly what they do. And then after talking about Wes's case a little earlier today in another site, another space call, you guys better break out the puke buckets, because if you read the new Mullen complaint, that made me sick. Forget about you guys, and I understand the law behind it. I mean, it's disgusting. You guys are fighting a retail battle with one arm tied behind your back, and you have no legs, right? You have your mouths and one hand is flailing around. That's what it's like. You're subject to thousands of trade orders done in a millisecond. So you can't even react fast enough. So, that's another reason why I want to kill the dilution funding. Look, if it's legitimate and legal dilution funding, that's fine. But if it's unlawful and illegal, why should you guys suffer? And that's how I look at it.
Absolutely. And Mark, we're coming close up to that 10 o'clock period. I did want to ask you, maybe you give a couple of court examples of some of the cases that you've won recently. I can start kind of skimming through the comments for any questions that you may be able to answer.
Well, there's a couple of cases. Dark Pulse versus EMA in the Southern District of New York. We brought a RICO action against the dilution funder. They made a motion to dismiss the case. Judge Schofield, who wrote the same opinion in the Harrington case for Wes, was also our judge in that case. And they said, no, you guys, looks like you guys violated the criminal usury statute. These loans are usurious. So we got a great decision on that. We just beat one of the biggest law firms in the country, Gibson Dunn, in the Ninth Circuit Court of Appeals against another dilution funder called LGH Investments. The Ninth Circuit Court of Appeals reversed the lower court dismissing our case, saying, wait a second, no, these guys have a California usury claim, which, by the way, mimics the RICO claim. And in that case, they took $12 million in warrants. So that's a big case. That's $35–40 million right there. We won a first in nation decision on the if a conversion discount to market is interest in New York State, which put out all the in 8R Bays versus Genesis ID, which basically put all the toxic lenders in the OTC market out of business. And we just won 2 judgments in the Careborn Capital versus Dark Pulse case in Minnesota, where the court granted us summary judgment and awarded us a final judgment on dealer registration violations for a dilution funder that did about 25 transactions in the last 2 years, got over 1 billion shares of stock, and the court ordered those the balance of the contracts canceled all the securities, and awarded our client monetary damages. And we have a huge oral argument coming up next the 13th. I'm not sure if that's Tuesday or Wednesday, in front of the Second Circuit Court of Appeals, which is the only Circuit Court of Appeals that has not addressed the dealer registration issue. That starts at 10 o'clock. You can listen to the oral argument at the Second Circuit Court of Appeals website starting at 10 a.m. on the 13th. We're number 4 on the calendar, so we're later in the morning. If you want to, hear how the judges, asking our firm questions, asking our adversary questions, which is from another big firm, Kirkland and Ellis, and you'll get to see my firm in action, at least on that issue. So if you guys have any other questions, I can stay like another 5 or 10 minutes. So.
Yeah, Mark, let me just do rapid fire. And of course, any of these, feel free just to pass on some of these. First question, I put them up in the nest as well, so kind of can read through it. Someone asked if a company is at risk of being delisted, has NASDAQ ever granted extensions if the company can prove manipulation in court? So I think this one definitely plays a key role in our specific company, Mullen Automotive.
I'm not sure if that's been tried, but it would sound like if you have proof, like a court decision, or some other hard proof, which you would think that the NASDAQ or the New York Stock Exchange would be able to look at their trading records on an issue and kind of see the anomalies. It could give you more time. I don't know if it will. That's up to the discretion of the committee.
Okay. And some of these, I think they'll be pretty quick. Another one said, I think they're talking about the dividends that you mentioned earlier. They asked if they're paid to retailers who were holding during that time, or is it paid to all retailers, even the new ones who just got in?
Can you say that again? You were breaking up.
So for the dividends, because you had talked about that a little bit earlier on, this person's asking if the dividend would be paid to retailers who were holding during that specific time of the infraction, or would the dividend be paid to all retailers, even new ones who just got in?
Well, I think in order to make it fair, the company's going to have to assess and have maybe different categories regarding issuing dividends. I mean, there are people who held and lost value. There are people who sold and lost value. And then there are people who bought and lost value, right? So, it's up to the company on how they want to structure that. But I would like them to be fair.
Right.
Because, right?
Yeah, that makes a lot of sense. A lot of investors have been through 2 reverse splits with this specific stock, so they've got all their QSIP numbers, and I'm sure they're able to get all that documentation together. So I could see how it wouldn't necessarily be a standardized kind of payout for investors if that's the route that's taken. But just want to get your take on that. Another person asked, how can we investors have bought shares in Mullen? How can we be part of the case if and be benefited by the result? So right now you're representing Mullen, the company. Is there any way for the investors themselves to be part of a class action lawsuit against these same type of lenders?
There are rules that will allow a class action by shareholders against the lenders, and sometimes you need to get the board of directors' permission, because what you're doing may be counterproductive to what they're doing regarding any lawsuits they commence. I don't do class action work. I don't recommend class action work because the class action attorneys are the ones that make the most money. It sounds counterintuitive since I'm an attorney, but since I don't do that kind of work, depending on the case, you've heard of stories, $1 billion fraud or whatever, and then you get a check for $2.90. Yeah. So that's not cool. But you'd have to really ask like a class action attorney, and then it depends on the state rules of incorporation, on if you have to get permission from the board first or whatever the case may be. Sometimes you have to let the board know, and the board under certain state laws has 30 days, 60 days, or a reasonable time to respond. Yeah, we're going to do it, or no, and these are the reasons why we don't want you to do it. And then maybe they make some sense, maybe they don't. I don't know. I can't really speak to that.
Okay. Only 2 more up here. Another one, and this may not necessarily have any relevance for your specific part in all this, but someone want to know if the dark pool volume has any kind of factoring in maybe what your firm would be going after in terms of the I guess the proving some of the dilutive trading. Are you able to have a look into the dark pool section, and track any types of trades in that manner?
That may only come into play on the damages aspect after we win the subject matter law on the case. So that may or may not come in. You know, usually it's the trading is usually back and forth, whatever. You know, we can't get loss of market cap in what we do. We could just go back to the dilution funder or funders and claw back whatever they took out of the market, less what they funded the company. And then, you know, that's why what I do is not glamorous. You know, it's effective. I have a lot of court decisions on that, and it's very effective, but it's not glamorous. It's like really pit bull kind of, you know, dog eat dog. It's a dog fight with these guys, and it's going to be a dog fight. Whatever Mullen decides to do, in any of its cases, it's going to be a dog fight, because when it comes to money, people don't want to give it up. So,
Yeah, absolutely. And just my own personal opinion, I definitely see how Mullen's taken a stance in many different facets of the market right now for the investors. So I see that as a very positive thing. But the last question, someone had asked, why does the SEC not enforce companies to go through only registered brokers to get loans? Are there any types of legislation, any bills that are currently out floating around now that potentially would help kind of solve some of these issues? Or do you think this is just something that, you know, investors are going to have to continue to deal with?
there is a proposed rule floating around right now where a lot of high-powered law firms that represent these dilution fundings are meeting with the SEC and fighting against. But there are rules to expand dealer registration. Right now, you know, it's really simple. You know, it's read the statute, stupid. Right? That's what we call it to other attorneys. Just read the freaking statute, stupid. It says, you know, if you're buying and selling securities, which is defined what a security is, as a business, the 11th Circuit Court of Appeals defined what as a business is, through a broker or otherwise. So whether you're part of a group that invested or individually, you have to be registered as a dealer. And if you can't affect a transaction, meaning you can't even enter into a securities transaction, and you can't perform that securities transaction. It's either or, right? So a contract could be legal on its face. So picture this, Ernest. A 13-year-old contracts with you, right? You didn't know he was 13 years old. He was 6'3", he's like Barron Trump, whatever the case may be, right? And you contract with him. You later find out he's 13 years old. He did not have the legal capacity to enter into that contract with you. You can seek to have that voided. It's the same concept. This is not rocket science. You know, these dilution funders are going to throw in all different things. Oh, they're investment advisors. Oh, you know, they were registered at one point, but not anymore, and blah, 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 blah. We saw it all already. It doesn't matter. Just read the statute, stupid. You know, I may post it up tomorrow or Friday for everybody to read, and I'll tag Mullen so you can see this. It's the statute. It's not judicially made up law, where sometimes we have to fight, where the courts get it wrong and the people think that's precedent, and then they're wrong, and then we have to appeal. And you know, we're 100%. Our appellate record is 100% so far, and we've won like 11 appeals. So whether we're right or wrong at the state, you know, at the trial court level, we've won every appeal that we brought. So that says something. That doesn't mean we're always going to be right. It doesn't mean we're going to, you know, continue that batting average, but it's indication that the stuff that we do is embedded in the statute. So you can't reword the statute if you're a judge. You have to follow what the statute says. So, you know, look, I'm as transparent as can be. I talked to David. I said, I'm coming on this space. I'm going to talk in generalizations. He goes, go at it. You know, I want my shareholder base to know who you are and what you stand for. And we're glad we're working with you and, you know, what have you. So, you know, I try to be as transparent. I don't like death threats against me, which some of your community members already did. And I was sent some bogus cease and desist that was so factually incorrect. I had to choke back my coffee. I was laughing so hard. And quite frankly, I don't put up with bullshit. So if somebody's going to call me out, expect me to come after you. Expect me to talk to you online because I want to clear the air. I don't want FUD circulating. I don't want people to get the wrong impression. I'm against dilution funding. I'm against, I'm against naked short selling. I'm against anything illegal that you guys are the victims vis-a-vis the issuers. And, sometimes I deal with, I won't take a case if I think a CEO is a bad guy, but I have to learn everything that he's done and what he's done and why he's done it. So I'm comfortable with David. I've been involved, and Ernest, you and I have gone back and forth a little bit. I've been involved in a prior EV company that was private. It's very hard to raise money. And they had the first EV truck called Zero Truck that was out and sold a couple of hundred units. So I understand this market. And I think that's why he brought me in to kind of do a 20,000-foot view on all their fundings and, make different recommendations to the board and how we can improve things going forward and what we can do about the past and stuff like that. That's as detailed I'm going to get with you at this point. So.
Well, I really appreciate it, Mark, and I'll speak on behalf of retail. I'm sure you see a lot of the comments and responses, but appreciate you taking the time with this investor base just to be transparent. I feel very good. I feel reassured on what your company's doing, what you're doing, and I'm excited for the future and the filings and all the information that we have coming down the pipeline. I'm very optimistic for what's to come. And in terms of dilution funding and everything like that, another aspect that I think is rather interesting is whenever you have a reverse merger, and not only are you getting the company's assets and this and that, you also get stuck with some of the dilution contracts that are already in place. So some of these companies, when these reverse merge, or some of these lenders, when these reverse mergers happen, they end up kind of getting rolled into it all, and you kind of get pregnant with some of these lenders and entities like that. So it's just it's been a quite a ride, I would say, as a Mullen investor over the last 2 years or so, and I'm excited to see all of the legal actions that are now getting put in place. I see a lot of great things operationally, and now I'm seeing some really good signs from the company in terms of getting legal to kind of go out and fight to kind of protect that share price and to protect those investors. So I appreciate your time, Mark. Appreciate you staying over a little bit. Hopefully I can have you on another space call. Maybe after you have some public filing or anything out there, and they have a great opportunity to kind of maybe break some of that down, or just have you in for another chat.
Yeah, well, if you guys don't hear from me, for a little while, don't worry. I'm working behind the scenes, and I'm working with the company. And I'm kind of glad to be working counter on the other side from Wes and Alan, because I think their Harrington decision basically opened up the lawsuit that was filed today by holding the brokers responsible for what their clients' orders are. You can't just have blinders on and say, oh, the client's doing, I'm just placing an order. No, you've got a responsibility. You're a registered broker. You've got to report. So, I think that, that's what happens in law. Nothing is ever really set in stone, and it takes sometimes weeks, months, and years to chip away at certain things to finally get to the point where now you're changing dynamics. In this case, you're changing market dynamics. And the more cases that are brought for spoofing, and the more that the issuers stand up for the retail base and go after the dilution funders, if they have grounds to, then I'm cheering you guys on. You hear me. This is the way I am in court. So you may not like how I say certain things, or I do curse, and that's just coming from New York and growing up the way I did. But I use that as an expression for content. So it's not like I'm trying to be vulgar. I just want you guys to understand.
Yeah, I appreciate that, Mark. Absolutely. one final note. As you said, it could be a little bit before we kind of hear from you. I just wanted to know. It sounds like your firm and yourself, you're definitely going after the dilution, the potential dilutive funding agreements and stuff that's happened in the past. Do you ever work with companies to help them broker new funding that basically your team's able to kind of skim over just to verify that it's ironclad and that to help to kind of protect the company moving forward?
Well, my firm not only goes after dilution funding, we've also did private restructurings and workouts for many OTC issuers. So, in my prior life, long time ago, I was a Chapter 11 attorney when I was with a big firm in Manhattan, and I learned a lot of tricks on how to resolve debt, how to restructure debt, how to restructure basically organizational functions and administration, how to make it operate leaner and smoother and more effective. And I bring all that to the table, So, there's, I have much more business experience than I do legal experience, and I have 35 years of legal experience. So, I look at everything with from a business perspective on making recommendations, and I'm very fiscally conservative. So if that translates into some of the things that I recommend to the company, then so be it. That's just me, and that's why I'm running for George Santos's seat in New York.
All right, Mark. Well, again, I really appreciate it. I'm excited. I really hope you stay part of this Mullen community, and long term, it sounds like not only can you help us with some of the history that we have, but it sounds like you're a great person to have on our side in terms of future dealings and things like that. So, again, appreciate the time. Thanks for staying over. If you want to hop down, I'll start bringing up some of the Mullen retail to kind of just have a kind of a spin-off chat. So.
All right, guys, have a great night, and hopefully we'll get together soon.
All right. Thanks, Mark.
Thanks.
Bye.
For Mark when he comes up is like, what can we propose to our congressman
Mark
to
is here.
change the retail situation that we're in? I mean, all these stocks that are messed up, not just Mullen, but all the retail stocks are just all this manipulation in the stock market. What can we propose to our congressman to change this? I mean, what can we email them about and everything?
Well, there's probably two answers to that, right? Have them enforce the laws that are on the books already. And the second is to instruct FINRA to fine violations of their brokers at 150% rather than at 1%, because there's no disincentive for them to not engage in these type of market manipulated activities in any issuer. And until the SEC starts becoming more aggressive, as well as FINRA, FINRA can only be aggressive with their registered brokers. The SEC has to get more aggressive against the unregistered brokers that aren't under FINRA's purview. But the fines are ridiculous. It doesn't disincentivize anybody from continuing to engage in securities violations. And the only people that get hurt is the retail investors, no matter what issue you guys are invested in. That's my 2 cents on that.
Right. That's why, like I think Citadel just got fined for just $7 million for wrongly listing stock that was being shorted. Just I think they were saying it was being shorted a certain way and it wasn't, or something like that, and they just got fined $7 million for that. Is that like the 1% you're talking about?
Well, I don't know the specific underlying value of the damage or the harm, or whether economic or finance, that the underlying violation caused. But that's, I think, the first thing that FINRA or the SEC has to look at is what's the nature and extent of the violation. Because you can't have, like, for instance, a Goldman Sachs did a $300 million violation, but only get, fined $3 million. I mean, that's coffee money for the entire Goldman Sachs family farm in New York City for a week. So it's it's very disjointed, and you think that these government agencies or these quasi agencies are there to protect you. But if the board of governors that make up FINRA, half of them have direct financial or employment ties to the hedge funds that they're supposed to be monitoring and supervising and then fining, well, then you have the team owns the umpire, and then the umpire is going to call balls all day long for the hedge funds. So it's really an upside down situation.
Yeah, Mark, do you have a timeline history of this? I've been in the stock market, from the 1990s, and it just seems like there wasn't all this spoofing going on back then. Of course, I had to pay for like $38 a trade. Maybe a lot of that money was going to the regulatory agency instead of the hedge funds doing their own regulating.
Well,
could you comment on
yeah,
that?
I think up to about 15 years ago, you didn't have as much instant information from all different sources as you do today, right? So there are a lot of paper decisions, there are a lot of published decisions that just didn't make it onto social media and retail is unaware of. But this has been happening for 20, 25 years, ever since they became high frequency trading on the broker's end. I mean, this stuff is happening all the time. Take a look at Wes's spoofing complaint, right? I read one of the paragraphs that they've put in fake asks and bids, like 3,000 of them within seconds. Now think about that. How the hell can you guys as retail traders react fast enough if the high frequency trading used by these brokers are just, they're all algorithmic trading. There's no, I mean, once in a while you'll have a broker hit a key on a keyboard to effectuate a trade, but this is all done by algorithms. I mean, you guys are really at such a tremendous disadvantage. So.
Hey, Mark, I have a question. Have you been able to look at the agreement for the loan recently done by Mullen with the SUSA?
Yeah, and I rather not comment on anything that I'm directly involved in regarding Mullen at this point, but you may see something come out about that in the near future. That's all I could say about it.
All right, thank you.
Yeah, we noticed up in the nest where the lawsuit has just been filed today against the toxic lender. I think, was it down there in the Bahamas?
Well, you guys should get a copy of the complaint and read it. I'm sure somebody will hold a space in the next 24 hours or so to go over it. It's a pretty simple lawsuit that tracks exactly what the SEC lawsuits have been doing with regard to unregistered dealers. And I really can't comment, but Mullen has many other transactions similar to this, and that's all I can say at this point about it. We'll put it this way, I'm only getting started. So, you take it for what it's worth.
Are you in active consultation with Mullen as far as like going ahead with loans? Like
to an extent, yes.
Yeah, like in the future, future borrowing. Are you a consultant with Mullen on that?
Well, it really depends what they share with me. I was hired to kind of help them with all of their fundings, past, present, and in the future. But it really depends on what the board decides to share with me, and that's all I could really talk about.
Right, and I think you had commented on the space in the past is they don't really share everything with you, right?
Yeah, I mean, no board of directors will share everything unless you're directly hired, to actually take proactive measures and do something about it. But we'll put it this way, almost everybody here, with the except of 2 or 3 buffoons I could see that are listening, know my position on corporate finance and dilution funding. And, at the end of the day, I try to look at things as an advocate for retail, because retail is the engine that sort of drives the company's performance in the marketplace. I mean, yeah, you have the fundamentals, and those are coming along, I think, very nicely for several of my clients. And I've kind of been brought in to kind of undo as much as I can legally to try to kind of rearrange everything. But at the end of the day, dilution funding litigation is all about taking out the future dilution that a company is facing. So through cancellations of agreements or cancellations of warrants or anything, and that sends a pretty strong signal to the short sellers who are.
Right. Does this have a lot to do with the New York courts of the 25% usury law?
No, and that's that's the it's kind of funny. A little information is dangerous, especially from this guy Kendall, right? He doesn't realize, and I did respond to one of his posts that the New York usury laws aren't applicable, and I said, yeah, they're not, because the fundings are over $2.5 million. But he said, well, what about loans that are underneath that? And you can't use it affirmatively. And I said, yeah, that's true. In New York, you can't use it affirmatively. You can't sue somebody to cancel a usurious contract, but you can use the federal RICO statutes for loans under $2.5 million that have already collected in excess, which includes in excess of 25% interest. Those are subject to the federal RICO claims, and federal RICO is, you get the money back and you get 3 times the damages plus your attorney's fees. So when somebody gives you information, be very, very careful, because they're likely not giving you the full picture. So, for companies that are going to get sued for loans less than 2.5 million, you can raise the criminal usury defense in New York as long as New York law governs it. If they've already extracted money from you and it's within 4 years of doing so, you could sue them under the federal RICO laws, which entitles you to get all that money back plus 3 times plus your attorney's fees. So there are ways to go back. If any of the issues that you're in have loans less than 2.5 million, and some of these big funders do have loans of less than 2.5 million with other clients of mine, and you'll see a couple of new lawsuits in the next couple of weeks going after them under the RICO statute. So just be careful where you get your information from. There are a lot of people that provide really good due diligence in every community, but you have to kind of look at what the due diligence they want you to lead to believe is the end result. So the due diligence could be really good, could be spot on, but the way they're using it is to kind of drive you to form a certain conclusion, right? Sometimes it's accurate, and sometimes it's missing elements purposely to drive you to a certain conclusion. And that's very important, for the retail investment community to understand. That's why, first of all, I don't believe anything that I see on Twitter, because just as much as there are pumpers, and there's also bashers, and they have different programs. And our back end AI is very kind of clear, putting these groups together and seeing how their posts affect market performance of certain issuers within certain parameters. So, I mean, I see a much bigger picture. But at the end of the day, I rather get my facts from depositions and subpoenas when I could talk to the people directly involved or get documents that they've relied on directly in a transaction, rather than people pontificating on Twitter and on space calls with half information and half baked speculation. So just keep all your minds open and get as many facts as you can. And if you're relying on certain bashers for your information, put that in perspective. You're relying on certain pumpers for information, put that in perspective. And the more information you have, the better investment decisions you're going to make. And a true
Yeah, but how long ago did these RICO laws change? Was it just in the last year that the federal RICO laws changed and that New York usury law?
No, what happened is that, the New York usury law has been in place for 150 years. It's just that some of the courts in the Southern District of New York didn't apply it properly. And frankly, I had to go through 11 cases And I had my head bashed in by some of these lower court trial judges that just didn't understand how to read a statute and didn't understand how to read case law from New York state courts. So I had to appeal the decision to the Second Circuit.
Right. That's just in this last couple of years.
Yeah, that's
right?
since 2020. But I'll tell you what happened though.
Yeah.
What happened was the Second Circuit said, you may be right, Professor Basile, you may be absolutely right, but we're going to kick this to the New York's highest court because we want them to tell us what the New York legislature meant when it put these laws in place. And of course, after going through all that, the New York legislature came back and said, guess what, Professor, you're right. That was sent back to the Second Circuit, and Second Circuit we've been using that Second Circuit to vacate judgments as old as 4 or 5 years that relied on the misinterpretation of law for public companies, saving these public companies 10 million, 20 million, and hundreds of millions of dollars in dilution that they were going to suffer under those judgments, right? So what happened was once New York set the law, that invoked the federal RICO statute. The federal RICO statute's been around for a long time, a couple of decades, and they've always had a provision for the collection of an unlawful debt, and that's defined as violating the state usury laws. So all of these convertible note lenders felt they were getting away with murder because they thought from their attorneys and everything that this was a legitimate business practice, and it didn't matter what the conversion discount was, it wasn't interest. But at the end of the day, New York Court of Appeals said, nope, you're right, it's definitely interest, and it has to be calculated when looking at the 25%. Now, that's good when you defend a lawsuit using the criminal usury statute as an affirmative defense. But now you can use the RICO statute to go back and get back the money that was taken from the issuers by these funders over the last 4 years since the date of the last transaction, and you get 3 times that money. So on a $2 million note, they made $20 million. Well, they owe you $18 million times 3, plus attorney's fees. And people don't like it. People will say, well, you made the deal and you took the money, but it's not the issuers who are breaking the law, not that law anyway. It's the funders who are breaking the law, whether it's dealer registration or RICO laws. So when you hear a fudster claiming that the funders are victims, you could throw that out. That's not the law. And you see people blaming the company, throw that out. That's not the law. Now, there may be other problems with companies, doing different things with fiduciary duties. But when it comes down to these funding agreements, it's not the issuers. The focus is not at all on the issuers, and the laws aren't designed to look at the issuers. The law is designed to focus on the lenders or the funders. So once everybody understands the basis for the law and who the law is supposed to apply to, then you're going to get a much better understanding that probably 80% of all fundings for all of your public companies are probably unregistered dealers. And then going back to what Atru said regarding this dilution funding website, there's another way to really focus in on dilution funding, right? Or the short position is that, once you find out the name of the funder who's in your issuer, go to Edgar, do a name search. You'll see how many transactions they've done. You'll see how many shares of stock that they took in those transactions, whether it's through warrants, convertible notes, bullshit equity lines of credit, or whatever the transitional documents and the mechanics are. It doesn't matter, right? And you can tell by looking at your issuer and the people who are in your issuer, the funders who are in your issuer, do an Edgar search, and you can almost pull out. And you can almost track yourself how much dilution they already suffered because of this. And you could also track how much dilution they're going to end up suffering in the future if this continues. So these are all stuff that are going to make you guys much better retail traders. And, I suck at trading. I tell people all the time, I kid around, I should adopt the George Costanza method of trading. Whatever my gut feeling is, I should just do the exact opposite and I'll probably do well. But I don't trade for a lot of reasons because I don't want fingers pointing at me saying, oh, you own the stock and you're manipulating it by filing lawsuits. No. So I don't own any shares. I don't have any family members or trusts or anything. We don't get involved. I don't invest in the market until they straighten that shit out, until they start enforcing their laws, and still they start finding what they should. And maybe when Congress starts looking at some of these ridiculous loopholes that allow these hedge funds and everything to get away with murder on your backs, which would be my back too if I traded, I'm not going to trade until that shit gets straightened out, you know? So, I mean, that's just my 20,000 foot view. That's really all I can share with you. Don't ask me any specific questions about Mullen or shot or finger motion or kappa, you know, any of that stuff. I can't talk specifically. I could just talk in generals on kind of like what I do, how I see this in general to the market, and how it impacts all of you.
And,
Hey,
Mark,
Mark, were you advised by someone to block certain people by any chance?
No. My firm has a strict policy on what elements are needed in order to block somebody. Now, if somebody, and I have a staff of probably 30 people that are always monitoring my social media accounts, and they're the ones who report certain things, and they have certain criteria. So if somebody feels that they were blocked wrongly or unintentionally, they can, you know, feel free to email my firm or DM me, and we'll take another look at it, whether or not they triggered it. Especially the clown who's laughing right now. He'll never be unblocked.
And Mark, we've spoken before about etiquette in these spaces, and you had mentioned you want to be co-host. I had stepped away doing some family things, so I had Dan up here co-hosting to help bring some people up. If you want to co-host, just let me know. I'll throw you an invite.
Well, this may be one of the.
Did you just invite the guy who admitted to blocking half the community to co-host a space?
Yeah, what's wrong with that?
We don't want to open up the space call for clowns.
He said if you've got any issues, email him at his company if you feel he's made the criteria that was met to block such people.
This dude ain't got
was a mistake.
Well, wait.
No, look, hold on.
Come on.
No,
Don't let these guys up here disrespecting our lawyers now. You need to drop those guys down.
Yes.
Yeah, well, look.
Fat Daddy.
Like, I'm a securities litigator. I have a pretty tough skin, but I'm not going to put up. I'm not going to put up. Let me just finish. I'm not going to put up with bullshit. I'm not going to put up with people who are asking questions to drive a narrative which I know is false. And guess what? If I block you or if my staff blocks you, you have no right to listen to what I have to say about things. You want to be unblocked, you can send me a direct message. You can send my staff a direct message and explain why you think you should be unblocked. But if you're gonna challenge me, call me names, and use FUD as a way to get your narrative across, count on it. You're gonna get blocked. And this is one of the few spaces that I'm doing that I'm not co-hosting, because whenever I speak in spaces, it's required that the host make me a co-host. So these people or these bots don't hear what I say because they're not entitled to. If they're going to be obstinate and not have an open mind, I'm a really fair person. I will engage in actual discourse, but not when I know it's trying to lead a whole bunch of people, including my 20,000 followers between my account and my firm's account, to try to mislead people with half facts and half truths without looking at the whole picture. So that's not going to happen. So keep laughing, do what you want. Trust me, my AI is turned on, and you're going to be surprised someday when you find out what you've been doing, how it helps to manipulate the market. Just warning you.
Mark, to move this along, because I had a question when you said that you don't trade because you don't want that conflict of interest. So I had a question on that. Do you advise your company employees to do the same? Try not to trade because we're in the market.
We have a strict policy here. Yeah, they're not allowed to.
That's great.
Yeah, they're not allowed to invest in any company. First of all, I can't stop them from investing in general, but they can't invest in any company we have any sort of relationship with. It's just
Brilliant. That's what I wanted to hear.
Yeah.
Thank you.
Yeah, the only
Also,
reason why I asked that question it was because after you were in a Christina space, and I know how she talks to people outside of spaces, myself and many others were magically blocked. That's why I asked that question.
well, there are a lot of things that if my staff sees a post that is completely false that if people are liking, then that's part of the problem too, because you're perpetuating false narratives. And you know, I only speak to what I know, and I'm not saying you could take it to the bank that if I'm blocking people that they're bad actors. I'm not saying that at all, but we have a very strict criteria. And trust me, when you block bad actors or people that get under your skin, your social media life becomes much better and much clearer, and everything comes into more focus. If you let the noise get to you, if you let people who don't know all the facts, who don't know the law, who are pontificating and always seem to be up your ass to try to persuade you into a certain direction, well, that's you know, that there's a point where freedom of speech crosses to market manipulation. So we just want to avoid all that. That's all.
Negativity breeds negativity. So, can you just clear this up for me? Because this person had a question. Number one, I'll never be an educator for yourself, and I will never work for Mark Brazil Law Firm. Can you just clear that up for this person? Because I just know you. I know you from a ticker I was in that you won a couple of cases for. That's how I was made aware of you.
Well, first of all,
just if you could clear that up for me.
You know, I wouldn't hire you if that was your attitude to begin with, right? The attorneys I have, and some of them were actually my law students years ago, that I've handpicked out of my classes, who are the brightest in their classes to come work for my firm. And I have a lot of other lawyers who came from big securities law firms are now working for us. Also, former department, attorney generals, SEC attorneys, you name it. You know, a lot of people are now working for me. So, you know, as far as they wouldn't work, you know, why? You have to ask yourself why. Because
no, this person believes that I would come to work for you in some capacity. No, I don't want that.
Well, let me tell you something. I'll tell you right now that there are certain community members in different various retail communities that have really sparked our interest with regard to the deep due diligence that they've been able to do. You know, rivaling some of my law students that intern for me, which is pretty good because my interns are trained in what to look for. And I've had discussions with a couple of them. A couple of them were popular, and a couple of them are not popular. But I don't think I would ever hire them to do any of the due diligence, for us directly. I think some of the issuers can possibly benefit from some of the due diligence. Even Ernest, some of the people in Mullen who do great due diligence. I think David and his board of directors would benefit from, some consulting gigs. Because what's going to happen in the next year or two, the SEC is probably going to promulgate a new rule that every public company has to have a social media impact area in their financial disclosures. And they're going to have to talk about the impact of social media on their stock price. And that's where some of the AI comes in, because AI can track and monitor that even anonymously if we program it to do that, and be able to, because you as retail traders don't necessarily know everything that's going on social media. And you're wondering why good news comes out and the stock price tanks. Well, a lot of it is social media. A lot of it is people preying on people's emotions and knee-jerk reactions to press releases. And as some of these people, down below in the space can tell you, you can twist any fact either direction. It depends on, whether or not you can point to a half-truth to make people question in their minds, well, is this really happening? So, I mean, a lot of you guys have done great due diligence. And I have to tell you, the MMTLP community's due diligence, even though they have different factions and competing due diligence, groups is beyond anything that I've seen, beyond what Wes and Alan can pay for through their experts. It's just amazing. And your retail community is getting up there as well, because it's just that you look at everything, and a lot of people are able to piece things together correctly, which leads you to, sort of putting together the pathway of the company going forward. So, you guys are really good at what you do, but I think, and the reason why I come on these spaces is to not tell anybody they're wrong or they're right. It's really just to help educate you guys. Because before you got onto Mullen, I'm sure only 3% of you knew what dilution funding was and how it affects the market. And now, I mean, we've got hundreds of thousands of retail traders among AMC, GameStop, MMTLP, Finger Motion, GTII, Mullen. They're all learning about this, and they're all learning where to look for this, and what are the red flags, and how maybe that will impact your good investment decisions going forward. And it's all about education. That's all I care about. So when somebody tries to shut me up or call me names because they don't like what I'm saying, I'm not saying anything against them. I'm just trying to educate them. And if they don't like it, well, that's what happens. The ones who don't want to get educated, believe me, are the fudsters. That's all I can tell you.
Yeah, Mark, I appreciate you, coming in here as speaker and just giving everyone here an opportunity to hear you out. Some people could just be misguided from the information they have, and this could be a great opportunity for them to kind of hear this side of the story from a professional, someone who's been in the game for a long time and can kind of provide a narrative that is more neutral, in fact, and you're giving us a lot of generalizations on how we can be better traders and how we can just open our minds to kind of see what's going on, behind the scenes. So I 100% agree when it comes to dilutive funding. That's nothing that I personally had ever looked at before Mullen, and just looking at even some of the market cap charts, just to kind of see how the market cap itself got pulled down. You can definitely see, you can definitely correlate some of the dilution with that. Just looking at what the company gets for financing for that funding versus what happens in the market cap. If it's a very large drop past just the financing amount, I mean, that kind of is a little bit of a red flag to me personally. But again, I'm just speculating and trying my best as a retailer to look into that kind of stuff.
Well, I will be able to talk about the recent funding in the near future, but not right now. And I could just I could dispel a lot of notions going on regarding that, but I don't want to talk about it specifically right now. But I do want to say that the Mullen community, I could see is it's very energetic, and it's mostly disciplined, right? And that there is a not-for-profit organization that's being right now developed and geared specifically to the retail community that I think a lot of you will get a lot of benefit from with regard to learning more about the markets and how it works, and learning about all these these terms that you hear about, options trading and dilution funding and everything else. and it's going to have a whole educational section with about 40 or 50 10-minute videos done by law professors, college professors, successful day traders, SEC counsel, just a lot of different things. And they're done for 10 minutes for a reason, because you don't have an hour a day to sit and listen to this stuff. But topically, there's going to be about 40 or 50 different topics. And these are 10-minute classes. They're free. They're free. It's not like you have to pay anything to listen to this. And hopefully that not-for-profit is going to be relaunched in the next couple of weeks. I know that the videos have already started by the instructors, and I think it's going to be a really a really good educational tool for retail going forward. And look, it's just part of my whole platform is just trying to educate retail. And there's going to be stuff that I say or try to educate on people aren't going to want to hear or listen to, and that's human nature. That's fine. You don't have to tune in when when I'm speaking. But I'm going to be conducting probably about 7 or 8 of those courses myself, as well as some other high-profile attorneys that you've seen that are involved with the retail community. And you'll see a lot of people who maybe some of these community leaders who host spaces also involved in instructing some classes. So, I'm just trying to do the right thing for everybody. And, it's always been kind of like my underlying theme, whether you're an attorney at this firm or a client of mine, try to get everything straightened out and create a level playing field for everybody. So everybody's operating under the same set of facts, the same information, and the same group of expectations, good or bad. So that's all I can contribute today. I got to get going. My office is now closed for New Year's weekend, and I want to get home.
Thanks so much, Mark, for coming up and speaking. I really appreciate it, man. I know it's holiday season and you're a busy man. I think these words that you've given us has been great. I know Sam's got his hand up. Sam, if you have a question for Mark before he goes, go ahead, man. If not, we can let him go about his holiday week.
Yeah, if he could, I'm not going to keep him long. I know he said he can't comment on this recent agreement, but almost alluded or made it sound like he will be talking about it soon. Now, everybody in the retail community knows about Isusa. We all thought that, hey, they're toxic lenders, and because you were hired to go after toxic lenders, I think that it would be a big disappointment if when you finally do get to talk about the agreement that you're not going after them, because I think everybody was pretty happy that you're coming on board to go after toxic lenders.
All right. So, Sam, first of all, I just unblocked you. So I think that's kind of like a fair question. And the only thing I can tell you is I hope I don't disappoint you.
Thank you. Thank you.
Yeah, I had a question, Mark. What prompted the SEC to make these companies start to closing their social media presence, like give an account of it?
Well, I think once they proposed the rule, and that's because they've had a lot of issuers, and I'm sure the SEC has had a lot of complaints. You go on SEC and you could file a complaint online. Oh, posters X, Y, and Z are manipulating the stock, blah, blah, blah. So on the SEC side, they're probably getting a lot of everyday complaints from retail traders, but they're also probably getting complaints from the issuers saying, there's a lot of market manipulation going on in social media, and there's no controls in place for this. So I think a disclosure on the potential of social media posting on the effects of their trading over the prior quarter, I think that's probably a very good topic for issuers to discuss.
So you're saying the company would just have to disclose that they've been getting a lot of complaints to the SEC about their on social media?
No, I think the SEC is going to eventually require the company to include like a social media impact statement, and we'll probably come up with a guideline on what information, just like the environmental stuff that companies now have nothing to do with environment, that are strictly online, but they're forced to disclose stuff. I think that's the way it's going to go, because it's important for everybody, whether you're social media day trader or just somebody who gets a prospectus. I think it's important for every retail investor to understand what the effects of social media could be on the stock. And I think that the SEC is going to create a lot of parameters in which there are certain discussion points that have to be addressed, just like any other rule they have.
Shouldn't they also look into
Yeah,
the
what
media
do you
side
think
of
the
it, of the
catalyst is?
manipulation also, not just the retailers and social media?
If I could just chime in and kind of button that up for David, what Mark is saying, that just like in campaign where finance and social media can have an impact on a campaign, there's a dollar value that can be placed on it, whether it be negative or positive. The same too for company and issuers. if you have a campaign that's running in social media that's affecting the stock price, that too should be a part of, I guess, filings and whatever, if people kind of get it.
Yeah, sort of. It's not just campaigns, awareness campaigns run or funded by the company. It could be any campaign that that's picked up on social media that can have a direct impact on the stock. I think at first you're going to see a lot of generalization disclosures and nothing really specific. I mean, there are going to be companies that use, different groups' AI and different groups' research to kind of chart and map out potential effects and look, our stock dipped over these 5 days, and this is what the social media posting activity was. It could be this. You're going to get a lot of unspecified indicators. And then as time progresses, the SEC will probably, move to improve the rule by requiring additional, more in-depth disclosures. And look, all this is designed to help you guys, right? It's not designed to hurt the companies or anybody else. It's designed to help you guys. So.
Yeah, they'll just disclose where the sentiment was, like negative or positive, as far as social media goes.
I really have no idea. I'm not involved in the constructions of the regulations or the proposed rules, so I couldn't tell you.
Do you think overall the SEC is looking into getting more strict on this illegal spoofing and shorting and stuff like that in the markets?
I think yes. And I think a lot has to do with the efforts of the MMTLP community. They've just overwhelmed Congress, the agencies, and then when you have a senator holding a hearing asking Gary Gensler for specific data on their brokers trading, and Gary doing a Ralph Cramden, chef of the future, humada without an answer. That doesn't bode well, and I think that there's going to be pressure on the agencies to tighten their own ships up and enforce the laws that they have on their books. I mean, look, the SEC has already brought actions against social media posters and groups. If you don't believe me, just do a simple Google search. I believe there's a whole group out of Texas that was sued a couple of months ago by the SEC for market manipulation through social media. So it's there and it's real. I just don't know, the parameters of what they're going to require to be disclosed, if they even get that far. So we'll see what happens when it comes to.
Mark, I have a question. Such as saying that they may go after the social media as influencers for the price movement. Would they also go after like legacy media for doing the same?
That's a good question. I haven't talked to my friends over in the enforcement division on this, but a lot of the things that we do as a law firm in lawsuits, they kind of pick up. And as you probably know, we have 3 lawsuits right now for 3 NASDAQ companies against Capybara, as well as Benzinga for reposting reports from short sellers. So, eventually, I'm sure the SEC has copies of those complaints, and whether they open up internal investigations, they don't share that with us. But I'm sure they're looking at it. They got to clean up the market. That's part of it. And if they ignore it, then they become part of the problem. So.
Thank you.
All right, guys, I got to head out. Just keep an eye on news and everything else over the next couple of days on all your tickers. Sometimes this is a very active time of the year when you think it wouldn't be. It actually is. There's probably a lot of tidbits that you can pick up from that. And I gotta run. So, and happy New Year, everybody. Hope everybody has a safe and healthy New Year. And I guess I'll be back next year.
Happy New Year to you too, man.
Yeah, thanks, Mark, for coming on the space.
Thanks, Mark. I
All
appreciate
right.
it, man.
Take care, everybody.
Bye.
Hello and welcome to another episode of Financial Earning. On today's video, I want to talk to you a little bit about the outstanding share count for Mullen Automotive. As you can see, I broke down some of the DEF 14As as well as the 10K and new 8K that Mullen just dropped on Friday afternoon. So let's go ahead and get into it. First thing I want to talk about is going back to the November 8th filing. So this was the proxy material that was filed. It had a record date of November 6th. I have it highlighted there. You can see that. And what I wanted to box in talk about is the common stock. So you can see 413,097,639 shares of common stock as of that record date of November 6th. And then in terms of beneficial ownership, Equitas Capital LLC had a total share count, including exercisable warrants, of 106,236,735. Isusa had 69,571,736. However, what I did want to point out was the two different superscripts there. First, starting with Equitas, if you go to the section number 3, you can see that Equitas had, as of record date November 6, 40 million shares of common stock and 66,236,735 shares of common stock issuable upon exercise of warrants. So if they exercise all the warrants, that as of that date, that's the amount of shares that they could acquire. All right, and then looking at section 4, talking about Isusa Holdings, they had, as of record date November 6, 36 million shares of common stock and 7,949,973 common stock issuable upon exercise of warrants, calculated again as of November 6th, and these would have been shares owned by Isusa Holdings. But then looking at section B of there, you'll see 25,621,760 shares of common stock, again issuable upon exercise of warrants. Those are held by Michael Wachs, who is the managing member of Isusa Holdings. So take out the already exercised shares. So take out the 40 million out of Equitas Capital, take out the 36 million from Isusa Holdings, and then add up those, and you're going to see that as of November 6th, Isusa, at a minimum, could have exercised, and this is post-split adjusted, this is the 1-for-100 split adjustment already, they could have exercised all their warrants that day and gotten 335,717 shares that would have increased the common share count. However, if they would have held until December 20th, looking at the price action difference. So if you see on November 6th, the price was $31 a share. Again, this is post 1-for-100 split. And then look at where we were at on December 20th, it was $8.50 a share. So that's a 72.6% decline. Just using that ratio there, one could speculate that if Isusa was to have held all of the warrants until December 20th, they could have then issued a total of 1,225,244 common shares. And again, that's post-split adjustment. Equitas, if you add up the segment 4 there on the beneficial ownership and then do your post-split adjustment, they could have exercised a total of 662,367 common shares. Again, same thing with the same percent. If they would have held all of those shares and exercised on 12/20, they could have acquired up to 2,417,399 common shares. So it's a big difference between when exactly they exercise that, and then looking at the common stock or the common share amount on January 17th filing, and this was effective as of January 12th, you'll see that it grew to 5,884,693. So looking at that delta, the share count, the common stock share count increased by 1,753,715 shares. Again, looking at that same filing, so this is the 10K I'm talking about, Equitas Group Holdings, only beneficial owner left as of that record date of January 12th had the equivalent of 870,743 shares. And if you look at section 3 or subscript 3 there, you'll see that these were issuable upon exercise of warrants calculated as of January 12th. So this also tells us that as of that date, Aquitas Holdings had no common stock ownership. So between Isusa's holding company and then also Aquitas, they sold out all of their common shares. Isusa turned around and exercised all the warrants and then sold all of those common shares as well. That had a very large impact on the share price. So if you look at that 72.6% decline, that was definitely a good portion of that, in my opinion. Again, this is not financial advice, but I did want to just share my sentiment. This is for entertainment purposes only. So again, Friday afternoon, we get this last filing from David Michery, and this is an 8K. This 8K has a couple of really good pieces of information in there. First thing it mentioned is that the company hasn't issued any new warrants. So there's been no new dilutive warrants being added to the common share price in terms of any type of share price offerings or anything like that. Also, it says that no existing warrants have been exercised since the reverse stock split of its common stock, which has an effective date of December 21st, 2023. So that's why I went ahead and used that December 20th date to kind of calculate that percent drop and to see that ratio of potentially what it means in terms of share count. So again, last little bit of information there was that currently there are 69,977 warrants outstanding. So just to be clear, that doesn't convert over to just 69,977 common shares being added. That's the amount of warrants. So you have to understand that that does have a exercise price difference, and we actually know as of January 12th, what does that 69,977 warrants account for? As of that date, it would have been 870,743. So again, just wanted to keep you all updated. Wanted to show you how this common stock count actually increased, and in my opinion, had a lot to do with the Isusa Holdings company and the Aquitas Holding Company, how they exercised their warrants, as well as how the price declined based off of their sell-off. And the one thing that this 8K did not tell us is that did Aquitas sell off any of their common shares, or did Isusa Holdings sell off any of their common shares after the reverse split? We don't know. All we know is that there was no additional warrants being exercised. So that's it for this video. I'm trying to keep it a little bit shorter than my others. If you like what you heard, please go ahead and put it in the comments. Let me know your thoughts. If you want to hear anything else about this situation, or if you want to hear any other types of coverage on Mullen, please let me know. And with that said, I hope you have a great rest of the weekend. Well, hello and welcome to another episode by Financial Ernie. On today's episode, we're going to talk about Mullen Automotive and a lawsuit they have going on right now. It's a spoofing case, and there are some latest filings provided to the public on March 19th. So we're going to go ahead and break those down. Just to let you know, this will be a little bit of a lengthy video. Got about 17 slides worth of content. The whole lawsuit, or the new filing, was over 70 pages long. There's also multiple exhibits that were provided as well. So let's go ahead and get right into it. So before we jump into the actual lawsuit, let's go ahead and break down who's actually involved. There were some new developments, some new people added to this case. Let's go ahead and take a look. So this plaintiff is Mullen Automotive Inc., as well now added Hyan Cha and Cheyenne Korami. And if I'm mispronouncing those, sorry about that, folks. And defendants, we still have IMC Financial Markets, Clear Street Markets LLC, Clear Street LLC, UBS Securities LLC, and John Doe's 1 through 10. All right, so the filing starts out with an intro. So those of you who are not familiar with what spoofing actually is, let's go ahead and read along together a little bit. So this case involves spoofing, a form of market manipulation that defendants used to drive Mullen's share price downward between November 5th, 2021 and November 15th, 2023. So a little over 2 years is the relevant period for this specific lawsuit case. And as discussed in depth below, the defendant's spoofing schemes involved the strategic placement of cancellation of thousands of orders to sell on a NASDAQ limit order book. These orders to sell, commonly referred to as baiting orders, were not intended to be executed and had no legitimate economic purpose. So that is, by definition, what spoofing is, and Mullen and their attorneys are about to go into much detail as we continue on. So the defendant's spoofing schemes were executed through algorithmic trading programs that were utilized on high-frequency computer systems. It's important to define that because as we will continue to move forward and you'll learn more about this, these specific baiting orders were placed and canceled within seconds, not even seconds, within microseconds and nanoseconds of actually being placed. So let's go ahead and keep reading here. So the use of this highly sophisticated technology enabled the defendants and or customers to place and cancel thousands of baiting orders in a matter of milliseconds, repeatedly during a trading day and throughout a protracted trading period, thereby causing Mullen share price to remain artificially depressed. So it's really important that they set that up to let the potential judge know exactly what the spoofing claims are going to be and how they can define spoofing and how they can prove spoofing. So we're going to go into that again as we continue on. So during the relevant period and reliance on the NASDAQ stock market being efficient and free from manipulation, Mullen sold over 5 billion shares, and the shareholders similarly sold shares at prices that were artificially depressed due to the defendant's unlawful spoofing schemes. It's important again that Mullen correlates this because yes, there were a lot of security purchase agreement warrants that were exercised during this period, but what's important to know is that if the spoofing, these baiting orders that artificially drove the price down, if those had any type of impact on Mullen's share price, then the exercise of those warrants by the different lenders, they're going to get them at the specific market price. If that market price is being reduced, that's going to create additional demand for more warrants, and we saw that as Mullen continued to have to provide additional supplemental prospectus filings, which means they gave more warrants to kind of compensate from the anti-dilution clause. So Mullen's going to go ahead and go into that a little bit further. So this lawsuit seeks to hold defendants primarily liable for their own unlawful principal and agency trading and knowingly, recklessly failing to fulfill their gatekeeping responsibilities of designing, monitoring, and enforcing a system of risk management and supervisory controls, policies and procedures that ensure that their traders and or customers complied with all applicable regulations and laws, including, and Mullen goes ahead and lists the actual laws that these market makers have to maintain, Section 9A and Section 10B of the Securities Exchange Act of 1934, and they go into the rules and the common law. So just in case you're still not quite familiar with how spoofing works, or in case the judge isn't quite familiar, the attorneys went ahead and gave a little bit more details in terms of spoofing. And again, they're going to use this information to kind of tie in how they can prove that these specific market makers were using this process. So in an efficient stock market that is free from manipulation, the prices of securities are determined by the natural forces of supply and demand. The greater the demand or lower the supply, the higher the price. Conversely, the lower the demand or greater the supply, the lower the price. The objective of a spoofing scheme is to distort publicly available information concerning the actual supply and demand of a company's securities by injecting false and misleading information into the marketplace. So if you are an investor and you're looking to purchase a specific security, whatever stock that may be, you're probably looking at that bid versus ask price, and you're probably trying to figure out, man, how can I get this thing at the right entry point, and then how can I get the right exit point? So if there are these artificial orders being placed and then canceled in terms of spoofing, that could actually change what the public is seeing in terms of the bid and the ask. So it's important that Mullen further defines that. Specifically, a spoofer often utilizing high-frequency trading computer programs that operate algorithmic trading programs to maximize the speed of their market access and execution of their trading strategies creates a false illusion of excess supply or demand by placing baiting orders into the limit order book. These baiting orders are not intended to be executed and have no legitimate economic purpose. That is bolded for emphasis because they are showing that this is a form of manipulation when the market makers place orders and they have no intention of filling those orders just to change the perception of the share price. That in itself is a form of manipulation. Instead, the baiting orders are placed solely to create the illusion of market interest, which is intended to generate a response from other market participants to follow the artificial selling or buying trend that the baiting orders were intended to create. So typically a trader buys when he or she thinks the price of a security is likely to go higher and sells when they think the price of the security will go lower. However, one of the clear signs of spoofing is a rapid reversal of trading direction. For example, where a market participant places many sell orders followed by a buy order followed by the cancellation of sell orders. This type of behavior strongly suggests that the original sell orders were not intended to be executed and instead were merely a ploy to drive the price downwards to buy low. So again, this is a way that these market makers are basically getting other people to purchase at these perceived bid prices, and then they're able to remove or cancel those specific bids. And then once the price is at a value that they want to enter at, then they'll enter at that. And that is spoofing and manipulation. So spoofing can be used to artificially inflate or lower the price of a security. If the spoofer's goal is to drive the price down, the spoofer enters baiting orders to sell, which are intended to bait or trick investors into entering their own sell orders to minimize or avoid suffering losses in a downward trending market. Shortly after the spoofers place the baiting orders to sell, and after those baiting orders have lured unsuspecting market participants into placing their own orders, the spoofer places orders to buy or executing purchases on the opposite side of the limit order book. These executing purchases to buy are intended to be executed at the artificially lower or low prices generated by the baiting orders to sell. Immediately after executing purchases to buy in a limit book order, the spoofer cancels the baiting orders to sell or otherwise removes the supply of shares represented by the baiting orders to sell, completing the spoofing cycle. And a spoofing scheme, whether to drive the price upward or downward, is frequently used multiple times during a trading day and repeated throughout a protracted trading period. While each spoofing event may have a limited impact on the market, and this is important, and I'll go into detail a little bit more, the cumulative and sustained effort of spoofing that occurs over a prolonged period can have a sustained negative impact on the price of the targeted security. So again, that little bit of information at the end is very important because this is part of the case. Although these specific baiting orders, this whole spoofing process may only show a very small amount of supply and demand changes, it does have a long-term impact on the price. And we will find out about more of that as we go along. It's actually part of the Exhibit 5. I'll give you a little sneak peek there. All right, this next little bit is going to be how Mullen's attorneys are setting up the future claims. So we're going to go ahead and get right into this. So the defendant's unlawful spoofing scheme. So it's basically defining how they were doing these specific things. So each defendant has participated in spoofing schemes. It is difficult to identify manipulative schemes in listed securities like Mullen on the basis of publicly available data because those who participate in market manipulation schemes often employ a variety of tactics to hide their unlawful conduct. And in most order flows, in listed securities is publicly available only in anonymized form, which means you don't know who the buying or selling is. However, under the NASDAQ rules, registered NASDAQ market makers must post de-anonymized buy and sell orders, the two-sided obligation. So they have to actually notate their specific buy or sell orders. That identifies them as the registered market maker behind the orders. Each of the known defendants were NASDAQ registered market makers during the relevant period. So again, they would have to abide by these rules. The two-sided obligation applicable to the known defendants mandates that each be willing to buy and sell security for its own account on a continuous basis during regular market hours. Moreover, Every broker-dealer, including the known defendants, is required under NASDAQ rules to engage in a course of dealings for its own account to assist in the maintenance insofar as reasonably practicable or of fair and orderly markets. So again, they're required to participate each day in the market for the different securities that they're representing as market makers. On information and belief based on methodology described in paragraphs 38 through 45, defendants' market activity in Mullen shares was not limited solely to de-anonymized orders placed pursuant to their NASDAQ two-sided obligations. Records produced by the Depository Trust and Clearing Corporation, the DTCC, indicate that the defendants often transacted far more Mullen shares that were evidenced by their de-anonymized orders alone. So that's important as well. Basically, they were doing additional transactions and they were not logged on these two-sided obligation orders. So that's important, and Mullen's going to be able to, or Mullen's attorney is going to be able to show how that is relevant and how these market makers did just that. For example, on the settlement date of July 14th, 2023, reflecting transactions executed on July 12th, 2023. And remember, there's a T+2 period. So whatever, that's the settlement date, whatever transactions were happening on day 1, they will be known on day 3. They will actually hit those specific accounts on that day. For example, on the settlement date of July 14th, 2023, reflecting transactions executed on July 12th, 2023, DTCC daily position reports show Clear Street LLC's DTCC closing balance increased from 22,016 the day before to 401,516 shares of Mullen. So that's an increase of 379,500 shares. An increase in Clear Street LLC's DTCC balance on the settlement date of July 14th, 23 indicates that Clear Street purchased shares of Mullen stock on the transaction date of July 12th, 2023. So again, Mullen and their attorneys are setting up how they're able to prove that this market maker made a significant number of purchases during this specific trading day, and it was not just provided by these de-anonymized orders. So again, however, NASDAQ's records indicate that none of the de-anonymized orders placed pursuant to Clear Street's two-sided obligations were executed on the trading date of July 12th. So according to NASDAQ, this market maker didn't place any orders. But again, with using the DTCC, you can show that it did. This may be hard to see, but I just wanted to break down some of the footnotes in this specific lawsuit case. So this is actually really important. When I started to read through these, I realized the importance. So I actually kind of jumped through the footnotes instead of just looking at the main filings after I had finished all the filings. Just let's read along. After plaintiffs filed the original complaint in this matter, Clear Street Markets and IMC wrote to the plaintiff claiming that they did not trade any shares of Mullen on a large number of dates listed in the original complaint. IMC's counsel went further and during a meet and confer represented that IMC did not even place a single order for Mullen shares on the days on which spoofing was alleged in the original complaint. For several reasons, plaintiffs do not find these representations credible. This is important because those of you who have been following this lawsuit, you would have seen these specific market makers, the defendants, you would have seen their response where they were basically trying to kind of discredit and disprove, saying, hey, none of this stuff really happened. They provided a very small amount of actual orders that were placed and showed the insignificant amount of money made by them in regards to that. So again, Mullen's attorneys have went back through and they've added this response, and I think it's very powerful, and I think it's very important, and I am optimistic that the judge will see it just like that. So first, these no trading representations by Clear Street Markets and IMC are inconsistent with their obligations under the NASDAQ rules to engage in a course of dealings for its own account to assist in the maintenance insofar as reasonably practicable of fair and orderly market. So we talked about that already, but again, the attorneys are putting that little bit of information out there. Second, Clear Street Markets claim that Clear Street did not transact in Mullen shares on any of the pricing dates is contradicted by data obtained from the DTCC. We just went over that. As discussed above, a purchase of Mullen shares would not necessarily lead to a change in Clear Street LLC's DTCC balance, if purchases and sales offset each other. However, the DTCC data indicates that ClearStreet, its subsidiaries, corporate parents, corporate siblings, or affiliates, or its customers purchased Mullen shares on the days identified in the first amended complaint through its own account and or through third parties that ultimately accumulated in clearing transfers to ClearStreet. For example, DTCC records for settlement date March 18th, 22, reflecting purchases and sales executed on March 16th, 22, show a net increase of 916,264 shares in ClearStreet LLC's closing balance, from a closing balance of 31,835 shares on the settlement date of March 17th, 22. So that's a significant amount of increase of shares that ClearStreet LLC was responsible for within a single trading day. And again, this is what the defendants are saying they didn't do anything about, or they weren't participating. Okay, so the date for which the DTCC position report strongly suggests net purchases by ClearStreet, March 16th, 22, was a pricing date for sales of shares by Mullen. Similarly, IMC cleared through Goldman Sachs, while other parties also cleared through Goldman Sachs. DTCC records for settlement date March 14th, 23, reflecting purchases and sales executed March 10th, 23, show a net increase of 825,944 shares in Goldman Sachs closing balance, from a closing balance of 24,432,488 shares. Shares on the settlement date of March 13th, 23, to a closing balance of 25,258,432 shares on the settlement date of March 14th, 23. So again, they're showing a single day change. They're showing a net increase of shares in the Goldman Sachs closing balance, and Goldman Sachs is being utilized by IMC. The date for which the DTCC position reports indicate net purchases by Goldman Sachs. March 10th, 23 was a pricing date for sales of shares by Mullen. Third, ClearStreet Markets representations concerning its order activity were inconsistent with the NASDAQ data. For example, ClearStreet Markets claimed that on October 25th, 22, it maintained a single order to buy 100 shares of Mullen and a single order to sell 100 shares of Mullen at all times for the entire trading day on October 25th, 2022. However, on October 25th, 2022, ClearStreet Markets placed over 60 distinct new attributed orders, which did not replace prior orders, message F in publicly available NASDAQ Total View, ITCH, historical data, at prices ranging from 42 cents to 78 cents, or 0.7865 cents. In addition, on that day, ClearStreet Markets placed over 48,000 new orders, which replaced prior attributed orders. The aggregate share volume in these cancel replace messages total over 4.9 million shares. So again, if you're a judge and the defendant comes out with false information and the plaintiffs turn around and provide clear evidence to show that what they're saying is not true, it's not looking too good in my opinion. Fourth, IMC's counsel's representation during a meet and confer that IMC did not place any orders for Mullen shares on the pricing dates in the complaint is flatly contradicted by the ITCH data. Finally, neither IMC nor ClearStreet Markets provided Mullen with verified records of their own order and trading activity as submitted to the Consolidated Audit Trail pursuant to their regulatory obligations. As evidence of its own activity, ClearStreet Market provided a partially redacted screenshot of 2 Excel sheets showing 4 rows of data on 2 days and publicly available ITCH data already in Mullen's possession. In conducting a reasonable inquiry into the factual basis of these allegations, plaintiffs are not required to accept ClearStreet Markets and IMC's self-serving, unverified representations that are inconsistent with their legal obligations and the data plaintiffs obtained from third parties. So again, Mullen showing that these specific defendants are giving very little information or publicly available information, and Mullen is able to use the DTCC to actually show, prove by transactions that these volumes, these number of shares were a lot larger than what the defendants are claiming. And getting into the details of some of these transactions, Mullen and the attorneys are trying to show that the baiting orders that were never meant to actually be transacted were very much so utilized in order to drive the price either up or down by the market maker. So if you look at section 39, it says here plaintiffs' claims are based on a far more conservative methodology. So really quick, if you were looking at the lawsuit, you'd see that typically a lot of these spoofing cases are able to use a 5-second window of time in order to validate that it was very much so a baiting type order and that spoofing was going on. What Mullen and the attorneys did is they went a lot more detailed and a lot quicker time periods of transactions, which helps increase the probability that that is what was going on. So again, here the plaintiff's claims are based on far more conservative methodology than the 5-second imputation window, which was found adequate to survive a motion to dismiss in NWO. Instead of 5 seconds, plaintiffs attributed orders set by a NASDAQ market maker only if they were placed within the same nanosecond or millisecond of each other. So that is a very, very small portion of time at which these orders were placed and then removed. Again, if a company is using software such with algorithms and things of that nature, that is how you're able to create such quick baiting type orders. So this highly plausible interference is based on, among other things, the properties of the technology through which order messages are sent to exchanges in computerized packets of data, meaning that a single market participant's close in time orders are likely to be part of the same data envelope, with the result being that a market participant's close in time orders are submitted at almost the same time to the exchange. So I think that's really important that Mullen and the attorneys are basically utilizing a much more conservative methodology to show that these specific transactions were very much done by the market maker. All right, jumping into section 45, the method imputes the firm identifier from the de-anonymized orders to anonymized orders arriving within the same nanosecond or millisecond, again, based on the expectation that the anonymized and de-anonymized orders are sent by the same market participant at the same time, including cancel replace messages throughout the trading day, which indicate a new order was replacing an old one. And then I highlighted this for importance. And moreover, to ensure that the same order was not included more than once, the methodology took the added precautionary step of removing duplicates that arose during the imputation process, even though doing so could remove accurate imputations and result in spoofers evading liability for their participation in spoofing schemes. So again, Mullen is going, and the attorneys are going much more granular than a 5-second window. They're going into millisecond and nanosecond transactions, as well as removing any duplicates. So if a same baiting order is utilized for the exact same amount of money, it is being taken out of this spoofing case. All right, now we're going to go into the magnitude for this specific suit. So now that you've understood exactly what the spoofing is about and how Mullen and the attorneys are utilizing the market data in order to show the relevance and to show the case for which these market makers would be doing the spoofing, you can see exactly the total magnitude. So defendants, this is section 58, defendants submitted fictitious baiting orders totaling at least 470,931,814 shares on the NASDAQ during the relevant period. So that's the 2-year period. The defendant's baiting orders led to a substantial sell-side imbalance in defendant's order flow, which were intended to and did send false and misleading pricing signals to the marketplace that interfered with Mullen's share price being determined by natural forces of supply and demand. Oh, and this is section 60. Over the course of each spoofing episode, the baiting orders placed by the known defendant successfully induced the entry of sell orders from other market participants, driving down the price of Mullen shares by an average of 1.09% per episode. So again, between Mullen exercising providing shares for the exercise warrants and also these 2 new plaintiffs putting in sell orders as well, all of those transactions are being affected by the spoofing. Section 61, almost simultaneously, the known defendants executed existing purchases to purchase a total of 2,777,294 shares at these depressed prices below the prevailing best offer price or best offer prior to entry of the baiting orders. So again, these market makers, these defendants, are utilizing the spoofing methodology in order to get a reduced price. Going into on the right-hand side, this is part of section 65. Only after complete and full party and non-party discovery can plaintiffs conduct a full and complete analysis of market activity to determine the extent of or to which the known defendants and John Doe's unlawfully manipulated Mullen share price. So again, this is just the information that Mullen and the attorneys have been able to put together. There is a lot more that if provided in discovery, specifically these John Doe's, this could be even larger of a magnitude case, but this is what Mullen and the attorneys are putting out for the judge to review. I went ahead and highlighted UBS as them being the market maker. They have the largest portion of baiting orders as well as the average price decline. So you can see that during the relevant period, UBS purchased a total of 470 times and had a total amount of baiting orders of 431,034,674. So that is a ridiculous amount of offset between baiting orders and actual purchases. And then the purchase volume during that time period was 689,621 shares. So again, they're utilizing over 430 million baiting orders in order to purchase a total of 689,000 shares over the course of 476 transactions. So just looking at the ratio of baiting orders to purchase volume, it is 625 to 1. And again, it had an average price decline of negative 1.7644%. So again, that is for those specific orders. And as Mullen has and the attorneys have talked earlier on in this filing, and you'll hear later on in the filing, this is not a temporary adjustment to the price. This has more of a permanent result in price action, and you will see how that's tied in later. All right, Section 82 says, as discussed above, defendants participated in spoofing schemes either by placing orders and or executing trades for their own proprietary or principal amounts, or doing so on behalf of customers or clients. Either way, pursuant to applicable industry rules and regulations. And here's how Mullen's attorneys are tying in what's going on with the law. It says, including SEC Rule 15C 3-5 and FINRA Rule 3120 and their own compliance manuals, defendants were gatekeepers of the integrity of the marketplace. Defendants were required to have internal policies, procedures, and systems that monitored, detected, and prevented their own and manipulative or fraudulent trading devices or schemes of their customers. Defendants failed to adequately design compliance systems or maintain supervisory policies and procedures to prevent the spoofing episodes set forth in this first amended complaint. Given defendants' obligation to monitor, detect, and prevent manipulative or fraudulent trading, and their FINRA report 3130, in which they stated they did in fact do so, defendants either intentionally manipulated the market through their spoofing scheme or recklessly ignored their own or their customers' fraudulent trading. So that's a very powerful statement that Mullen's attorneys are making in terms of the defendants and how they are acting outside of the law. And these are the allegations that are set forth against the defendants. And then the next section I want to talk about is Section 83. It says the short time period between the placement and the cancellation of defendants' baiting orders is further indicative of scienter. And scienter, for those of you who don't know, in legal terms, it refers to a culpable state of mind. In other words, scienter is a defendant's knowledge that an act or conduct is wrongful and intent to act despite this knowledge. Scienter is often an element of liability, including in most cases involving assertions of fraud. So again, it's a very powerful word. Those of you who didn't know what it meant, I didn't know either until I had to look it up. If you are a legal buff, you probably already did know that. But again, this is definitely what Mullen is putting in here, and you will see later on that there is a section of claim about fraud. So the short time period between the placement and cancellation of the defendant's baiting orders is further indicative of scienter. The known defendants placed and then canceled the baiting orders within seconds and even milliseconds. The fastest time to cancellation among spoofing episodes by IMC, UBS, and Clear Street, and you can see the times there was 0.000000822. That was by IMC, and then UBS was 0.000062106, and then again Clear Street, they give that as well at 0.000001181 seconds respectively. This practice, which occurred thousands of times over the relevant period, indicates that the known defendants were never intended to execute the baiting orders. Again, how do they do this? They did this through their proprietary trading software, their algorithms, and everything else of that nature. Section 85, the size of the baiting orders that were canceled in comparison to the size of the bona fide sell side orders that were executed by the known defendants is also indicative of scienter. During each spoofing episode, the known defendants placed and subsequently canceled a median of 5,700 shares in baiting orders while executing a median of 0 sell-side orders. So that's pretty big. That's showing that these three defendants had placed volumes of baiting orders and had zero actual executing sales. So why would they be making these if they didn't have any intention of actually offering these on the market? Because this is part of this baiting and the spoofing that we've been talking about. All right, jumping ahead to section 90, I went ahead and highlight and underline some pretty important parts. Just wanted to kind of talk through this. Defendants had a strong motive to spoof shares of Mullen stock by posting the fictitious baiting orders. Defendants were able to purchase millions of Mullen shares at depressed prices compared to purchasing shares of Mullen at the prevailing best offer. In some cases, as described below, the known defendants executing purchases closed out a pre-existing short position, yielding an immediate profit. In other cases, known defendants converted these profits to cash by selling shares prior to the price decline or following a partial rebound. So again, the allegations is that these defendants were manipulating the share price using these baiting orders to not only gain money in terms of their short position and be able to close those out, but also to be able to cash out specific sales or purchases at a lower, partially deflated position or share price. Going a little bit further, they provide an example that the SEC took. So section 91, while the profits from any single spoofing episode are small, the rapid placement and cancellation of these baiting orders by known defendants shows how the accumulation of profits due to spoofing activity may be substantial. Because rapid placement and cancellation allows the strategy to be repeated over and over and applied to numerous securities on an industry or even market-wide basis. And then here it is. In SEC versus Lex Securities, a case which involved a common form of spoofing known as layering, the SEC wrote in its complaint that although the defendant's profit on any single instance of layering might have been small, when multiplied by hundreds of thousands of instances of layering in which the defendant capitalized this section, I didn't put the rest of it here, but basically this is giving an example from the SEC in terms of this specific securities entity, that although these individual ones didn't amount up to a lot, over time in combination it would become substantial. So jumping on to section 100, Clear Street had a motive to engage in spoofing in order to close a short position. So we already talked a little bit about one of these other defendants, but this is actually going into more the defendants in general. This one's going into more detail. So Clear Street had a motive of engaging in spoofing to close out a short position of Mullen stock, and they gave an exact example on March 8th, 2023, and they gave the exact time up to the, looks like millisecond, nanosecond. Clear Street sold 100 shares of Mullen stock at a stock price of 0.1953 per share, yielding a return of 3.224101% by executing purchases at artificially depressed price of 0.1892. So again, this is an example of how they were manipulating or allegedly manipulating the stock price in order to be able to close out their short positions. While the dollar profits on that single transaction were small, the profits from spoofing activity are far larger when performed repeatedly and compounded through Clear Street's algorithms that operate in thousands of securities. On an annualized basis, the return of this spoofing episode is extremely significant. Achieving that return every day over 1 year would have multiplied Clear Street's capital invested in spoofing episodes more than 8-fold over the course of the year. So this is how Mullen is tying the magnitude of what's going on to this one specific episode. All right, jumping to section 138, we had already talked about Clear Street. Now we're going to talk about UBS. So UBS had a motive to engage in spoofing in order to close their short position in shares of Mullen stock. On August 23rd, 2023, they give the exact time, UBS sold 200 shares of Mullen stock price at 0.8469 per share, yielding a return of 2.159228 by executing purchases at the artificially depressed price of 0.829 per share. So again, this is an example that Mullen is providing of how this defendant is utilizing the baiting orders and this spoofing methodology to be able to close out a short position. While the dollar profits on this single transaction were small, the profits from spoofing activity are far larger when performed repeatedly and compounded through UBS's algorithms that operated in thousands of securities. So this is the exact same thing they're talking about with Clear Street. For this instance, they went ahead and extrapolated over the course of a year, and for them, they would have more than 5-fold over the course of the year in terms of return. Jumping into section 157, so this is where Mullen starts to talk about how these spoofing episodes affected other entities, company, or individuals. So defendant spoofing caused plaintiffs to suffer significant losses. So during the relevant period, Mullen sold or issued for value over 5 billion Mullen shares. We know that these shares were added into the market in terms of warrants being exercised. However, if the prices were temporarily, artificially depressed, that would have a significant impact as these shares were exercised and put into the market. As set forth below, many of the known defendant spoofing episodes occurred immediately prior to plaintiff's sales or issuances. So this is what I was talking about in terms of warrants. Because plaintiffs sold or issued for value Mullen shares during the relevant period, at times when the prices of those shares were artificially deflated due to defendant spoofing, plaintiffs were directly damaged by defendant's unlawful conduct. So if you remember, Mullen shared in their 10K, or I'm sorry, their 10Q, their annual return, sorry, 10K, that they had a realized loss of over $1 billion in terms of some of the security transactions. And this is a portion of that. Yes, they did sell their securities to various lenders. However, the price of the shares did go down over time, and this spoofing episode did play a factor into that. So that's what Mullen is tying in right now. So jumping down to 158, each spoofing episode was intended to and had a significant immediate impact on the price of Mullen shares. The after effects of each spoofing episode could be felt most strongly within 1 minute of the cancellation of the bidding orders, with a significant and observable effect persisting for hours and lingering for multiple days. So again, this played a significant part in Mullen's share price decline for specific timing of each of these episodes. And you'll see in just a few more slides how this correlates to long-term impact. And in terms of the long-term impact, here we go. Section 161. This effect, the persistence of the price impact of manipulation, is well established in the market microstructure literature. As Nobel Prize winning economist Professor Milgram has explained, because manipulative trades are viewed by the market participants as potentially informed, and potentially informed trades can result in permanent price impact, manipulative trades can lead to permanent price impact. So there you go. So this basically correlates, this professor correlates that these episodes will have permanent price impact to these different companies, to the stock. Based on excessive review of applicable literature, Dr. Milgram provides 2 reasons for why the market participants cannot readily identify manipulative trades. So the first reason is highly improbable that manipulative trades can immediately be identified as manipulative and uninformed by the market participants. For any agent in the market, the incentive to gather private information and thus become informed is directly related to the volume of its trades and of its position. So that's important to kind of show it's very difficult to be able to prove that these were manipulative. However, Mullen has put together the case using the DTCC information as well as the NASDAQ transactions, and then what the small amount of information that these defendants have provided. They've been able to tie all this together to kind of show how these spoofing episodes were created and then what the impact was. Jumping into section 168, Professor Milgram discusses the extensive economic literature establishing that the price impact of any form of trade-based manipulation, including spoofing, is not likely to fully reverse, meaning it's going to be a permanent impact. Peer-reviewed research has found that order cancellations drive the price up by less than new orders drive the price down. So again, when it comes to bait orders, anytime that you have a baiting order which is less than the best offer at the time, it has a much larger impact than having a baiting order with the price going up. For this reason, the impact of baiting orders is not likely to dissipate merely because those orders were subsequently canceled. Manipulative spoofing causes the execution of trades, not only the placement of orders, because baiting orders induce other market participants to sell shares at artificially depressed transaction prices. So again, whenever market participants, whether they be shareholders, whether they be institutions, when they start to see the bid price going down, whether they have limit orders or whether they have specific types of price points that they're looking at, when these bait orders do show up, they have some of these companies, some of these institutions, they use their own set of algorithms in order to do these trades, and they're going to automatically get out when they see these depressed pricing. So going into 169, the permanent price impact that Professor Milgram discussed as resulting from manipulative trading is established in the economic literature and is not limited to same-day effects. So again, this does have a lasting impact. So we talked exactly how the spoofing episodes were done, how Mullen was able to tie the three defendants to their transactions, in terms of the baiting orders versus the executed orders, how those companies were making some profits. We talked about how the short-term impacts of these spoofing episodes, and then we talked about how there is a permanent impact according to the Milgram report. And if you want to hear more about the Milgram report, it is Exhibit 5. And I can share that if you guys would prefer. Just shoot me a comment and I'll break that down as well in a later video. But going into the injury, in fact, and loss causation. So this is where they're talking about how the different plaintiffs are being affected. So Section 170, as set forth more fully herein, defendants' fraudulent trading activities have both temporary and long-term adverse effects on the market price of Mullen securities. 171, during the relevant period, the spoofing events identified by the manipulation analysis occurred on 359 out of 504 trading days, which is 71% of the trading days within this specific period, the relevant period. Based on records maintained by shareholder plaintiffs, the shareholder plaintiffs sold various amount of shares during the relevant period. So again, this is showing the price action for Mullen as a company and how they were exercising shares for these warrants. Based on records maintained by Mullen, over 5 billion shares were sold or issued for value by Mullen during the relevant period. Many of these sales consisted of issuance of shares to satisfy debt obligations. So these are the SPAs, the warrants, or other liabilities where the price of the shares was formulatically, we're just going to leave it like that, derived from secondary market closing prices on one or more days on which, as indicated by manipulation analysis, those prices were artificially depressed by defendants' manipulative spoofing. So again, this is how Mullen, a company, this is how they were affected in terms of their money, and then how the share price was affected. Section 174, we'll just talk a little bit about pricing formulas. They can divide into two groups. First group consists of sales of common stock, which occurred at closing price of one or more pricing dates. So these would be the ones that the various shareholders, market participants would have been exercising in terms of common shares. And then the second group is the issuance of shares to satisfy debt obligations. So these would be the warrants. So both of those have impact. And yes, the exercise of warrants adding additional shares to the common share count will have some impact, but when you couple that with the spoofing episodes, it has a larger impact, as well as market participants selling their shares at these temporarily deflated pricing points. Jumping into the next section there, talked about the liabilities. So these liabilities are both cashless warrant exercises, where the value of the liabilities extinguished by the sale of shares was based on the closing price of one or more pricing dates on which those prices were artificially depressed by defendants' manipulative spoofing. So again, we talked about the derivative liabilities on the Mullen 10K, and this is what drove some of that impact. Collectively, the dates for which the closing prices were used to, there's that word again, formulaically, there you go, derive the value of the sale or issuance are the pricing dates. So then it talks about the different exhibits. So exhibit 2 would be the sale of Mullen shares or issuance for value by Mullen, the company, at prices artificially depressed by the defendant's spoofing activity. They talk about the different spoofing episodes by each known defendant, and that they were occurred on the designated pricing date, thereby depressing the price of Mullen shares sold or issued by Mullen on the indicated transaction date, which was executed at the closing price of Mullen shares on the pricing date. So again, Exhibit 2, if you were to look through that, it's just a list of all the transactions from Mullen in terms of whether they be providing debt obligations in terms of new shares, adding to the common share count, or any of their actual purchase of shares themselves, because you remember they did have a share buyback program going on. Exhibit 3, this is section 176, this talks about the sales by plaintiff Cheyenne Korami. this plaintiff sold Mullen shares on open market in close proximity times when the known defendants participated in the spoofing schemes. And they gave examples of this. August 3rd, 2023, the plaintiff sold 100,000 shares of Mullen stock mere minutes after Clear Street engaged in the spoofing episode on that same day. Similarly, on June 15th, this plaintiff sold 25,243 shares of Mullen stock less than 2 hours after UBS engaged in spoofing episodes on that same day. And then Exhibit 4 is another plaintiff. This is Hyan Cha. Plaintiff Hyan Cha sold Mullen shares on the open market in close proximity to the times when known defendants participated in spoofing schemes. And then they gave an example of that. Jumping ahead to 178, defendants' fraudulent trading activities had both temporary and long-term adverse effects on the market price of Mullen shares. As discussed above, the artificially depressed price resulting from any given spoofing episode does not fully recover to the price that existed prior to the spoofing episode. And when spoofing events occur continuously throughout the day and continue without interruption over a protracted period of time, the long-term cumulative effect of spoofing places enormous downward pressure on the market price of a security, which is persistent and long-lasting. So if you remember, Mullen's attorneys they had the naked shorting case open, and then they had the spoofing case open. They said that the spoofing case would have a much larger and much more higher magnitude in terms of the impact for the share price of Mullen, and we're starting to understand a little bit more by understanding how the spoofing episodes were transacted and how Mullen, the company's stock, was impacted, as well as these two plaintiffs. Section 179, the priced impact of defendants' spoofing activity was not limited to the time period immediately following each individual spoofing episode. As a result, plaintiffs and Mullen shares and issuance for value of its stock throughout the relevant period were negatively affected by the defendant's spoofing that occurred in close proximity to those sales and issuance by the lingering price impact of spoofing episodes. So again, they're just laying out that the spoofing episodes had a significant impact on the company's transaction of shares. While each spoofing episode had a small negative impact on the price of Mullen shares, the placement and cancellation of baiting orders throughout the relevant period had a cumulative effect of driving Mullen share price down during the relevant period. According to manipulation analysis, defendants' wrongful conduct proximately caused the losses that Mullen suffered when it sold or issued for value shares at times during the market price of Mullen shares was being driven downward, or was driven downward by the lingering effect of past spoofing episodes. Plaintiffs suffered when they sold Mullen shares at times during which the market price of Mullen shares was driven downward. 181, defendant spoofing had a persistent and long-lasting price impact on the share price of Mullen, even when adjusted for market-wide price movement. So this is going to actually tie in the NASDAQ and look at that versus Mullen. The following graph shows the average cumulative return across spoofing episodes identified by manipulation analysis from 30 minutes prior to each executing purchase to the end of the trading day. The red line shows Mullen's return, while the blue line shows, for comparison, the return of the NASDAQ Composite Index. The dashed line shows the final cumulative return over the minutes following spoofing episodes, indicated by manipulation analysis. So you can see that the spoofing episodes had a negative impact of 3.35%, which is highly statistically significant when looking at a standard t-test. So you can see from the top, the line that pretty much stays very close to 0%, that would be the NASDAQ Composite Index, whereas Mullen, if you look, they were following the NASDAQ Composite Index rather closely until the spoofing episode happened, and you can see that the big pull down there, about 1.5%, and then over time, throughout the rest of the trading day, you can see how that price impacted. All right, we're getting close to the end, folks, so bear with me. Just a couple more slides left to go. Section 183, moreover, to whatever extent confounding information that negatively impacted the price of Mullen may have emerged at around the same time as the known defendant spoofing episodes, it is exceedingly unlikely and implausible that the confounding information emerged at precisely the same time as so many of these spoofing episodes repeatedly, so as to confound the average price impact of these episodes. This is all the more convincing when considering that each spoofing episode occurred at points in time that are quasi-random, meaning they're unlikely to be systematically correlated with confounding information such as negative news releases. So this is basically tying in that these spoofing episodes did not have anything to do with any of the news that Mullen was providing, whether it be positive or negative news, that these specific episodes were merely the cause of these baiting orders. This strengthens the inference that the decline in the share price of Mullen stock was caused by the defendant's participation in spoofing schemes. So pretty much just negates the fact that the defendant may try to say, oh, well, Mullen put out some bad news, had some bad PR. That was actually the reason for the price decline. No, they were saying that these spoofing episodes were random and did not have any correlation to do with Mullen's news. Section 184. Second, the fact that there is no material or statistically significant price declines in the minutes leading up to the spoofing episodes, and we talked about that on the previous graph, strengthens the interpretation that the decline in the price at the time was caused by those episodes. It is standard practice in the economic literature to examine the presence or absence of so-called pre-trends. Again, pre-trend would be prior to something happening, and you can see that pre-trend was correlating with the NASDAQ, which might indicate that a purported causal effect was contaminated by a spurious event that was occurring prior to the intervention of interest. So again, part of the literature, you have to make sure that this is not a cause. And according to this report here, you can see that the PR was not at all involved with the spoofing cases. You can see that the price of Mullen stock was trending well within the NASDAQ Composite Index. Section 187. Moreover, these price declines accompanying the spoofing episodes are unlikely to have been caused by any dilution accompanying the issuance of shares by Mullen. So I know a lot of people have been very frustrated. They're saying that the share price has been just dragged down due to dilution. But what they're showing here is that outside of any forms of dilution, these spoofing episodes had a major impact to the price. To the extent any dilution negatively affected the price of Mullen shares, that would have occurred through the additional sale of newly issued shares. However, the spoofing episodes occurred at short, discrete intervals in time. There's no reason to believe, nor has Mullen identified any evidence to consider that purchases of newly issued shares were aware of spoofing episodes. Basically, meaning that these lenders that were exercising warrants, they were not aware of these spoofing episodes and were trying to sell prior to that occurrence or during that occurrence. Much less that those shares were likely to be sold during these short, discrete intervals in time. Sorry, I just read that. It is extremely unlikely as a statistical matter that any such sales occurred systematically within narrow 2-minute windows of time. The sharp decline in price of Mullen shares in those very minutes indicates that dilution was not responsible for that decline, because any such price impact to dilution would have naturally occurred over the course of time as newly issued shares were sold into the market, meaning Mullen's just not dumping millions of shares within a millisecond. The spoofing episode happened within a short period of time. You could see a massive, or you could see a large, I should say, price decline in percentage. All right, we've tied the spoofing. We've talked about how it had nothing to do with Mullen's PR, how they're showing that it was not at all impacted due to the dilution because of the timing of it. So now we're going to talk about the claims for relief. So the first claim for relief for spoofing in violation of Section 10B of the Exchange Act 1934 and Rule 10b-5a and c promulgated thereunder. Plaintiffs incorporate by reference paragraphs 1 through 192 as if fully set forth herein. So basically they laid it all out, and then now here's what they're asking for. During the relevant period, the manipulation analysis indicates that defendants participated in a scheme that was intended to and did manipulate the price of Mullen shares by placing baiting orders on NASDAQ. Defendants' baiting orders were used to further a market manipulation scheme that had a direct and immediate adverse impact on the market price of Mullen securities being traded on NASDAQ. And they talk about rules 10b-5a and c make it unlawful for any party to employ any device, scheme, or artifice to defraud and to engage in any act, practice, or course of business which operates or would operate as fraud or deceit. So basically, this specific portion of the law says you cannot do anything that you know is illegal, that is deceitful, which is where that word scienter gets put in place. So the manipulation analysis indicates that defendants are liable for placing baiting orders on NASDAQ that had no legitimate or economic purpose, were never intended to be executed, and were part of a spoofing scheme. placing executing orders that were intended to complete the spoofing episode that operated as a scheme to manipulate the market price of Mullen securities. Second claim. This is spoofing in violation of Section 9A2 of the Securities Exchange of 1934. Plaintiffs incorporate by reference paragraphs 1 through 204 as it's fully set forth herein. The manipulation analysis indicates that defendants' manipulative schemes violated Section 9A2 of the Securities Exchange Act of 1934, which makes it unlawful to engage in a series of manipulative transactions in any security, creating actual or apparent active trading in such security, or raising or depressing the price of such security for the purpose of inducing the purchase or sale of such security by others. So you can't manipulate the stock price in order to be able to make a transaction, in order to make a sale. So we already talked about how they closed out their short position. We talked about how they made some profit in terms of after these spoofing episodes occurred. All right, and this is the last slide of the lawsuit document that I'm sharing with you all. So thanks for bearing with me. Let's go ahead and get into this last little bit. So third claim for relief is for New York common law fraud. So this is why I mentioned that they were talking about fraudulent activities. Plaintiffs incorporated in reference, and again, they're going to talk about all the paragraphs used in this specific lawsuit document, this filing, 1 to 210, set forth herein. Plaintiffs seek to permanently enjoin defendants from engaging in spoofing conduct, whether on their behalf or on behalf of their customers, that affects the Mullen share price. This is huge. If successful, they're not going to be able to spoof any more of Mullen shares. And this is going to set a precedent for any future market makers that may want to try and attempt to do the same thing. Defendants' actions identified herein have caused, continue to cause, and will cause future permanent and irreparable harm to Mullen. Plaintiffs Hyan Cha and Cheyenne Korami presently own shares of Mullen stock and thus still are and will continue to be harmed by the defendant's spoofing conduct. So they're putting it all out there like, you guys need to stop them from doing this moving forward. The balance of the equities favors an injunction to prevent defendants from continuing to spoof shares of Mullen stock. The harm to plaintiffs is significant. In contrast, the potential harm to defendants of an injunction is insignificant, meaning it shouldn't hurt them to be forced to stop spoofing. It's not legal. They just went over all that. They provided the law, the Securities Exchange Act law that says you can't do this types of stuff. So the market maker should still be able to act as gatekeeper and do their job, regardless if they are being told by the attorney, or I'm sorry, being told by the judge, you can't do this anymore. Defendants would merely be required to halt their illegal activity. Thus, the public interest is best served by enjoining defendants' spoofing behavior. As noted throughout this first amended complaint, it is likely that the plaintiffs will succeed on the merits in this case. That is a very, very bold statement. It's a very confident statement that Mullen and the attorneys have. They're basically telling the judge, with all this information provided in paragraphs 1 through 210, we feel that this succeeds. That this is likely that the plaintiffs will succeed on the merits of this case. They laid it all out there. They provided all the steps. They provided transactions. They explained in detail on how this has long-term permanent impacts to the company's share price, and how the company, as well as these other two plaintiffs, how they were injured, or they're from a pricing standpoint, from a capital standpoint, because of this. So prayer for relief. This is what Mullen and their attorneys are asking for. Wherefore, plaintiffs respectively request that this court enter a judgment finding that defendants violated the federal security laws as alleged in the first amended complaint, ordering defendants to pay damages as a result of their unlawful conduct in an amount to be determined at trial. So this is going to be huge. If the judge agrees and moves forward with trial, the amount of damages, I'm assuming Mullen is going to be putting out another filing to kind of put into place how much, what kind of impact this is going to be financially. Enjoining defendants from engaging in any further manipulation of the share price of Mullen, whether on their behalf or their customers' behalf. This should be a no-brainer. Awarding reasonable attorney fees and costs together with all available pre- and post-judgment interest. Again, the defendant should be paying for the plaintiff's legal fees. The company's stock price should not be affected by that. And the last section here, The plaintiffs are demanding a jury trial. Pursuant to Rule 38 of the Federal Rules of Civil Procedure, plaintiffs demand trial by jury in this action of all issues so triable. Well, thank you so much for sticking around through the end of this and for reviewing this lawsuit filing with me. If you like what you heard, please consider liking this video. Subscribe if you haven't already. If you'd like to hear more content about Mullen, leave me a comment. Let me know what kind of information you'd like to hear about. And I will see you guys on the next one. Thanks. Hello and welcome to another video by Financial Ernie. On today's video, we're going to talk about a memorandum that was provided by Mullen Automotive and Mullen Technologies attorneys in regards to the March 21st conference with GEM and their attorneys. So without further ado, let's get right into it. So before we jump into the case, it's important that we go ahead and define the parties that are going to be involved. So plaintiffs are going to be Mullen Technologies Inc. and Mullen Automotive. Defendants are going to be GEM Global Yield, as well as GEM Yield Bahamas, and Christopher F. Brown. The petitioners are going to be GEM Yield Bahamas and GEM Global Yield. Respondents are going to be Mullen Technologies Inc. and Mullen Automotive Inc. So now that you understand that, throughout this memorandum, you're going to need to pay attention when you hear the terms plaintiffs, defendants, petitioners, respondents. And they're going to go ahead and give you one more opportunity as you start to read through the intro of this. So let's go ahead. Pursuant to the court's directive made during March 21st, 2024 conference held in the above captioned matters, plaintiffs-respondents respectively submit this memorandum of law to address two specific issues. Number one, whether the above captioned actions and or plaintiffs' ongoing AAA arbitration with defendants-petitioners should be stayed. Number two, whether this court has the authority to order MAI to transfer $24 million into an escrow account in accordance with the second interim measures arbitration award issued by the arbitrator in the arbitration on or about January 24th, 2024, and that would be the interim award. As detailed below, the court should stay the confirmation of an interim award and any damages determined by the arbitrator pending this court's resolution of the securities action. In addition, there is no authority that would suggest that this court possesses the power to enter an order akin to the interim award. So that there is summarizing exactly what this memorandum is going to lay out. Mullen's attorneys went ahead and provided a lot of cases that are very relevant and support their arguments throughout this memorandum. I am not going to highlight each one of those different case studies. Just note that if you were to read through this is available on the Pacer. You would be able to find a lot of supporting documentation. So let's go ahead and continue on. So getting into the background, this is the factual background. We're going to start with Section A, the arbitration. GEM commenced its arbitration against MTI back on September 27, 2021. Several months later, GM filed an amended statement of claim which added MAI as a party to the arbitration and asserted 5 claims against both MTI and MAI, including a series of claims under the SPA and RRA, and a claim for breach of the warrant based on plaintiffs' alleged repudiation of their obligation to sell GEM shares pursuant to the warrant. On February 1st, 2022, plaintiffs filed an answer to GEM's amended statement of claim. You are not going to be able to see that answer. So throughout this document, you're going to see some redacted information. All of the redacted information has to do with specific quotes and specific items within the arbitration. So that document is sealed. That is still within the attorney-client privilege of the arbitration. So you're going to find that this memorandum deals with different items that are not part of that arbitration, and they go to show and prove to the judge that those items are not the same and cannot be treated the same. And therefore, as mentioned in the introduction, all of these specific arbitration penalties, these fees, these interim awards, those should all be rescinded or stayed. Either one of those, they mentioned stayed quite a few times, until the Securities Act concern, which is the complaint that Mullen has filed against GEM, until that comes to resolution. So let's go ahead and continue. Plaintiffs never reference sections 15A or 29B of the Exchange Act in their answer, nor did they subsequently pursue a defense or claim under those provisions. So again, that is basically lining out that they never talked about the Security Exchange Act at all during that arbitration. And we're going to find out a little bit more about that as we continue on. Number 2, or section B, is going to be the liability award. On November 17th, 2023, the arbitrator issued the liability award. Notably, however, the arbitrator never issued an award for breach of the warrant. So again, the arbitrator never mentioned anything in terms of the warrant. It's only been about the SPA and the RRA. In describing GEM's prayer for relief, for example, the arbitrator omitted any reference to a claim for breach of contract under the warrant and instead stated that, we don't know, as I mentioned, all of that information is being redacted. But let's go ahead and continue on. However, the liability award never explicitly analyzed or adjudicated, sorry about that, the merits of any defenses or claims available to plaintiffs under sections 15A or 29B of the Exchange Act, nor did the arbitrator make any findings regarding GM's status as an unregistered securities dealer. Again, if you've been following this case, Mullen Automotive, they went ahead on the offense and they did file a complaint and they're demanding a jury trial in terms of the fact that GEM, both the GEM Bahamas as well as the other GEM entity and Mr. Brown, none of those are registered security dealers. So none of those entities should be able to exercise any type of warrants. So let's go ahead and jump into section C, the interim award. On December 15th, 2023, GEM filed with the arbitrator an application for interim measures. Again, there's some redacted information. On January 24th, 2024, the arbitrator issued the interim award and ordered MAI to deposit $24,114,921 into escrow. The arbitrator derived his authority to enter the interim award from Rule R37 of the AAA rules. Rule R37 provides in relevant part that the arbitrator may take whatever interim measures he or she deems necessary, including injunctive relief and measures for the protection of conservation of property and disposition of perishable goods. So again, Mullen's attorneys are going to kind of argue that a little bit and explain why this specific amount isn't necessarily necessary. So on February 15th, 2024, GEM filed the related action and asked the court to confirm the arbitrator's interim award pursuant to the FAA and the New York Convention. On March 1st, 2024, plaintiffs filed their cross motion to vacate the interim award and to stay enforcement of the interim award pending this court's resolution of the securities action. On March 1st, 2024, the court issued an order terminating both GEM's application and plaintiff's cross motion and directing GEM to refile its application in the form of a motion for summary judgment. On March 5th, 2024, the court stayed all briefing in both of the securities action and the related action pending a conference with the court, as well as the enforcement of the interim award. So again, that was what this conference on March 21st was all about. Section 2, the court should stay confirmation of GEM's application to confirm the interim award and any damages determination by the arbitrator pending this court's resolution of the security action. So basically, Mullen's attorneys are stating that the interim award as well as any activities going on in that arbitration be put on hold until the securities action can come to an agreement. So as we know, Mullen's attorneys, again, they state that these lenders are non-registered lenders, so they are not allowed legally, according to the Security Exchange Act, able to deal in any of these types of securities. So Section A, the arbitration does not have preclusive effect on the securities action. The gravamen of defendant's request to stay the securities action in favor of the pending arbitration is that the arbitrator's passing reference in footnote 14 of the liability award to certain defenses asserted by plaintiffs should be given preclusive effect under doctrines of res judica. And for those of you who don't know res judica, you'd have to be a type of paralegal or an actual attorney to really understand that, or potentially judge. For those commoners like myself, I had to look this up. So res judica basically states that Once there's judgment that's held, you cannot reopen this type of issue. So that was the concern with arbitration. If the arbitration was completed and the judgment was held, Mullen Automotive could not come back and basically try to counter that using the Security Act or the Securities Action concern. So let's go ahead and continue on. And or collateral estoppel. For the reasons discussed below, neither doctrine should be invoked as a preclusive bar to the securities action. Plaintiffs' claims in the securities action are not barred by res judicata. To establish that the doctrine of res judicata bars a claim in federal court based on prior determinations in arbitral proceedings, a party must show that, number one, the previous action involved in an adjudication of the merits. Number two, the previous action involved the parties or those in privity with them. And number three, the claims asserted in the subsequent action were or could have been raised in the prior action. Defendants argue that the 15A claim in the securities action was previously raised in the arbitration. In support of this assertion, defendants point to plaintiffs' two vague defenses presented in their answer to GM's amended statement of claim. And they provide those two statements. Again, it's redacted, so we don't have that information. Those equivocal defenses, however, do not constitute the same affirmative claim asserted in the securities action. Rescission pursuant to Section 29B because the warrant was made in violation of Section 15A of the Exchange Act. Accordingly, absent any reference to Section 15A of the Exchange Act, the defenses raised in the arbitration cannot be interpreted to constitute the same claims in the securities action. So the defendants put out these two very vague statements about what Mullen's attorneys are saying. They're tying those statements saying that the warrant that was brought up is actually in violation of the Exchange Act. So the Exchange Act was not actually discussed during the argument from the defense. So I wanted to take a break from this section and kind of go into the footnotes. I thought footnotes 4 and 5 are actually pretty important. They give us a little bit more background, so let's go ahead and read those. In addition to the arguments herein, plaintiffs respectfully refer to the court to the arguments submitted in their opposition to defendants' request for stay, and add that the cases cited by the defendants in support of their stay requests are distinguishable from the case at bar. I'm going to go ahead and jump through those cases and continue down below. Section 5, plaintiffs assert two claims in the securities action. First one, which is I, a claim for rescission against GEM pursuant to Section 29B of the Exchange Act for violating Section 15A of the Exchange Act by making the warrant as unregistered dealers. And Section 2, II, a claim against Mr. Brown for violating Section 20A of the Exchange Act by acting as a control person of GEM in connection with GEM's transactions as unregistered dealers. So again, those two footnotes pretty much helped explain Mullen's defense on why they believe that it's very important that the judge considers the fact that they are working these warrants in violation of the Securities Exchange Act. All right, this next section is an actually pretty good point Mullen's attorneys are bringing up. So turning next to whether plaintiff's 15A claim could have been raised in the arbitration, courts in this district have refrained from applying res judicata to claims that arise from an agreement distinct from those previously arbitrated, particularly when the subject agreement of the litigation does not contain an arbitration provision. And they go ahead and state a case that kind of helps defend their claim or their clause here. So go ahead down here. Here, the warrant, the subject agreement of the securities action, not only lacks an arbitration provision, but it also includes an express jurisdiction and venue provision requiring that venue for any dispute arising under the warrant will lie exclusively in the state or federal courts located in New York, and the parties irrevocably waive any argument that New York is not the proper venue. The issuer and holder irrevocably consent to personal jurisdiction in the state and federal courts in the state of New York. Because the warrant does not contain an arbitration provision, it is not at all clear that the plaintiff's claim could have been included as a claim in the arbitration, and that plaintiff's claim has to do with the Securities Exchange Act. Accordingly, the arbitration proceedings do not bar plaintiff's claims in the securities action under the doctrine of res judica. So again, res judica means that even if this arbitration comes to a conclusion, it cannot be brought up again. That would be what res judica is. And what Mullen's attorneys are showing is the fact that they have the Securities Exchange Act clause, and the warrants never once mention arbitration, that you cannot, it can't be a closed book case, that this still stands on its own. And it's very important because, in my opinion, and what the attorneys are stating, is that if this case holds and the judge agrees that they are unregistered dealers, then the warrants are nullified, they get zeroed out. That means that the interim award amount would get zeroed out as well, because then it would have no face value in terms of warrant cost. So let's go ahead and go to the next section. Insofar as the court considers whether plaintiffs nonetheless should have raised their claims in the arbitration despite the warrant's exclusive jurisdiction provision, the Second Circuit evaluates whether the claim was sufficiently related to the claims that were asserted in the first proceeding. To demonstrate that a claim should have been previously asserted, a party must show that the prior and current claims involve the same transaction or connected series of transactions. The same evidence is needed to support both claims. So again, that's what I was saying, the fact that the arbitration is never mentioned in the warrant agreement. These two issues or concerns cannot be intertwined. And I want to go ahead and bring up some of these other footnote sections. So footnote number 6, during the conference, GEM's counsel asserted that the venue provision in the warrant is not applicable to GEM, but rather only applicable to any subsequent transferee or holder of the warrant. Section 8 of the warrant, however, defines holders to mean the persons who shall from time to time own the warrant. GEM unquestionably owns the warrant and is therefore bound by the warrant's venue provision. So there you go. They have to have this New York venue, section 7 or footnote 7. The parties thus consented to exclusive jurisdiction in this court and irrevocably waived any objection thereto as it relates to the warrant. As such, had plaintiffs contested the validity of the warrant during the arbitration, as they do here in the securities action, they would have been in breach of the clear language in section 11 of the warrant. To the extent that the court finds section 11 of the warrant inconsistent with the arbitration provision in the SPA, it is well settled in New York that any ambiguity subject to confusion should be construed against the drafter, which in this case was counsel for the defendants. And they give you an example of that. So going into the first full paragraph, here plaintiffs' claims under the Exchange Act are broader in scope and unrelated to the time, space, or origin of the claims raised in the arbitration. The claims presented in the arbitration pertain to the SPA, which is Security Purchase Agreement, and the RRA, Registration Rights Agreement, and are substantively and chronologically bound to the plaintiff's alleged breaches of those arguments. Conversely, the claims arising under the Exchange Act involve GEM's conduct with unrelated third-party issuers before, during, and after the subject transaction. Going on to the section, plaintiffs' claims under the Exchange Act therefore greatly expand the facts that would have to be considered in the arbitration to determine whether plaintiffs breached the SPA and RRA, and would not so obviously have to be litigated simultaneously that one would expect both sets of claims would be necessarily be brought together. While there is overlap between some facts demonstrating GEM's conduct as an unregistered securities dealer and its securities transactions with plaintiffs, the operative nucleus of facts in the arbitration arises from the SPA and RRA, not the warrant, which underlies the claims brought by plaintiffs under the Exchange Act. Even if plaintiffs, arguendo, could have raised the Exchange Act claims as counterclaims in the arbitration, permissive counterclaims in prior arbitrations conducted in New York are not precluded from being asserted in a subsequent litigation under res judica. And neither New York law nor the AAA rules provide for compulsory counterclaims. Granted, A party is not free to remain silent in an action in which he is the defendant and then bring a second action seeking relief inconsistent with the judgment in the first action by asserting what is simply a new legal theory. So basically, I read that quote from this specific legal case because it's important to note that you can't bring up one fact and seek relief and then have an inconsistent issue with a second one. So going on here, however, plaintiffs are simply bringing a claim pertaining to GM's business conduct that extends beyond the limited transactional nucleus giving rise to arbitration. Additionally, the securities action cannot be characterized as a second suit on the basis of pre-existing claim for relief that would impair the rights or interests established in the first action. Because the claim for relief in the arbitration is for breach-related remedies under the SPA and RRA, whereas the requested relief in the securities action is the statutory remedy of rescission under Section 29B. Finally, as an unconfirmed award, the liability is not a final judgment on the merits. Whether the prior decision was a final judgment on the merits, accordingly, it remains unclear whether any rights or interests have in fact been established. All right, folks, we're about halfway through. I know some of this legal jargon can be quite a bit dry. Some of it is hard to understand. I myself do not fully understand everything, but I'm just giving you my opinion as I read it. Section 2, the plaintiff's claims and the securities action are not barred by collateral estoppel. So I'm going to go ahead and explain what collateral estoppel is and all the criteria that you have to meet in order to be considered, not barred. And then we'll talk about exactly why Mullen's attorneys state that this does not apply. So collateral estoppel is permissible if, number one, the identical issue was raised in a previous proceeding. Number two, the issue was actually litigated and decided in the previous proceeding. Number three, the party had a full and fair opportunity to litigate the issue. Number four, the resolution of the issue was necessary to support a valid and final judgment on the merits. And they give a couple case study examples. It says in addition to these four factors, the court must also assure itself that the application of collateral estoppel is fair. And then they go on a little bit further, another case study, and they quote, a party seeking to obtain summary judgment on collateral estoppel grounds based on an arbitrator's award must make a showing so strong that no fair-minded jury could fail to find that the arbitrator necessarily denied the claim for the reason they assert. The very last sentence for this section. For the reasons discussed below, defendants do not meet this burden. So now we're going to go ahead and discuss why this specific case does not meet this plaintiff, or does not meet what the plaintiff is saying, which means that this case cannot be barred by collateral estoppel. The issue of whether the warrant was made in violation of Section 15A of the Exchange Act was not raised in the arbitration. So that actually counters number one of this collateral estoppel, which says that the identical issue was raised in a previous proceeding. So they're stating right here that the warrant made in violation of the Security Exchange Act was not raised during the arbitration. With respect to the first element of collateral estoppel, an issue is raised when it is presented to the arbitrators and specified in the party's first communication to the arbitrators. They give a case study example. Collateral estoppel should not be invoked to preclude a district court action, whereas here a party asserts a Section 29B claim for rescission under Exchange Act, which itself is predicated on a violation of Section 15 of the Securities Act, and that identical claim is not presented during the arbitration proceedings. They give a case study. I'm going to go ahead and jump down to noting that the plaintiff's rescission claim may not have been necessarily been artfully pleaded. This Bulgoski, I said that wrong, court nonetheless found that the assertion of the claim was not precluded by the arbitration proceeding and left open the question thus presented whether plaintiff is entitled to rescission of his customer agreement with SRSI because SRI failed to register as a securities broker. The reason why I went ahead and read through that case is because this is what we are dealing with. GM and their manager, their fund manager, this Mr. Brown, is not registered as a security broker. The Second Circuit's reasoning in this same case should apply with equal force to the case at bar. Here too, plaintiffs assert a claim for rescission under Section 29B of the Exchange Act, which is predicated on a violation of Section 15A of the Exchange Act and was not raised in the arbitration. While defendants contend that plaintiffs raised the same argument in the arbitration, they cannot point to a single reference to Section 15A of the Exchange Act in the arbitration. So they're claiming they talked about it, but yet they didn't mention a single time about Section 15 Exchange Act, which is the, if you want to call it, the crucible of Mullen Automotive's attorney's defense here. And again, they actually show that very vague statement, and then it says a violation of Section 15A was never raised. Going ahead a little bit further, Section 29B is not a standalone claim that can be raised without asserting a predicate violation of the Exchange Act. Rather, Section 29B is a statutory vehicle through which an aggrieved party can rescind a contract made in violation of any provision of the Exchange Act or any contract where performance involves a violation of the Exchange Act. Number two. Number one, this is if a person can avoid a contract under this section, they have to show, number one, the contract involved is a prohibited transaction. Number two, he is in contractual privity with the defendant. Number three, he is in the class of persons the act was designed to protect. Stated differently, because that was a little bit hard to understand, the issue of whether the warrant was made in violation of Section 15A of the Exchange Act is separate and distinct from, it's redacted, accordingly, defendants cannot demonstrate that the identical issue was raised in the previous proceeding. So there's a lot of discussion there, a lot of these different case studies, a lot of this backing is just to help strengthen the argument here. So going to Section II, the issue of whether the warrant was made in violation of Section 15A of the Exchange Act was not actually litigated and decided in the arbitration. So again, this is the number two for being part of this estoppel. Even if the court were to determine that the identical issue of whether the warrant was made in violation of Section 15A of the Exchange Act was actually raised in the arbitration, it was not. Defendants would still need to demonstrate that it was actually litigated and decided. Courts find that issues were actually litigated and decided in a previous arbitration where the arbitrator properly considered and resolved those issues. And they give a case study. Here, the arbitrator's commentary in footnote 14 of the liability award cannot be reasonably interpreted as a final decision on the merits of plaintiff's claims under the Exchange Act as an initial matter. And they go ahead and probably list the footnote 14. It's redacted. Going on, if nothing else, this statement establishes that the issue of whether the warrant was made in violation of Section 15A of the Exchange Act, even if the court were to consider it as encompassing the blank, was certainly not litigated in the arbitration. So whatever that statement was saying, again, Mullen's defense is saying that it was not litigated in the arbitration. Going a little bit deeper, just to kind of drive home Section 2. Furthermore, the arbitrator's statement that blank, don't know what it says, is not the same as actually deciding on the merits whether the warrant was made in violation of Section 15A because GEM is an unregistered securities dealer. Such a finding would have required the arbitrator to actually consider whether GEM is a securities dealer within the meaning of the Securities Exchange Act, whether GEM is registered as a dealer with the SEC or any other regulatory body, and whether the warrant was thus made in violation of Section 15A. By conducting a thorough analysis of the relevant statutes, interpreting the controlling case law, and applying the facts before him to actually decide the issue, the arbitrator actually decided issues in the final award by thoroughly considering and determining the elements of the claim at issue in the second litigation. So they gave a case study that said basically in order to come up with a final award, you have to consider all the elements, which in this case would include the Security Exchange Act issue, which is that GM is not a dealer. So if the arbitrator was actually aware of this circumstance of the Exchange Act, they would have had to have taken this under consideration and would not have been able to weigh the decision that was put out there in terms of the interim award. There is nothing in the record that demonstrates that the arbitrator made any such finding. So again, that just drives home the point that the arbitrator was not aware and did not review the Security Exchange Act concern about GM and Mr. Brown not being a registered dealer. Section 3. Again, we're still talking about the estoppel. Plaintiffs did not have a full and fair opportunity to litigate the 15A issue in the arbitration, nor was resolution of that issue necessary to support the liability award in the arbitration. Courts in the Second Circuit generally consider 4 factors in determining whether a party had a full and fair opportunity to litigate an issue for the purposes of applying collateral estoppel: the nature of the forum and the importance of the claim in prior litigation, the incentive and initiative to litigate and the actual extent of the litigation, the competence and expertise of counsel, the availability of new evidence, the differences in the applicable law, and the foreseeability of future litigation. At least 2 of those factors weigh in favor of the plaintiffs, as the Exchange Act's claims asserted in the securities action do not address the SPA, Security Purchase Agreement, and the RRA, the Registration Rights Agreement, related claims in the arbitration, nor were they litigated to any extent in the arbitration proceedings below. Courts have also adopted the restatement of the judgment full and fair factors, which disfavor giving preclusive effect to the prior proceedings when treating the issue as conclusively determined would be incompatible with the applicable scheme of administering the remedies in the actions involved. All right, a little bit more background. The Supreme Court has held that arbitral awards should not be given preclusive effect when, number 1, Congress intended the statute at issue to be judicially enforceable, and number 2, arbitration could not provide an adequate substitute for judicial proceedings in adjudicating claims under that statute. They give an example or case study. Indeed, the Exchange Act vests exclusive jurisdiction in the federal courts over suits brought under its auspices. Finally, the proponent of collateral estoppel has the burden to make a showing and must clearly establish that an issue was necessarily decided. Again, they give a case study. An issue that is necessarily decided must have been both actually decided and necessary to support a valid and final judgment of merits. Here, plaintiffs' claims and/or defenses under the Exchange Act were never raised or pursued in the arbitration. So again, they're not clearly establishing the issue that needs to be decided, which would be the Securities Act agreement and the issues of them not being a registered dealer. As such, resolution of plaintiffs' defenses and claims under the Exchange Act could not possibly have been necessary to support the arbitrator's findings on liability. Section B. This is a separate claim. This court should stay GEM's application and any damages determination by the arbitrator pending resolution of the securities action. As discussed in the previous memo, if the warrant was indeed made in violation of Section 15A of the Exchange Act, it shall be void and subject to rescission. Such a finding would in turn render the interim award moot, as the $24,114,921 that MAI, Mullen Automotive Inc. was ordered to deposit into escrow was based on the minimum value of the warrant sought by GEM for breaches of the SPA and RRA. If the warrant is in fact void, then the amount would necessarily be reduced to 0. The issues presented in the securities action must therefore be resolved before the court can fully adjudicate GEM's application. Likewise, any pending arbitration proceedings pertaining to final damages must also be stayed in the interest of judicial economy and efficiency. So again, what Mullen's attorneys are saying, pump the brakes, stay this interim award. The securities act concern that Mullen's attorneys are bringing up is so important. This warrant section that was not mentioned in the arbitration is so important. It can zero out what these warrants would be worth if in fact they are illegal to be issued because they're not registered dealers. Then there's no award for the SPA and the RRA because the warrants are zero. And then before any kind of final award could be provided, basically if just to cover the basis that they continue with the interim award and then want to kind of round out and finish arbitration, it should not be done until this concern over the warrant and the Securities Act is finished. So the power to stay proceedings is incidental to the power inherent in every court to control the disposition of the causes on its docket with economy of time and effort for itself, for counsel, and for litigants. So that was pretty important. Just to kind of state that is support for Mullen's attorney's claims that they should stay the interim award and basically finish out this Security Exchange Act concern in terms of the warrant contract. Want to go ahead and get into the next section. It starts with courts, and we're going to go ahead and get to the next slide so we can read the rest. All right, folks, thanks for sticking around. We are almost done. Just a couple slides left. Picking up where we left off, courts typically consider 5 factors in deciding whether to grant a stay. So this is actually really important. This is actually helping confirm what the judge should do in terms of stay versus letting the arbitrator and the arbitration and this interim award continue on. So the private interests of the plaintiffs in proceeding expeditiously with the civil litigation as balanced against the prejudice to plaintiffs if delayed. So basically, if they kind of continue on, they don't stay, how does that weigh against how is that prejudice to if they go ahead and delay it? So obviously it's going to hurt the plaintiff if they don't delay it, if they don't stay it. So it is in the plaintiff's best interest for it to get stayed. The second section is the private interest of and burden on the defendants. So again, the defendants haven't paid Mullen any form of money at all. So they're not in any kind of like hurting financial type situation. Number 3, the interest of the courts. Again, if we're talking about how this warrant document and the Security Exchange Act will basically, if judged and ruled in favor of Mullen and their attorneys, it will nullify this SPA and RRA, then you're wasting the court's time if you continue on and proceed through arbitration. Number 4, the interests of persons not parties to the civil litigation. And number 5, the public interests. Courts in this district have routinely stayed an action pending the resolution of an independent proceeding, whereas here, the resolution or outcome of that proceeding bears upon the action. And they give an example of that, a staying case where resolution of a related class action would impact the plaintiff's claims in the case and defendant's contractual right to demand arbitration of the claims. So in that case, they basically talk about the 2 situations that I kind of slowed down and went through, which would be number 1 and number 2. The aforementioned factors indisputably favor staying GEM's application and any damages determination by the arbitrator pending resolution of the securities action, as Mullen Automotive Inc. would suffer irreparable harm in the absence of a stay, as explained in the previous memo, if MAI is forced to preserve $24 million in escrow. So again, they're showing how this would actually hurt the plaintiff, which is part of Section 1, and they actually give a little bit better explanation. I don't know if that's their financials that they're talking about, but they have to be able to show the judge how not granting a stay would be prejudice to the plaintiffs. And then a stay, however, would serve the interest of this court by promoting judicial economy and efficiency. Again, this was the Section 3 that I kind of touched on a little bit further, and avoiding potentially inconsistent adjudications. There is also nothing on the face of the interim award or GEM's application for the matter to suggest that the fourth and fifth factors articulated above weigh against a stay. As such, GEM's application and any pending arbitration proceedings to address the damages should be stayed pending the resolution of the securities action. So that's a final statement after all of the pertinent information was supplied. All right, last two slides. Section 3, Claim 3, there is no authority that stands for the proposition that a federal court possesses the authority to order the type of relief entered by the arbitrator in the interim award. Although the court may confirm, deny, confirmation, or vacate the interim award under the procedures set forth in the FAA and New York Convention, there is simply no authority to suggest that a federal court possesses the power to provide the sort of relief entered by the arbitrator in the interim award and other MAI to transfer money directly into an escrow account. To be sure, federal district courts possesses the authority to issue provisional measures, including measures in the aid of arbitration. Under Rule 64 of the Federal Courts of Civil Procedure, for instance, a court may impose every remedy that under the law of the state where the court is located provides for seizing a person or property to secure satisfaction of the potential judgment, including arrest, attachment, garnishment, replevin, whatever that means, sequestrian, and other corresponding or equivalent remedies. Again, go ahead and look up some of those terms if you're not aware of them. New York law, in turn, provides that the court may entertain an application for an order of attachment or for a preliminary injunction in connection with an arbitration that is pending or that is to be commenced inside or outside New York, whether or not it is subject to the New York Convention, but only upon the ground that the award to which the applicant may be entitled may be rendered ineffectual without such provisional relief. Under New York law, a writ of attachment is the appropriate remedy for securing a judgment with property that is not subject of the action. And they give a case study. However, the remedy differs in material ways from the AAA Rule R37 and does not provide the court with the authority to order MAI to place funds directly in escrow. So basically, the court does not have the authority to do so. As an initial matter, whether an order of attachment is requested or on notice or ex parte, it must be sought by motion or application for that specific form of relief before a court can order such remedy. Even if GEM had moved for an order of attachment, and it hasn't, the court would still lack the authority to order MAI to transfer money into escrow. Courts have generally only entered orders of attachment in aid of arbitration where the evidence shows that the party has begun to dissipate, move, or otherwise encumber assets, even in circumstances where a defendant finds itself in a precarious financial condition. Let's go ahead into the next section there, as the attorneys are going to show that Mullen is not in this situation. Attachment in aid of arbitration where the respondent was no longer actively functioning. There was some indication that the respondent had engaged in liquidating and transferring assets, and there was a high probability that the respondent would be unable to meet any debts determined by the arbitrator to be owed to the petitioner. They give the case study for that specific issue. Granting attachment where the evidence demonstrated that the individual respondent had stripped the corporate respondents of its assets, historically failed to pay its creditors, and stated to others that he intends to remove his assets from New York and does not intend to satisfy the award. So again, in this specific case, that is what happened. But according to Mullen's attorneys, there have been no such findings here. Moving on to the next paragraph. In addition, under New York law, a party seeking attachment, including one in aid of arbitration, must post a bond. Further, the property that is subject to the writ must be located in New York. In addition, any order of attachment is directed to the sheriff of the county where the property is located, and the property remains within the actual or constructive possessions of the sheriff. And they talk a little bit about how that specific law or that ordinance is laid out. none of these aforementioned requirements are found in the AAA Rule R37. In short, a federal court does not have the authority to enter an order akin to the interim award. So there's a whole lot of background, and just to help strengthen that last statement, which is that a federal court does not have the authority to enter an order akin to the interim award. And then finally, the conclusion. For the foregoing reasons, plaintiffs respectfully request that GEM's application to confirm the interim award and any damages determinations in the arbitration by stayed pending this court's resolution of the securities action. Additionally, plaintiffs respectfully request that the court refuse to enforce the interim award at this time. So they want to get it stayed, and they want the court to actually place the judgment to say that it cannot be enforced. So that would actually give them some backing to go back to the arbitrator and say, we took this to court, the judge has agreed that this interim award should not be enforced. And again, I wanted to give credit to the attorneys that wrote this memorandum. All right, and that wraps it up, folks. I just wanted to point out that I am not a legal expert. This is just my opinion and my interpretation of this legal document, this memorandum. Again, I am just a shareholder of Mullen. I do not work for Mullen. I do not work for any of these law firms. If you did like this video, please consider liking, subscribing to the channel. Leave me a comment below with any information that you'd like to hear more about. Whether it be this specific case or it be some additional content that you'd be interested in. I'd love to hear from you. And with that said, I hope you have a great rest of the day, and I'll see you on the next one. Well, hello and welcome to another video by Financial Learning. On today's video, I'm going to break down one of Mullen's latest PRs. This one has to do with a new shareholders' rights agreement. There's been a lot of questions, uncertainty around everything involved. I did do some digging. I read through it a couple times, and I'd like to just share with you all my understanding. So let's go ahead and get right into it. All right. So let's go ahead and get right into Mullen's PR, and then we'll break out into Mullen's 8K filing, as well as some of their exhibits to kind of really explain some of the details behind this PR. So start from the top. Mullen announces adoption of limited duration stockholder rights plan. So we do know based off of this and the filings that this is a 1 year from May 1st, 2024 through May 1st, 2025. So let's go ahead and talk a little bit about what it includes. If you read the bold section, this rights agreement is not a financing transaction, and no additional shares of common stock or preferred stock or warrants or convertible notes are currently being issued in connection with a rights agreement. So we'll talk a little bit about some of these new A1 series preferred, these junior preferred shares that have been added in, but none of those have been issued. So there's no current dilution going on in terms of new shares being added due to any of these things listed here. Preferred stock, warrants, convertible notes, or anything of that nature. So no SPA or anything like that. So again, this rights agreement is intended to promote the fair and equal treatment of all stockholders, and is similar to rights plans adopted by other publicly held companies. So going down in here, the board unanimously adopted this specific rights plan. And it's actually intended to help stockholders realize long-term value with their investment, and it's intended to protect Mullen and its stockholders from efforts by a single stockholder or group that would like to obtain control of the company without paying a control premium. So this doesn't stop a certain person or company from gaining control, but they would have to pay Mullen Automotive a significant amount of money. I don't believe that that amount of money has been disclosed, but that is written in here as a way to protect the shareholders, protect Mullen and the board, so that no one can come in here and basically perform a hostile takeover. There would be a significant premium that Mullen Automotive, the shareholders, and the board would all receive before any individual or group obtain controlling interest. So let's go ahead and read a little bit more about that interest. What we know that the rights agreement works by imposing a significant penalty upon any person or groups that acquires a beneficial ownership of 10% or more of shares of common stock without first getting prior approval of the board. And this rights plan is effective immediately and will expire on May 1st, 2025. Additional information was provided in an SEC filing, so let's go ahead and hop right into that. All right, so this is the 8K that was filed a little bit after that PR came out by Mullen. So the first section is different, and then once you start to get into the bold section, that was actually shared as part of the PR, so I'm not going to really go over that. But I will start at the top of this entry into a material definitive agreement. It says on May 1st, 2024, the board of directors of Mullen Automotive declared a dividend distribution of one right, and then a right is in parentheses, for each outstanding share of common stock per value 0.001 per share of the company common stock, and preferred stock, again, par value 0.001 per share of the company's preferred stock. The dividend is payable to holders of record as of the close of business on May 13th, 2024. That is the record date. In connection with the distribution rights, the company entered into a rights agreement between the company and Continental Stock Transfer and Trust Company as their rights agent. And then this other section, I'm not going to read through the rest. This is part of the PR I already mentioned on the previous slide. Let's go ahead and get into some more of the details. We're going to look at some of the additional exhibits. So before we get into the exhibits, just wanted to go a little bit further down into the 8K. We're talking about the issuance of rights. Each holder of a common stock and preferred stock as of that record date of May 13th, 2024, would receive a dividend of one right per share of common stock and preferred stock as applicable. It says one right will also be issued together with each share of common stock and each share of preferred stock, the terms of which provide for holders thereof to be issued rights issued by the company after the record date and prior to the distribution date, as defined below, and in certain circumstances after the distribution date. New certificates for common stock and preferred stock issued after the record date will contain a notation incorporating the rights agreement by reference. So again, a couple of things here has to do with the record date, but then there's also a distribution date. So let's see if they talk a little bit about that as we keep going through. So the rights will not be exercisable until this distribution date. The rights will be evidenced by the certificates for common stock and preferred stock, and the rights will be transferable by and only in connection with the transfer of common stock and preferred stock. So the only way to get these rights is to actually own the common stock or the preferred stock. And then in terms of the distribution date and the beneficial ownership, the rights are not exercisable until this distribution date. As of and after the distribution date, the rights will separate from the common stock and preferred stock, and each right will become exercisable to purchase 1/10,000th of a share of Series A1 Junior participating preferred stock. Par value again at 0.001 per share at a purchase price of $30. So for $30, you can purchase 1/10,000th of an A1 preferred stock. So if you had $300,000, you could purchase one of these A1 preferred stocks. And this portion of an A1 preferred stock would give the holder, therefore, approximately the same dividend, voting, and liquidation rights as would one share of common stock. Prior to exercise, the right does not give the holder any of the dividends, voting, or liquidation rights. So let's go ahead and talk a little bit about this distribution date. So 10 days following a public announcement that a person becomes an acquiring person. So again, acquiring person is someone who obtains 10% beneficial ownership of the company by purchasing 10% of the common stock. That would actually trigger this distribution date, and that would occur 10 days after the announcement. One type of situation or scenario that would not be included in this distribution date would be if the company decides to repurchase common stock, and then that actually pushes someone that may be a 9.5% owner into a 10% ownership because of the common shares being reduced. That would not trigger a distribution date. The second item, and again, this distribution date is the earlier of the two, the second item would be after a tender offer or exchange of offer on behalf of any person that if which they received it would become an acquiring person. So again, if there was an SPA involved and a specific group or person due to the SPA receives 10% or more shares of the common stock, then that would again trigger a distribution date. So just want to kind of bring up the two scenarios in which a distribution date would occur. Again, we already talked about the expiration of rights. So this is good from May 1st, 24 to May 1st, 25, and the record date is May 13th, 24. So the two types of triggering events that would happen after this distribution date would be a flip-in event and a flip-over event. So the flip-in event would again be if this acquiring person obtains 10% ownership of common stock. What is really nice is that everyone else except for the acquiring person, so anyone that has this right, which anyone on record date of May 13th is going to have, they are going to have a value equal to 2 times the purchase price of the common stock. So in essence, everyone's going to get double the amount of shares that they're holding as of that record date. So that's actually pretty exciting, meaning you can basically double your share count depending on what you have in the event that one of these individuals obtains 10% ownership. And at the same time, because of that situation, this person would actually only end up with 5% of the common share count of that time. So they would no longer have a 10% controlling interest. They would be down to 5%. The second situation, which would be a flip over event. This has to do with a merger. So if the company mergers with another company and the common shares of Mullen Automotive were to change over to the other company, or vice versa, whichever company is the surviving company in terms of common shares. One thing to note is that people that have this right, shareholders that have this specific right, they will have the right to receive upon exercise of their common share value 2 times purchase price. So whatever the purchase price for their shares would be, if the shares were going to be basically purchased at market due to a type of merger, each shareholder that has this right is going to actually get 2 times the value. So these are 2 really good examples of how Mullen Automotive is looking out for the shareholders in the event that there is any beneficial owner. Again, every shareholder is going to be receiving double their amount of shares. And then in a flip over event, in the event that the shares are going to be getting sold, each shareholder is going to get twice the value of whatever the price is. So again, all that has to be taken into account whenever this new person or group would be interested in basically buying out and creating a merger with Mullen Automotive. So there are a couple of other scenarios at which this shareholder right could actually change. And this was written in, this is one of the clauses, this is a redemption clause. So at any time prior to a person becoming an acquiring person or the expiration date, meaning May 1st, 2025, the board may direct the company to redeem the rights in whole, but not in part, which means they would have to basically take away these rights for all the shareholders of record. And they would do this at a price of 0.001 per right. So it'd be a very small amount of money or a small amount of shares that would get added to each shareholder in the event that the company decided to perform a redemption. And again, this would terminate all of the shareholder rights agreement except for this 0.001 redemption price. So this is just one of the additional lines that Mullen has in this rights agreement, which would basically just nullify the entire thing, but it would pay out shareholders of record at least this fraction amount of price. A couple other things to mention is they talk a little bit about the tax considerations. I don't want to go too much involved with that. If you are interested, you can definitely check that out. And then they talk a little bit about some of the other amendment of the article. So they went ahead and added this rights agreement as well as the Series A1 Junior Participating Preferred Stock into their bylaws. So it's another thing that got added into here, and this 8K kind of notified about that. And then you'll see the two exhibits down there, 3.1 and 4.1. We're going to jump into those. I'm not going to go over everything. I'm just going to kind of breeze through and go over a couple of the high notes. So starting with exhibit 3.1, you can see up on the upper right, this is the certificate of designation of preferences and rights of Series A1 Junior Participating Preferred Stock. So this is a new type of preferred stock offering that Mullen Automotive is now going to be offering shareholders. It is going to be starting out at 50,000 shares. And then it does have a designation amount. It says there in that clause that Mullen can add additional shares to this specific type of preferred stock, but they cannot decrease the number of shares. So there'll be a minimum of 50,000 available. I guess depending on how much interest people have, Mullen could definitely increase this in order to continue to provide this opportunity for shareholders. All right, and what you get with this preferred stock, they talk a little bit about the dividends and the distributions. So you can see the subject to the rights of the holders of this series preferred stock, you do receive quarterly dividend payments equal to or greater than, depending on which of the two, you're either going to get $30 for each of those Series A1 Junior Preferred Stock, or you're going to get 10,000 times the aggregate per share amount of cash dividends, or a subdivision of outstanding shares of common stock. So that's pretty interesting. So if Mullen ends up announcing a specific dividend to all shareholders of common stock, anyone who has this junior preferred stock is going to get 10,000 times the amount. So that's pretty incredible. It's pretty awesome. We're going to talk a little bit about exactly how much it costs to purchase one of these, and how many of these purchases would it take to have a whole preferred share, because they do allow you to own a fraction of this preferred share. And then you'll see some other sections. I did not go through all these other sections. Has to do with the voting rights for anyone who owns this type of preferred share. Certain restrictions, reacquired shares, liquidation, dissolution, or winding up, consolidation, a merger, etc. Talk about a no redemption clause, certain ranking, how does it rank up against the other preferred shares, and then of course common shares. If there's any type of amendments, there's a clause for that section, and then they talk again about some fractional shares. So there's been a lot of discussions in terms of what exactly this right is. I did read through the exhibits, and I believe I have an understanding. If you do not agree, please leave a comment. Let me know what you think this is actually dealing with. But I will share from the actual filing itself what it says it means. So again, this is talking about the May 1st, the rights dividend declaration date. This has to do, again, with this shareholder rights agreement. You can see this on the left-hand side right above where I am filming. It says the rights agreement between Mullen Automotive, Inc. and the Continental Stock Transfer and Trust Company. So they are the ones they are the agents for this specific right. So what is this right and who gets it? So this is declared as a dividend distribution. Again, this is of one right for a common right, and then they also mention this is one right for a preferred right. And the record date at which you have to be holding your shares is May 13th, 2024. And then it talks a little bit about each one between the common and the preferred. And the last sentence is something that I want to read. I'll start at the part that's underlined there, section 22. The earlier of the distribution date and expiration date, each right initially representing, here it is, the right to purchase a share of preferred stock or a fraction thereof, as applicable upon the terms and subject to the conditions hereinafter set forth. So this right that each shareholder of record on May 13th is going to have the ability to purchase one of these A1 junior preferred shares. So it goes into a little bit more detail in the rights certificate. You can see that for a purchase price of $30, you can get 1/10,000th of a share of preferred stock. So this, again, this has to do with this Series A1 Junior Participating Preferred Stock. It's listed there in this rights certificate clause. And then it does talk a little bit about the flip-in event and how those would have the same type of protection that was mentioned in the prior filing in terms of basically getting two. So I think this is pretty exciting. This does allow the shareholders to have an opportunity to actually get a preferred share or a fraction of a preferred share, which again would have the opportunity to get quarterly dividends in the future. So again, that $30 quarterly dividend would be for a single share of this A1 junior preferred stock. So if you think about it, for $30, it's 1/10,000th. So for $300,000, that would be the cost. That would be what it would take to obtain one share. But again, you don't have to have one share to get the dividend. You will just get a fraction of that dividend. Or if the company decides to provide dividends to the shareholders of common stock, again, you would get, if you have one share of the A1 junior preferred, you would get 10,000 times that dividend payout or distribution. So it's a pretty good thing. I think it's really cool that Mullen is providing some of these additional preferred shares. Again, as they start to grow the company, as we start to see them becoming profitable and getting more revenue on the books, and really scaling up production so that their profit can actually outweigh their cost of operations. The company is going to continue to grow, and it's awesome to think that as an initial shareholder, you have the opportunity to get yourself some preferred shares as well. And again, you have until May 1st, 2025 to make the decision if you'd like to purchase these preferred shares. Again, there's 50,000 of these preferred shares for these A1 junior preferred shares. And Mullen and the board, they have the opportunity to increase the number of these types of preferred shares, depending, I guess, at their discretion. Well, that wraps up for me, folks. I hope you enjoyed this video. Hopefully it wasn't too confusing. There is a lot more in those filings. I would definitely suggest that you go ahead onto the SEC website and pull them up and really read through them all. I just kind of took what I thought were the high-level notes and tried to do my best to explain it. Hopefully I didn't confuse you more. If you did like this video, please consider giving it a like. Please subscribe if you haven't already. And again, leave me a comment. Let me know what you thought about my explanation of this rights agreement. Let me know of any other future content you'd like to see or hear about. And again, I am not a paid representative. I don't work for Mullen. I receive no commission of any type, no compensation. I am just a mere investor who is extremely bullish about Mullen Automotive and what they have going forward in their operation side of things. And with that said, I hope you all have a great rest of your day, and I'll see you on the next one. Well, hello, and welcome to another episode by Financial Ernie. On today's episode, we're going to give a GEM update. We're going to be talking about both the arbitration as well as the lawsuit update. So without further ado, let's get right into it. All right, so this first update, it's actually a little bit ago. It was back on May 6, 2024. you'll see that there was a memorandum of law in opposition to the petitioner's motion of summary judgment and in the support of the respondents' cross motion for summary judgment. And this was submitted by Mullen Technologies and Mullen Automotive's attorneys. We're going to go ahead and break this down a little bit, and then we're going to talk about some latest updates and developments in both the arbitration as well as in that lawsuit. So getting right into it, first thing I want to talk about is the green boxes. Throughout the filings, I'm going to go ahead and highlight the important information in my opinion, and I'm going to do that using these green boxes. If you feel like reading the majority of what I have here, please feel free to pause the video. If you'd like to download the full documents, many of these filings are available for free on the court listeners website. So just wanted to go ahead and provide that information to you up front. So getting into it, as I mentioned on the first slide, this is a memorandum of law in opposition to petitioner's motion for summary judgment and in support of respondents' cross motion for summary judgment. As far as the preliminary statement by the respondents, who is going to be Mullen Automotive, it says, respondents seek to vacate an interim measures order entered by an arbitrator in a AAA arbitration between petitioners and respondents. That requires MAI, Mullen Automotive Inc., to escrow over $24 million. You will see throughout these filings that there's quite a few items that have been redacted. That has to do with information that's not privy to the public. It has a little bit to do with the company's overall financial situation at the time of filing. Let's go ahead and read a little bit further. Down at the bottom there is, however, no authority under the applicable AAA rules for this type of relief. Those rules grant an arbitrator the authority to take whatever interim measures he or she deems necessary for the protection or conservation of property and disposition of perishable goods prior to issuance of a final award. So again, it is important to show that that is part of what Mullen Automotive will be dissecting, their attorneys will be dissecting throughout this filing. So jumping straight into that green boxed area, you're going to see that for this motion papers, petitioners do not dispute that an arbitrator lacks the authority to impose interim relief. So that's important that that is going to be one of the things that Mullen's attorneys bring up throughout this filing. And looking down at the bottom there, it says, and they're talking about the arbitrator here, it says, amongst other things, even if the arbitrator possessed broad discretion to fashion an interim remedy, he was nevertheless required under the AAA rules to analyze MIA's financial condition before the close of the arbitration and conclude that the interim measures were necessary before the issuance of a final award. So again, keep that in mind as we go throughout all of this. This is something that is basically going to preview, and we're going to be talking about this throughout this arbitration case as well as going into the judgment case or the legal case that is also open with Mullen Automotive and GEM. So on January 4th, 2021, and again, this is a preview, kind of just giving a little bit of the background of this specific arbitration. Petitioners GEM Yield Bahamas Limited and GEM Global Yield LLC together executed 3 integrated equity financing agreements with MTI, Mullen Technologies Inc., a share purchase agreement, a registration rights agreement, and a warrant. Collectively, they're calling these 3 items the GEM agreements. Under the SPA and the RRA, again, registration rights agreement, the parties agreed to resolve any disputes arising out of those agreements through arbitration in New York under the rules of the AAA. And further, the agreements would be constructed in accordance with the New York law. Again, if you notice that only 2 of those 3 items have listing in them in terms of arbitration, which means that the warrant documentation does not have anything involving the arbitration, but instead that actually can be sought out in the court of law. So moving on to the second box area, I have several weeks later, and this is important to note as well, GM filed an amended statement of claim adding Mullen Automotive Inc. as a respondent to the arbitration. On August 3rd, 2023, the arbitrator granted GEM's first application for interim relief. The reason why I boxed this is it's important to know that GEM originally was only going through arbitration with Mullen Technologies Inc. And if you recall, Mullen Automotive Inc. and Mullen Technologies Inc. had a transition service agreement, and those 2 companies are completely severed from one another. So I think it's interesting that Mullen's attorneys are bringing up the fact that GEM originally only had Mullen Technologies Inc. listed on their documentation in the arbitration. All right, we talked about this during the preliminary statements, but Mullen is going to go ahead and lay it out very clearly on why this is an important part of the arbitration argument. And again, this is for the arbitrator to review and decide if he or she feels that their judgment of this case in terms of arbitration is valid. And then this same information will be brought into the court in terms of Mullen Automotive's lawsuit with GM. So just keep that in mind as well. So the order should be vacated because the arbitrator exceeded his powers under the AAA rules. So this is the main complaint that Mullen's attorneys are going after. And here's a couple of the examples of how he did such things. So example 1, this is section A. The order is not supported by a finding that serious injury was likely to occur prior to the issuance of a final award. Again, Mullen's attorneys are saying that there is no need to require an interim award. Instead, they should have just sought for that final arbitration award. Under the FAA, an arbitration award must be vacated where an arbitrator exceeded their powers or so imperfectly executed them at a mutual, final, and definite award upon the subject. So again, if they have exceeded their powers, you're supposed to vacate that arbitration award. The third box section, it says a court may vacate an arbitration award if the arbitrator acts outside of the scope of his contractually delegated authority and issues an award that simply reflects his own notions of economic justice rather than drawing its essence from the party's contract. So keep that in mind, and we'll go ahead and talk a little bit more about what has changed since these initial filings and why this interim award should not be met and should not be valid. So Rule 37A of the AAA rules provides that an arbitrator may take whatever interim measures he or she deems necessary, including injunctive relief and measures for the protection or conservation of property and disposition of perishable goods. In assessing GM's request for interim relief and analyzing the appropriate standard for interim measures according to this AAA rule, the arbitrator, and we don't know what it says there, but we do know that Mullen is going to provide a second reason on why the arbitrator is not really using their powers appropriately. And it has a little bit to do with the fact that they did not review all of Mullen Automotive's economic situation before really requiring that interim award. All right, and moving into this first box section here, you can see that it says that to issue the interim relief, he or she must take a realistic commercial view of the likelihood that serious damage will occur prior to the end of the arbitral proceedings. So again, the only reason why the arbitrator should provide an interim award is if there is a serious concern for the defendant or respondent not being able to honor the final award. Looking at the very bottom, this is just another way to say it, another way to phrase it. It says, put differently, a finding of urgency is a necessary condition for granting interim measures under the AAA powers provided to the arbitrator in the SPA and the RRA. So again, it has to be an urgent, it has to be the interim award must have a very high urgency. It must be weighted heavily in order for the arbitrator to be able to require such an award. And looking at when this arbitrator was supposed to provide their final award, it says in the order, however, the arbitrator, and this part's sealed, but it does say April 30th, 2024, the date by which the arbitrator has stated he will deliver a final award. And again, a little bit more of this is sealed. It says it looks like the arbitrator has made a decision that does not coincide with this April 30th, 2024 date because the arbitrator, and as such, the arbitrator exceeded his authority. So whatever this sealed section is, it's some information that's not privy to the public. Mullen is claiming that this arbitrator exceeded their authority by requiring this interim award so close to the final award date. All right, and as far as when that is appropriate, it says the interim measures are warranted only in limited circumstances. And here are a couple of them. To protect a future award in the face of urgent financial difficulties or because a company is dissipating assets or engaging in other financial maneuvering, that it will likely render a final award meaningless. In fact, the courts have generally only confirmed interim awards where the evidence shows that a party has begun to dissipate assets or finds itself in a precarious financial position, such that a final award will likely would be rendered meaningless in the absence of provisional relief. So again, if Mullen Automotive Inc. was selling off their assets, if they were acting in any way in which they were showing that they could not actually meet the final award, then that would give reason for this interim award. But again, it is up to the arbitrator to review Mullen Automotive's financial statements and their economic status to make that decision. If the arbitrator would have reviewed all of Mullen Automotive's assets, then that would have been more than enough to pay for the arbitration amount. Again, this is my opinion, but I have seen their earnings. I have seen their quarterly earnings reports, their 10Qs, their 10Ks, the annual reports, and they definitely have enough assets to be able to cover this circumstance. Not to mention that there is something else that's going to be coming up a little bit later in this video. So going to the second section, this is part of paragraph B. It says none of the petitioner's arguments compel a different conclusion. So in its memo, GEM does not dispute that an arbitrator lacks the authority to impose interim relief. So GEM is not in agreement with Mullen Automotive in terms of them lacking the authority to, basically require this interim relief. Going down to the second box section, the arbitrator was nevertheless required to analyze MIA, Mullen Automotive Inc.'s financial condition before the close of the arbitration and find, under Rule 37 and the legal framework, and we don't know what the rest is about, that interim measures were necessary before the issuance of a final award. So again, before the arbitrator issued the final award, they were supposed to review all of Mullen Automotive's economic situation and make sure that this interim award was still required. And this is something that Mullen's attorneys is saying never happened. All right, the next section, GM tried to argue that there's a certain urgency required to impose this interim award, but whether urgency is a requirement under the AAA rules or merely a factor, the arbitration to be considered, the fact remains that the arbitrator was obligated under Rule 37 to conclude that interim measures were necessary before the issuance of a final award in order to enter such relief. So again, the arbitrator was supposed to review Mullen's economic status and conclude that it is necessary for this interim award to happen. And we all know Mullen Automotive has not been selling off their facilities in Tunica or in Mishawaka. There's been no such things going on. So really looking at their inventory levels, looking at their overall asset column, they have more than enough, again, to be able to pay for whatever this final award was going to be. Going into section 4. So this is that the award was rendered in manifest disregard of the law. So again, Mullen's attorney is saying that this arbitrator was going against some of these AAA rules and they're not following the law, and that's why this specific case, this arbitration award amount, should be thrown out. So Mullen's attorneys at that top green box, this is another thing that they're arguing. It says, in short, the arbitrator imposes his own brand of justice in complete and utter disregard of the controlling of New York law. So I think that's important to note that Mullen's attorneys are saying that this arbitrator is not within their power of authority. They are doing things that are not within the bounds of New York law. So again, this is part of why Mullen's attorneys are saying that this interim award and this arbitration in general is not valid, and that this arbitrator is not being fair. So reading in this next section, it says, first, GM contends that the arbitrator could not have acted in manifest disregard of the law because under AAA rules, an arbitrator has broad remedial powers, limited only by the arbitrator's consideration of justice and equity. That contention, however, completely misunderstands the doctrine of manifest disregard of the law, even if, as GM suggests, arbitrators are afforded greater flexibility. So again, this is what GM was trying to state. Again, trying to keep it very broad. They don't want to actually look into the details of how this AAA rule is set up, because Mullen's attorneys are highlighting very well so, in my opinion, of how this arbitrator is not following those specific rules. So last section there, down the bottom, says, in other words, again, this is them paraphrasing with a little bit of this law, the arbitrator cannot ignore controlling law and dispense his own brand of industrial justice. So again, they got to follow the law. They can't just shoot from the hip and make up their own decision. There are laws, there are specific cases, there are specific rules that must be used in an arbitration. All right, thanks so much for sticking around. This is the first half of the video. We're about to get into some latest filings, actually just from this past week, but let's go ahead and conclude here. So again, this is GEM's second argument. They are asserting that the order should be confirmed because the arbitrator, we don't know what it says here, and that the respondents provide no evidence regarding the arbitrator's intent. Again, and then they discuss about the liability award. So they are just arguing Mullen's attorneys' arguments and what they are actually trying to say here. So they're not really providing a lot of, information, in my opinion, as to why these arguments would not stand. Again, reading into this other portion, which I thought it was pretty important. It talks about that there is the separate corporate identities of MAI and MTI should be disregarded. So again, Mullen Automotive and Mullen Technologies, Inc., they are separate companies that separation agreement, or this transition agreement, was completed and they have severed ties. So again, this is kind of what Mullen was talking about, how at the beginning of this specific arbitration case, only Mullen Technologies, Inc. was added into the filing. And then at a later date, Mullen Automotive, Inc. was put in. So again, it says, further, even if MAI and MTI are affiliated entities, GEM has provided no authority. We don't know what they're talking about here. Consequently, the arbitrator's finding, again, we don't know what that is both factually and legally baseless, and respondents' cross motion seeking vacatur of the order should be granted. So again, Mullen Automotive's attorneys are putting it all out there on the line, and they're basically calling it as it is in terms of this arbitrator, and that they are both factually and legally baseless. So it's pretty bold words in terms of the attorneys here. And in conclusion, again, this is the memorandum that Mullen's attorneys put together. For the foregoing reasons, respondents respectfully request that GEM's motion be denied, and further, that respondents' cross motion to vacate the order be granted. All right, and one more thing about this specific memorandum. Both of the companies, the respondent, which would be Mullen Automotive, and the plaintiff, which would be GEM, they both provided memorandums, and they both provided their proposed orders and judgment. So I know there was quite a few investors that got excited when they were reading this, but again, this is basically something that each side has to provide to the judge. The judge would then read over each document and make their decision. They would have an opportunity to kind of edit a little bit of this, and this just kind of helps save the judge a little bit of time, or the arbitrator a little bit of time. So again, let's go ahead and read through this a little bit. So the respondents, Mullen Automotive Inc. and Mullen Technologies Inc., having moved this court pursuant to Rule 56 of the Federal Rules of Civil Procedure, the Convention on the Recognition and Enforcement of Foreign Arbitral Awards, and the Federal Arbitration Act 9, for an order denying petitioner's motion for summary judgment, granting respondents' cross motion for summary judgment to vacate an interim measures award issued on January 24th, 2024 by the arbitrator, presiding over an arbitration proceeding between respondents and petitioners, GEM and versus Mullen Technologies Inc. and Mullen Automotive Inc. This is a AAA case, and they give a case number, and then the third proposal is granting such other and further relief as the court deems just and proper, the respondents having duly come to be heard before this court, and upon this court's due consideration of respondents' cross motion dated May 6, 2024, the accompanying memorandum law, which I just got done reviewing with you guys all, in opposition to petitioner's motion for summary judgment and in support of respondents' cross motion for summary judgment. And with all that being said, here is the short synopsis. First order, that the petitioner's motion is denied. Second, further order that respondent's cross motion is granted, and it is further. Third order, that the interim measures award is vacated. So again, Mullen Automotive's attorneys, based on the memorandum, based on this proposed order, they are requesting that the interim measures be vacated. Again, they're stating that the arbitrator did not review Mullen's financial situation, therefore they could not have taken such drastic measures as requiring an interim relief. Not only that, but the fact that the final award was being provided means there was no need for this interim award. And that the arbitrator was acting outside of his power and not using the New York law and the AAA, some of the AAA law as well, in order to be able to kind of provide a fair judgment in terms of arbitration on this specific case. All right, I mentioned that I was going to talk about some more recent filings. Look here, this is from May 16th, 2024, and this is addressed to the judge proceeding over the lawsuit between Mullen Automotive and GEM. You can see that it is sent to the Honorable Catherine Polk Faila, and this is for the United States District Court, Southern District of New York. And looking at this green box, again, they're stating they are the attorneys for the respondents, who would be Mullen Technologies, Inc. and Mullen Automotive, Inc. In terms of the reference action, so they're highlighting the previous filing that was put in place by the petitioners. So again, the petitioners on May 13th, 2024, they noticed the judge about this supplemental authority, supporting their motion for summary judgment and seeking confirmation of a second interim measures order. Again, if you recall, the first measured order was that $7 million that was put into restricted cash into an escrow account by Mullen. Again, the second one, this second interim award, was for about $24 million, if I'm not mistaken, and that was also supposed to be going into an escrow account. Mullen Automotive, Mullen Technologies, they are arguing this case, and you'll see why if we continue reading. So it says, as noted in petitioner's submission on May 10th, 2024, arbitrator Mullen issued the final award in the arbitration. The issuance of that award renders petitioner's summary judgment motion moot. Again, if the final award has been provided and issued, there's no need for an interim award. Again, Mullen Automotive is going to discuss why that is the case. Again, it says, in addition to the interim measures award, again, they don't say how much that was, it says, but it does say that, however, on May 14th, 2024, Mullen Automotive, Inc. announced that it had received a commitment for $100 million in new financing and sold an additional $50 million in a note providing Mullen Automotive, Inc. with sufficient capital over the next 13 months. They provided the exhibit, which was that a PR announcement that came out, that the financing renders the interim measures unnecessary and unwarranted. Again, if Mullen Automotive, Mullen Technologies, if they have the financial capacity to be able to pay for whatever the final award may be, there's no need for an interim award. That is what Mullen was arguing in their memorandum, and that is what they are bringing to the judge's attention now. Going to that bottom box section. In addition, as explained in respondent's memorandum of law in opposition to petitioner's motion for summary judgment, respondents in any event may raise one of the grounds articulated in the convention for contesting an award issued in the arbitration in opposition to a motion to confirm. So that was a lot of legal jargon there, but basically my understanding is that Mullen Automotive has the right to go to this judge here in the Southern District of New York and argue the case that there's no need for this interim award anymore. So again, it's going to be interesting to see what the judge says about this information. You can see that it was submitted by one of Mullen Automotive's attorneys there, David K. Mambareke. Sorry if I mispronounced that, David. And another filing. This one came out on May 17th, 2024. And this is a joint update. So they're updating the judge of this specific situation between GEM and Mullen Automotive, Mullen Technologies. It says the parties jointly report that on Friday, May 10th, 2024, the arbitrator, Mark C. Morrill, issued a final award in the arbitration. The parties are conferring regarding a stipulated briefing schedule regarding the partial final award on liability and the final award, and expect to submit a stipulated briefing schedule for the court's consideration next week. So there is one more filing or one more document that I'd like to share with you all. But just wanted to kind of bring this up, that this is a joint submission where both parties are acknowledging and reporting to the judge that there has been a final award for this arbitration. And the last filing to share with you all, again, this is May 17th, 2024. This is from the Basil Law Firm. And let's go ahead and read this section in the green here. Those concerns have since been rendered moot with the issuance of the final award in the arbitration on May 10th, 2024. Again, there's no need for this interim award anymore because there's been a final award provided on that May 10th date. See related action. Because the arbitration has now concluded, plaintiffs respectfully request that the court issue an order lifting the stay on the action or of the action and setting a schedule for defendants to answer, move to dismiss, or otherwise respond to the complaint. So if you recall, the judge in terms of this lawsuit did stay this specific judgment or this order waiting for the arbitration to conclude. And guess what, folks? Arbitration is done. The final award has been issued. Mullen Automotive, Mullen Technologies has not paid for that final award yet. They will still have the opportunity to argue that. And now they're going to go ahead and pull this case forward, and they're requesting that the judge remove the stay. So it looks like we're going to have another round between Mullen Automotive and GEM. Can't wait to see what the judge decides and how the defendants are going to respond. All right, guys, thanks so much for watching. If you like this video, please consider giving it a like. If you haven't subscribed yet, please subscribe. Leave me a comment on this video. Let me know your thoughts. Try to give you my best understanding and debriefing of this GEM Mullen Automotive lawsuit update. Again, I want to point out that I am not a paid representative of Mullen Automotive. I've received no compensation at all from the company. I am just an investor and still currently invested long in the company. And I just want to provide you all with an update because I do believe in the company. I believe that they have a really good opportunity here with their offerings on their commercial section. I'm looking forward to some additional updates from the company. And with all that being said, I hope you all have a great rest of the evening or the day, and I'll see you on the next one. Well, hello and welcome to another video by Financial Earning. On today's video, we're going to break down one of Mullen's filings. This one is the S1 that was dropped this week. This actually correlates with an 8K that Mullen shared back in May. But without further ado, let's get right into it. So there's quite a bit of heavy reading involved in the 8K, in the registration filing, and then also in the S1. I went ahead and boxed some of the important statements that I'd like to show you all in green. But by all means, if you'd like to read through the full filings, go ahead and go to the sec.gov website, go to company filing, search for MULN. You can find all of Mullen's filings there in the Edgar search. But jumping right in, this is from the 8K. This is an entry into material definitive agreement, and this was actually shared back on May 21st, 2024. And this is a stock purchase agreement. So sometimes people call it a securities purchase agreement. This one's a stock purchase agreement. This one is actually just for the stocks themselves. There's no warrants attached to this specific definitive agreement, this material definitive agreement, which is part of this S1. So let's go ahead and continue. You can see here that has the effective date of the registration statement, where it's going to be shared below until earlier of. Here's the part that I thought was important. This is a 36-month commencement date. So there is a 3-year period for this filing, for this financing to be able to be used. That is the expiration for this specific agreement. And then going down a little bit further, you can see the aggregate purchase price. That is $150 million. And that is going to be provided to Mullen through the purchase of stock. So let's continue reading. You'll see a little bit more of how this transaction is going to occur over the next 3-year period. So it says, and also, just to point out, as consideration for the commitment to purchase the company's common stock, Under this purchase agreement, the company agreed to issue shares of common stock equal to 6 million divided by the lower of the, and they mentioned a word called VWAP, on the effective date of the initial registration statement or the closing price of the common stock on the effective date of the initial registration. So just wanted to kind of mention that VWAP is volume weighted average price. So you're going to see a little bit more about that as we continue throughout this video. And then jumping down, mentions after the commencement date, as defined below, on any business day selected by the company, and that's important. So the company is actually the one who decides when the stock purchase will be will be effective. So it says the company may, from time to time, as its sole discretion, direct the investor to purchase such number of shares of common stock that does not exceed 20% of the trading volume of the NASDAQ stock market on the applicable purchase date at a purchase price equal to 94% of the lower of, and then this is where the VWAP is mentioned again. It kind of gives a couple of different scenarios on what exactly that purchase price is going to be. It's either going to be 94% of the lowest daily VWAP of any trading day within that 15 days prior to the stock purchase request. And then, or the closing price of common stock on the applicable purchase date. So there's a couple different options, and again, this is going to be the lower of. So if they're reflecting back on the 15-day period and they have a lower price according to that VWAP, they're able to make that 94% cost purchase for those shares, or they could utilize the same day and they get a 94% purchase price of based off of the lowest price for that specific closing date. The company will control the timing and the amount of sales of its common stock to the investor. Again, just pointing out that the company does have the power to kind of manage when these shares will be getting distributed to the investor via the purchase. Continue a little bit further, and the investor has no right to require the company to sell any of the shares to it under this purchase agreement. So again, it's really up to the company, the way that this agreement is stated, exactly how much of this $150 million aggregate purchase price will be utilized. And there's some other stipulations, so let's just continue reading through this. Actual sales of shares of common stock to the investor under the purchase agreement will depend on a variety of factors to be determined by the company from time to time, including, among others, market conditions, trading price of its common stock, and determinations by the company as to available and appropriate sources of funding for the company and its operations. The investor may not assign or transfer its rights and obligations under the purchase agreement. So only the investor, and we'll talk about who that is in the upcoming slides, has the rights for this agreement. They cannot transfer this right to anyone else. They can't basically sublet or subsell this agreement to any other entities. And then another section I have boxed here, the company has agreed not to issue or sell to the investor under the purchase agreement any shares of its common stock, including the committed shares in excess of, and they list that 2.391 million shares, which is equal to 99.99% of shares of common stock outstanding prior to the execution of this purchase agreement. So again, that is the maximum that the company is allowed to offer this investor at this current time, and we'll go into how that can get changed on a future slide. All right, another section to bring up, the top there says the purchase agreement may be terminated by the company at any time at its sole discretion without any cost or penalty. So again, this is kind of like an open line of credit. The company can choose when to utilize the transactions, and they can choose when to cancel it. So if the company does receive some windfall of money, or they're able to start to generate that cash flow, they have the option to basically just cancel the rest of this SPA without any kind of penalty at all to the company. Reading a little bit further, the investor has agreed not to cause or engage in any manner whatsoever any direct or indirect short selling or hedging of the company's common stock. So again, this investor is pledging not to short sell, not to hedge the company's stock. So a lot of times when you hear about toxic lenders, that would involve a lender that actually shorts the company on the front end and then begins to rapidly sell off to reduce the price to gain additional money additional capital on the short sales themselves. So that is something that is not part of this agreement. The investor agreed not to engage in that type of activity. And then I went ahead and boxed 2 exhibits. We're going to go over those 2 exhibits in the next couple of slides. This is the common stock purchase agreement. So the full purchase agreement, this was just the 8K, and then also just a little bit about the registration rights agreement. All right, starting with the common stock purchase agreement. Again, this is dated May 21st, 2024. And you can see here, this is between Mullen Automotive and Isuso Holdings, LLC. So Isuso Holdings is the investor for this specific purchase agreement. Let's continue reading. The investor shall purchase from the company up to the lesser of $150 million, which is the total price commitment, and an aggregate gross purchase price, duly authorized, validity issued, fully paid non-accessible shares of common stock, or the other option, the lesser of either the 150 million or the exchange cap to the extent applicable under section 2.3. So basically they cannot violate the overall market cap, the exchange cap of the company when they're making these purchases. So you can't just do all this at one time. As you know, Mullen's market cap is a little under $40 million right now. So this company cannot just purchase $150 million worth of shares because there's just not that many shares available for the market cap at the current time. Going into that VWAP purchases, again, the closing price or the floor plan for this specific SPA is equal to or greater than 10 cents, and the company shall have the right but not obligations to direct the investor by its delivery to the investor of a VWAP purchase notice to purchase the VWAP purchase sale amount. So this is a way that the company can kind of protect the overall share price. They can direct this investor to make these purchases to continue to drive back up the purchase price. And create that volume and everything else like that. As we know, that they're going to talk a little bit about what this money is going to be used for in the upcoming slides. So we'll go ahead and cover that as well. And that is here actually, sorry, on the investment purpose, section 3.4. It says the investor is acquiring the securities for its own account for investment purposes only, and not with a view towards or for resale in connections with the public sale or distribution thereof, except pursuant to sales registered under or exempt from the registration requirements of the Security Act. So I'll stop right there. Basically, this is letting you know that this investor is looking for a long investment. They're not looking for a rapid sale of these shares. That is the investment purpose. They are looking to be a long investor in the company. It's considered an equity investment. Let's continue on. Provided, however, that by making the representations herein, the investor does not agree or make any representation or warranty to hold any of the securities for a minimum or other specific term, and reserves the right to dispose of securities in any time in accordance with or pursuant to registration statement filed pursuant to the registration rights agreement. We'll go over that a little bit later. Or in applicable exemptions under the Securities Act, the investor does not presently have any agreement or understanding directly or indirectly with any person to sell or distribute any of the securities. So again, the company is not looking to sell these securities. They're looking to purchase them and hold them. However, this statement does allow them, for certain reasons, to be able to sell and dispose of the shares. So it's really up to the investor's discretion, but their intent is to hold long and be an equity investment. And then section 3.11, no prior short sales. At no time prior to the date of this agreement has any of the investor, its agents, representatives, or affiliates engaged in or effected in any manner whatsoever, directly or indirectly, any short sales of the common stock, hedging transactions, which establishes a net short position with respect to the common stock. So Isuso Holdings they're declaring here that they've never short sold their Mullen shares that they've owned from time to time, and they are not planning. In fact, they are not allowed. They are short sale restricted. They are not allowed to sell these shorts. And you can tell by the investment that it's an equity investment. So again, I have to ask all the viewers here, and I have to ask myself from time to time, just looking at it from a bullish speculation here, why would an investor invest $150 million into a company with a market cap under $40 million? If you look at that, it would take about 4x to be able to actually meet the market cap amount. So when I look at this, I tend to think that the company has provided this investor with a forecast, with some forward-looking information that makes the investor feel that this $150 million is going to be used appropriately, and it should correlate with what a market cap, a projected market cap should be. And again, that's my bullish perspective, my bullish speculation. Just wanted to share that with you all as we continue on through these documents. All right, getting into the section about capitalization, reading over the box section in green, except as set forth in the commission documents, there are no securities or instruments containing anti-dilution or similar provisions that will be triggered by this agreement. So let's pause there. In some previous security purchase agreements, there was some anti-dilutive clauses that would allow the investor to be able to get additional shares in the event that the price action and the use of the securities caused a dilutive effect. So again, that is not part of this agreement. And again, as I mentioned at the beginning, this is a stock purchase agreement. There are no warrants tied to this $150 million. Plus the $6 million that they will be receiving as part of the agreement to lend and invest this money. Actually, it's not lend, it's an invest, because they're purchasing these shares. So continuing on, the registration rights agreement or any other transaction documents or the consummation of the transactions described herein or therein. So again, that was the last of that section there, but there is no anti-dilution provisions in this filing. Going into the dilutive effect, the company is aware and acknowledges that the issuance of securities could cause dilution to existing stockholders and could significantly increase the outstanding number of shares of common stock. That's kind of a no-brainer, but you still have to put it in here. If you are offering common stocks for purchase from an investor, it's going to increase the outstanding share count, the common share float, if you will. So there would be a form of dilutive effect. It isn't guaranteed to be a dilutive effect on price. If there is justification for an uptick in volume and the price goes up, there is an opportunity here for the market cap to grow, although there are shares being injected. Will that slow down the growth opportunities? In my opinion, yes, it will. However, if there is significant news, if there is something that really puts a significant value on the investment, that should help grow. And then again, the company has the opportunity to say how much of these securities will be sold at any given time. So there's opportunity once the investor has reached their saturation at either 9.9 or 19.99%. To have some significant news to still increase that share price. So let's continue reading. Going into the reservation of common stock. I'm sorry, let's finish out the dilutive effect. The company further acknowledges that its obligation to issue the commitment shares and to issue the shares pursuant to the terms of a VWAP purchase in accordance with the agreement is in each case unconditional regardless of the dilutive effect that such issuance may have on the ownership interests of other stockholders of the company. So, of course, if you are offering a purchase of a share at a basically 6% discount, you're getting it at 94% of whatever that value would be, and it's the lowest value over the 15-day period. You are going to be getting these stock at a discount. And again, I want you to think about this. If you were lending someone money, there's typically an interest rate attached to that. I don't see anywhere in these provisions where there's an interest rate. So this is the opportunity for the investor to basically kind of hedge their bets, if you will, in terms of getting some form of return on investment. They are guaranteed to be able to purchase these shares at a 6% discount at the lowest price. So just want to kind of put that out there. And again, the company is controlling when that purchase happens. So they could do it every 15 days. There could be a disbursement to where it allows the share price to grow. I don't really know how that's going to be managed by the company, but just wanted to bring that up to you all and make you aware. All right, getting into the reservation of common stock. So the shares pursuant to this agreement, as of the date of this agreement, the company has reserved, and as of the commencement date, shall have continued to reserve out of its authorized and unissued common stock 2,391,073 shares of common stock solely for the purpose of effecting VWAP purchases and issuing the commitment shares. The number of shares of common stock so reserved for the purpose of effecting the VWAP purchases under this agreement may be increased from time to time by the company from and after the commencement date. and such number of reserved shares may be reduced from and after the commencement date only by the number of shares actually issued, sold, and delivered to the investor pursuant of any VWAP purchase effect from and after the commencement date purchase of this agreement. So basically, for the current state of this agreement, they have only 2,391,073 shares kind of reserved, set to the side that this specific company is allowed to purchase. And that has a lot to do with a certain percentage of ownership of the outstanding shares. So as that outstanding share count changes, the percent of ownership, of course, will change with it. And there will be an opportunity for a shareholder vote to allow the company to own more than 9.9%, or the lender to own more than 9.9%. Let's continue reading through a little bit further. Under the no dilutive issuances during reference period. Neither the company nor any subsidiary shall issue, sell, or grant any right option or warrant to the purchase, or issue, sell, or grant any right to the reprice, or otherwise dispose of for cash, or enter into any agreement, plan, or arrangement contemplating any of the foregoing, or seek to utilize any existing agreement, plan, or arrangement to effect any of the foregoing, or announce any offer, issuance, sale, or grant of any option or warrant to purchase or other disposition for cash, or any agreement, plan, or arrangement therefore at any time with respect to each VWAP purchase under this agreement for which the company has delivered to the investor a VWAP purchase notice, the period beginning on the third trading day, immediately preceding the applicable VWAP purchase date of such VWAP purchase, and ending on the third trading day. So let's unpack that a little bit. So what that's letting you know is that there is no, based off of this clause, they are not going to convert these common shares to any form of warrant. They're not going to be converting it over to any form of cash or anything else like that. They have to be used as described in this security purchase agreement.
All right, and as I've already mentioned before, Isusa did already put out a statement in one of the other filings that they have never short sold the Mullen stock before. And for this specific stock purchase agreement, there is section 5.9, which is the selling restriction. So let's go ahead and read the section boxed in green. Except as expressly set forth below, the investor covenants that from and after the closing date through and including the trading day next following the expiration or termination of this agreement, neither the investor nor any of its affiliates nor any entity managed or controlled by the investor, collectively the restricted persons, shall directly or indirectly engage in any short sales involving the company's securities or grant any option to purchase or acquire any right to dispose of or otherwise dispose for value of any shares of common stock or any securities convertible into an exercisable or exchangeable for any shares of common stock, or enter into any swap, hedge, or other similar agreement that transfers in whole or in part the economic risks of ownership of the common stock. Notwithstanding the foregoing, it is expressly understood and agreed that nothing contained herein shall, without implication that the contrary would otherwise be true, prohibit any restricted person during the restricted period from selling long the securities or selling a number of shares of common stock equal to the number of shares that such restricted person is or may be obligated to purchase under a pending VWAP purchase notice, but has not yet taken possession of, so long as such restricted person delivers the shares purchased pursuant to such a VWAP purchase notice to the purchaser therefore or thereof, or the applicable broker-dealer upon such restricted persons receipt of such shares of common stock from the company pursuant to this agreement. So, in other words, Isusa has a section here in this stock purchase agreement that says that they will not short sell any of these securities or any of these common shares that they do own or that they will plan to own. So that is, again, that's another good thing that just shows that this is really for an investment purpose, not for a type of spiral toxic dilution type of situation, which we have seen Mullen get into before from some other lenders. And then just jumping down to section 6.2, just talks about some of the conditions precedent to commencement. They're all listed there, I through 16.
So if you'd like to read through all of those, you can. And then section 6.3 also talks about conditions precedent to purchases by the investor. So I thought section 5.9 was very important. A lot of people were uncertain about Isusa in general as a lender, but after reading this specific section, this clause of the stock purchase agreement, and then knowing that they've already put out a statement that they have never short sell Mullen, in my opinion, that, and it's not just my opinion, it's what's written, that gives me good confidence that Isusa actually is an investor for Mullen Automotive and that they are planning on holding long and that this is more of an equity type of investment. All right, jumping into a different filing, this is the registration rights agreement. I didn't really grab a whole lot of sections out of this. Some of it was basically just repeating, but this is a supplemental exhibit that was part of the 8K. This goes hand in hand with the stock purchase agreement. But let's go ahead and read the section boxed in green. This should look familiar. A lot of these specific cases or a lot of the details in this registration rights agreement you can also find in sections of the stock purchase agreement as well as the 8K. But it says the company and the investor have entered into that certain common stock purchase agreement dated as of the date hereof, and we know that this is the May 21st, 2024, pursuant to which the company may issue to the investor from time to time up to 19.99% of the company's outstanding shares of common stock as of the date of this agreement per value of 0.001 per share, unless stockholder approval is obtained to issue more than 19.99%. So again, we know if any specific investor, if any entity owns more than 9.99%, that will trigger a flip-in event for Mullen Automotive and any of the shareholders that have that right. So many shareholders that were holding earlier in May, they did receive a shareholder right. It was a form of a dividend, and that dividend will become triggered if any single investor, single entity owns more than 9.99%. And you can see based off of this registration rights agreement that it is setting up Isusa to be able to hold more than 9.99%, but we'll have to see exactly how that unfolds. And then going down into the agreement, I went ahead and boxed in section as part of the registration, section A. It says mandatory registration. The company shall prepare and as soon as practicable, but in no event later than the filing deadline, file with the Commission an initial registration statement on Form S1. And as you all know, the S1 was filed just this past week. So just wanted to kind of make you all aware of that. Many of you have seen this. There's been some requests to kind of go over the S1. We will touch base on the S1, but just kind of wanted to set it up. And let's go ahead and continue reading. So, or equivalent if Form S1 is unavailable to the company, covering the resale by the investor of all of the commitment shares and the maximum number of additional registrable securities as shall be permitted to be included thereon in accordance with applicable Commission rules, regulations, and interpretations, so as to permit the resale of such registrable securities by the investor under Rule 415 under the Securities Act at then prevailing market prices. So just wanted to kind of go over that section. This is, again, the mandatory registration. So this is kind of tying in that S1 form, which we will be going over with shortly. All right, as mentioned, here is that S1. This is what was just put out on June 24th, 2024, just this past week. This is the date of record for this S1. So let's go ahead and read the section boxed in green. You can see that this prospectus is related to a potential offer and sale from time to time of up to 75 million shares of our common stock for a value of 0.001 per share by Isusa Holdings. So Isusa Holdings is the selling stockholder. For more information about the selling stockholder, the shares of common stock to which this prospectus relates will or may be issued by us to the selling stockholder pursuant to a common stock purchase agreement dated May 21st, 2024. So there you go. That ties this S1 directly to that 8K, the registration of rights, that stock purchase agreement. All of that is all tied in together. This was the last section pending the shareholder vote, which will be happening on July 9th. Let's go ahead and continue reading through.
It says, under the applicable rules of the NASDAQ stock market, in no event may we issue to the selling stockholder shares of our common stock representing more than 19.99% of the total number of shares of common stock outstanding immediately prior to the execution of the purchase agreement, unless we obtain the approval of issuance of such shares by our stockholders in accordance with the applicable stock exchange rules. So again, there you have it. This is what one of those proposals are on the July 9th shareholder vote. So continue on. Such shares of common stock consist of shares that we may, in our sole discretion, elect to sell to the selling stockholder from time to time after the date of this prospectus pursuant to the purchase agreement, shares of common stock that we have agreed to issue to the selling stockholder as consideration for its commitment to purchase shares of our common stock. And just to tie that in, just to kind of remind you all, there was a 6 million share commitment that Mullen was offering to Isusa for this specific stock purchase agreement. So let's go ahead and get back into it. Half of which will be issued upon the effective date of the registration statement, of which this prospectus forms a part, and the remaining half to be issued upon stockholder approval of the transactions contemplated by the purchase agreement. Each share of common stock offered under this prospectus has associated with it one right to purchase from us 1/10,000th of a share of our Series A1 Junior Participating Preferred Stock per value 0.001 per share under our rights agreement. Please see the section entitled Descriptions of Securities, Rights Agreement, Series A1 Junior Participating Preferred Stock in this prospectus for a more detailed discussion. So some of you may remember that there was Series A1 Junior Participating Preferred Stock mentioned earlier on, and that was around the time that the shareholder rights agreement was formed that had to do with that dividend. So basically that is allowing Isusa to now be able to take advantage of that same Series A1 Junior Participating Preferred Stock. And again, the nice thing with that is if they choose to purchase those shares, that is going to be able to give Mullen additional money for their operations. So going down to this second box section, says the selling stockholder may sell or otherwise dispose of the shares of common stock included in this prospectus in a number of different ways and at varying prices. Although the selling stockholder is obligated to purchase shares of our common stock under the terms and subject to the conditions and limitations of the purchase agreement to the extent we choose to sell such shares of our common stock to it. The timing and the amount of any sales of common stock by the selling stockholder are within the sole discretion of the selling stockholder. There can be no assurances that we will choose to sell any shares of our common stock to the selling stockholder, or that the selling stockholder will sell any or all of the shares of our common stock, if any, purchased under the purchase agreement pursuant to this prospectus. So again, one other thing I did want to mention to you all is Mullen Automotive is actually responsible for when these shares will be delivered to the selling stockholder or the selling lender here. So it's not Isusa that gets to say, hey, I want 10 million shares right now. It is up to Mullen Automotive, basically based off that VWAP. If you recall, there is a 15-day at the lowest price, a 96% of that price, according to that VWAP, that Mullen is able to sell Isusa these shares. So again, it is really up to Mullen Automotive on the timing of the transaction of these shares. So as I mentioned, this is kind of like a line of credit. If Mullen chooses to utilize it, they will be utilizing their shares, their stock, to be able to gain capital for their operations and other items. And then Isusa will own those shares, and it'll be up to Isusa's discretion if they choose to sell those long or if they want to hold their investment. So going down to the last section I have boxed here, I think it's important that everyone understands some of the information in this S1. It says investing in our securities involves a high degree of risk. Before making any investment in our securities, you should read and carefully consider the risks described in this prospectus under the heading Risk Factors, beginning on page 5 of this prospectus in our filings with the Securities and Exchange Commission. So we're going to go over some of those risks on the next slide. but just wanted to go ahead and kind of go over the basics of this S1 and just remind you all that it's going to be Mullen Automotive that decides when these transactions do occur, and they have a 3-year period to be able to exercise these shares and these purchases. All right, before we get into the risk factors, let's go ahead and go over a little bit more of the details here in this S1. We're talking about the committed equity financing. So kind of summarizing what we already read a little bit on that 8K, a little bit of that registration rights and the stock purchase agreement. But here we go. On May 21st, 2024, the company entered into a common stock purchase agreement with Isusa Holdings, the investor or selling stockholder. So those are the two names if you hear throughout this prospectus, or if you did hear this on the stock purchase agreement, they are referring to Isusa Holdings. Pursuant to which the investor has agreed to purchase from the company at the company's direction from time to time in its sole discretion from and after the effective date of the registration statement of which this prospectus forms a part and until the earlier of the 36-month anniversary of the commencement date or the termination of the purchase agreement in accordance with the terms thereof. So again, Mullen can choose at any point in time to cancel the remaining line of credit, if you will, from this stock purchase agreement. So again, Mullen has quite a bit of leverage in terms of how much of this financing they're going to need and when they want to use this. Again, what's nice about this stock purchase agreement is there's no interest bearing on this stock purchase agreement. So it's a little bit different than just getting, a standard line of credit and you have to pay the interest and pay it back. Mullen is choosing to utilize their shares to provide those to Isusa as an investment for Isusa, and they're able to get that cash. So let's continue reading throughout the rest of this. It says having a total maximum aggregate purchase of $150 million upon the terms and subject to the conditions and limitations set forth therein. And then we're going to go down to the next box section. It says, as consideration for its commitment to purchase the company's common stock under the purchase agreement, the company agreed to issue shares of common stock in an amount equal to $6 million. So I mentioned 6 million shares earlier. My apologies, we're talking $6 million divided by the lower of the volume weighted average price. That's that VWAP we've been talking about of the common stock on the effective date of the registration statement to which this prospectus relates. And so it's going to be the lower of, remember that, the closing price of the common stock on the effective date of such registration statement to the investor. Half of the committed shares will be issued upon the effective date of the registration statement to which this prospectus relates, and the remaining amount will be delivered upon stockholder approval of the issuance of shares in excess of the exchange cap, provided that all the committed shares will be issued by the date that is 6 months from the date of the purchase agreement. So again, the Mullen has already committed the $3 million to Isusa for this stock purchase agreement. So they're able to, at any point in time, exercise the right for those shares. And then the remainder of that will have to be voted on by the shareholders, as we will have to vote to increase the current market cap and approve these additional shares. After the commencement date, on any business day selected by the company where the closing sale price of the common stock is equal to or greater than 10 cents, the company may from time to time at its sole discretion direct the investor to purchase such number of shares of common stock that does not exceed 20% of the trading volume on the NASDAQ stock market on the applicable purchase date at a purchase price per share equal to 94% of the lower of the lowest daily VWAP of any trading day during the 15 trading days prior to and including the purchase date. So that's the first statement, or that's the first type of purchase that Isusa is able to do. And again, they have to be directed by Mullen Automotive. They're the ones that get to initiate this transaction. And then the next lower of is going to be the closing price of the common stock on the applicable purchase date. So if the actual day that Mullen wants Isusa to purchase these shares happens to be lower than the previous 15 days, utilizing that VWAP, then again, Isusa would be able to purchase at the current day's closing price, and that the company would control the timing and the amount of any sales of its common stock to the investor, and the investor has no right to require the company to sell any shares to it under this purchase agreement. So again, Mullen Automotive gets to choose when these shares are being exercised. Actual sales of shares of common stock to the investor under the purchase agreement will depend on a variety of factors to be determined by the company from time to time, including market conditions, trading price of its common stock, and determinations by the company as to available and appropriate sources of funding for the company and its operations. The investor may not assign or transfer its rights and obligations under the purchase agreement. So Isusa cannot sublet or sublease, if you will, this stock purchase agreement. They have to continue ownership throughout this agreement. The purchase agreement prohibits the company from directing the investor to purchase any shares of common stock if those shares, when aggregated with all other shares of the common stock then beneficially owned by the investor's affiliates, as calculated by the Security Exchange Act 1934 as amended, would result in the investor and its affiliates beneficially owning more than 9.99% of the total outstanding shares of the company's common stock. So Mullen Automotive can't force Isusa to take ownership of more than 9.99%. As we know, there is an additional fee that any single investor that wants to own more than 9.99% must pay, and that is that amount or that fee is something that is decided upon by the board of directors. So let's continue through the last little section here. The company has agreed not to issue or sell to the investor under the purchase agreement any shares of its common stock, including the committed shares in excess of 2,391,073 shares, which is equal to 19.99% of the shares of common stock outstanding immediately prior to the execution of this purchase agreement, unless the company obtains stockholder approval to issue shares in excess of the exchange cap in accordance with the applicable rules of the NASDAQ. So again, that's why this July 9th vote is so important. If you would like Mullen Automotive to be able to continue in operations, this stock purchase agreement is very critical to that. It's going to provide them the additional funding for the rest of this year, as was already stated in a PR. And you would have also saw that there was some discussions on some mergers and acquisitions. So we'll have to see exactly what unfolds with that. And then a little bit about some over-the-air technology. So besides all that, there's also just the day-to-day operations, the cost of operations that Mullen Automotive is still needing help with. They have not sold enough vehicles to be able to have profit to be able to pay for those costs of operations. So this is an opportunity for Mullen to be able to bridge that gap again for the rest of this year. We know they have plans to beginning in January for some of this battery production. So I think this was definitely needed for Mullen Automotive for the time being. So we'll have to see if this gets approved by the shareholders. This full amount will be able to be utilized by the company. All right, let's talk a little bit about the offering. This is the S1 offering itself. Again, this is the 75 million shares. This is equivalent to the 150 million, just basing it off of $2 a share. This is why there is a total of 75 million shares as part of this initial prospectus. And then they do give us an update on the common share count or the common stock. You can see that it's currently at 16,031,470 shares. So it's a slight increase. It was sitting around 15,500,000 or so shares somewhere in the beginning of June. So now we're sitting around 16 million. So we do know that there were some litigations that were closed up between, I believe it was Silverback, as well as I think Alt also received some Series E stock. So there were some various methods that could have contributed to the share count increase, as well as just the employee incentive program that was approved back in 2022. So we're not quite sure exactly what, but this is the current share count as of this S1 date, which is June 21st, 2024. And as I stated, we will go over the risk factors. But let's read through these right now. So risk factors. The sale or issuance of our common stock to the investor may cause dilution, and the sale of the shares of common stock acquired by the investor or the perception that such sales may occur could cause the price of our common stock to fall. So again, anytime that someone is purchasing new shares and they're getting added to the common share count, it is going to be a form of dilution. Depending on what happens after those shares are acquired will really tell you if the price will go down or will not. So if the investor, Isusa Holdings, decides to hold long their shares, there'll be an increase on common share count. However, there will be no additional shares available for borrowing. So it's really going to depend on what Isusa decides to do once they acquire these shares. Again, they can only hold so many shares at a time. So it's going to be interesting to see what they do. But anyway, let's continue reading through the rest of these risks. So the investor will pay less than the prevailing market price for our common stock, which could cause the price of our common stock to decline. So again, this has to do with the fact that they are getting these shares at a 94% of the current price, or actually of the lowest price of that 15-day VWAP, or if it happens to be the lowest price of the day when the transaction is made, again, it could cause the share price to go down. So if you are familiar with other companies, anytime that there's an opportunity where there's a large volume spike, if there's some really good news that comes out that creates a bullish sentiment and some good amount of buying pressure, a lot of companies utilize that opportunity to be able to sell shares into the float at that point in time. So just something to remember that will stop, if you will, a short squeeze per se. But again, Mullen Automotive has full rights to the activities of exactly when these shares will be sold. Reading on a little bit more into the risks, we may require additional financing to sustain our operations, without which we may not be able to continue operations, and the terms of subsequent financings may adversely impact our stockholders. Our management will have broad discretion over the use of its net proceeds from our sales of shares of common stock to the investor. You may not agree with how we use the proceeds, and the proceeds may not be invested successfully. So again, that is a risk. Exactly what Mullen decides to do with these, with this money, this financing, is it going to be successful or not? It's going to be dependent on how the market perceives their decision. So, if they do a merger acquisition and it is a successful one, that's great. If it's not, there's a potential that it could impact, the company's continuation. And then just recall that this is enough financing for the remainder of the year. Just from a cost of operations standpoint, if they choose to spend, some or the majority of this on some form of merger acquisition, again, depending on the type of revenue that is generated from that, there may be some additional needs of financing. So we do know that there is another $100 million already assigned, already filed for Mullen. So just recall they have that additional money as well. Continuing through some more of these risks. It is not possible to predict the actual number of shares we will sell under the purchase agreement to the investor, or the actual gross proceeds resulting from those sales. So again, Mullen can decide to cancel this stock purchase agreement at any point in time. The number of shares that may be issued to the investor under the terms of the purchase agreement may be limited due to the requirements of the NASDAQ capital market. So again, if the shareholders do not vote for the increase of the market cap and allow these additional shares to be sold, then that could stop this purchase agreement from being fully effective here. Investors who buy shares at different times will likely pay different prices. Our commitment to issue shares of common stock and commitment shares pursuant to the terms of the purchase agreement could encourage short sales by third parties, which could contribute to the future decline of our stock price. So again, sometimes when these types of SPAs are announced, some types of short sellers do try to jump in. They try to front run the dilution.
But again, Mullen Automotive has an opportunity to be kind of strategic of how much is going to be let into the market at various times. And then again, Isusa has the option to hold long. So that is some really good ways that they can kind of leverage and kind of hedge a little bit in terms of how some of these short sellers may try to utilize this to try to get financial gains. And then let's read the last section here. So I'm not going to go over the use of proceeds again, but I will read this, the last paragraph down below. It says, we expect to use the net proceeds. So I'm not going to go over all of the use of proceeds, just this last paragraph here. We expect to use the net proceeds that we receive from sales of our common stock to the selling stockholder, if any, under the purchase agreement for general working capital and general corporate purposes. As of the date of this prospectus, we cannot specify with certainty all of the particular uses and the respective amounts we may allocate for those uses. For any net proceeds we receive, accordingly, we will retain broad discretion over the use of these proceeds. There can be no assurance that we will sell any shares under or fully utilize the purchase agreement as a source of financing. So again, just because this S1's filed does not mean that these shares will be coming into the market. However, if you understand how much cash Mullen has on hand, it is in their best interest to be able to utilize some of this stock purchase agreement very soon. And again, I'm sure Isusa would like to have a long stake in this company, depending on the type of news that Mullen Automotive has provided them. Again, I think I mentioned this earlier on. You have to recall the market cap now is less than 40 million. Just this one stock purchase agreement alone is $150 million worth. So again, you have to ask yourself, why would Isusa put 4 times the market cap into financing for purchasing shares of Mullen Automotive? We don't know. It's not public knowledge as of yet. So I think it's going to be very interesting for the rest of us shareholders to find out what has urged Isusa to decide to put such a large amount into Mullen Automotive in the form of stock purchase. All right, last slide here before the outro. Just want to remind you all, this is part of the S1. Talks about the selling stockholder. We've already mentioned it. It's mentioned again, though, that as used in this prospectus, the term selling stockholder and investor means Isusa Holdings LLC. And then if you look at the very bottom of this slide here, you can see the number of shares of common stock owned prior to this S1 offering of Isusa was 8,753,061. And that was a combination of shares through the promissory notes as well as some warrants. And you have to remember that they cannot hold more than 10% or 9.99% of the common share count at any point in time without the board's approval. So therefore, based off of that 16 million, they can't have more than 1.6 million shares of common stock. So just want to point that out. And then you can see the maximum number of shares to be offered. This is the 75 million pursuant this S1. And then you can see the total number of shares of common stock owned after the offering. And you can see here that is just a straight addition of the 2. And again, this shows that there is no additional warrants as part of this S1 agreement. This is just a straight up stock purchase agreement between Isusa and Mullen Automotive. All right, folks, thanks so much for watching. If you like this video, please consider giving it a like. Subscribe to the channel if you haven't already. Let me know your thoughts on this video. Leave me a comment on this information, or leave me a comment on some future content you'd like to see me cover. And with that said, I just want to point out that I am just an investor in Mullen Automotive. I am not paid in any way. I take no compensation from the company. I'm just a mere investor who has a bullish outlook on the company and its operations. And with that, all that said, I hope you guys all have a great rest of the day, and I'll see you on the next one.